Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honourable Senators, leave of absence has been granted to Senator Jayanti Lakshmi-Dayal, who is ill, and Senator Evans Welch. Honourable Senators, I am awaiting the instrument of appointment, so we will revert to this item on the order paper later in the proceedings.
Papers.
Leader of Government Business.
Madam President, I have the honor to lay on the table the following paper as listed on the supplemental order paper in the name of the Minister of Works and Transport. The Motor Vehicle and Road Traffic Extension of Period for Payment of 50% of Fixed Penalty Number 2 Order 2022.
Senator Vieira.
Madam President, I have the honor to lay on the table the following paper as listed on the supplemental order paper in my name. The delegation report on the parliamentary gathering on the occasion of the 9th Summit of the Americas, held in Los Angeles, California, United States of America, from June 6 to 7th, 2022.
Urgent questions.
Leader of Government Business.
Madam President, I wish to indicate that I have conferred with and received the agreement of Senator Mark to defer this item till later in today's proceedings.
So this item is deferred until later in the proceedings.
Questions on notice. Question for oral answer.
Leader of Government Business.
Thank you, Madam President. I wish to indicate that there are 3 questions for oral response on today's order paper, and the government is prepared to answer all 3.
Senator Mark.
Thank you, Madam President. Madam President, question number 121 to the Minister of Energy and Energy Industries.
Minister of Trade and Industry.
Thank you, Madam President. No work has been resumed on the numbers 36 Sea Line pipeline associated with the unfortunate and tragic deaths of the 4 LMCS divers. Thank you.
Senator Mark.
Can I ask through you, Madam President, when did Parliament take the decision not to pursue any further works on this particular pipeline? Can the Minister share the date of that discontinuation, Madam President?
Senator Mark, that question does not arise.
Thank you, Madam President. May I go on?
Yes, next question.
Question number 122 to the Minister of Public Utilities.
Leader of Government Business.
Madam President, in response to this question, I wish to indicate to the Senate that the residents of Castara, Tobago are generally in receipt of a regular and consistent 24-hour a day, 6 days a week scheduled supply of pipe-borne water. Unfortunately, on March 2nd, 2022, the residents of Castara began experiencing an intermittent supply of water, which was triggered by a faulty TN-Tech transformer, which caused the pump at WASA's Parrot number 1 booster station to malfunction. Following the repair of the transformer and pump, the 24-hour-a-day, 6-day-a-week supply of water has been restored to this area as of March 7, 2022. Thank you, Madam President.
Senator Mark.
Yeah, Madam President, can the Minister indicate whether TN-Tech provided the reasons for this particular fault or development that took place that resulted in this challenge at the material time?
Minister.
Madam President, the question was posed in accordance with the normal business of the Senate. The question was shared with the relevant officials at TN-Tech. They provided the response to us and the rationale to us for the interruption, and that was presented in the answer.
Senator Mark.
Madam President, may I go on? Question number 123 to the Minister of Trade and Industry.
Minister of Trade and Industry.
Thank you very much, Madam President. The Ministry of Trade and Industry is aware of the negative report made by a former guest of the Magdalena Grand Beach and Golf Resort, which was circulated on social media. Evolving Technologies Enterprise Development Company Limited, ETEC, has taken the necessary steps to address it and ensure that the policies, the standards and procedures of the Magdalena Grand Beach and Golf Resort meet the highest levels of certification. The guest who made the report was a member of a group being accommodated at the hotel, which consisted of 50 persons, during the weekend of 25th to 27th February 2022. The fallen ceiling incident on 26 February 2022 at approximately 10:30 p.m. caused no harm or injury to anyone. In addition to this incident, the video also included an unsubstantiated claim of bad food. The affected guest was compensated with a one-night refund and a formal apology was issued. Infrastructure works. As it relates to the partially fallen ceiling, the Magdalena's Engineering Department responded that very evening, 26th of February 2022. It was determined that the damage was largely due to a passing weather system that comprised strong winds, which was compounded by several storms within the past year that tested the Magdalena's infrastructure. Following the incident, the chief engineer and his team inspected both wings and all public areas of the Magdalena, and all infrastructure was found to be intact. In addition to the Magdalena's engineering department's continued daily maintenance and upkeep of the resort, there is ongoing general maintenance that is required for the aging property. In its 2021 to 2022 program of works, ETEC is engaging a structural engineering consultancy to support the planned upgrade works of the north and south wings of the resort. The approved PSIP funds for the consultancy and structural upgrade works are $503,250 and $759,000 respectively. Both the consultancy and the upgrade work are expected to be completed by September 2022. With regard to food and beverage standards, Magdalena maintains stringent food and beverage protocols and as such is compliant with all necessary international standards. In light of the food incident, stricter management protocols have been implemented that include a label system that states the date that items are placed on the buffet, proper disposal of unused buffet items, and daily inspection of all such items. These protocols are being managed by the executive chef and the food and beverage manager and supervisors. Overall customer experience. The Magdalena continues to implement measures to ensure that a satisfactory customer experience is maintained and that negative incidents are avoided or dealt with efficiently and effectively. To help improve the current service standards, encourage repeat customers and build a reputation for quality and service, all guests receive satisfaction surveys after checking out to assess their quality of stay. And based on the feedback received from the surveys, the hotel management takes proactive measures to improve the establishment's standards. Earlier this month, the Cabinet approved funding for works at the Magdalena Brand Beach and Golf Resort, which are expected to enhance the guest experience. And these works include the repainting of some rooms and upgrades to the flooring, the tiling, the bathroom fixtures, and the furniture, among other areas. This enhancement of the facilities is also expected to impact positively on the short-term commercial viability of the hotel and its attractiveness for potential investment and divestment. Thank you.
Senator Mark.
Yes, Madam President, may I ask through you, if the Minister can share, what was the quantum of monies approved by the Cabinet to fund repairs and to bring this very important hotel and resort up to international standards?
Minister.
Thank you. The initial amount, as I said before, within this year's PSIP is $503,250 and $759,000. However, in addition to that, I can tell you that that we have just approved another $7,288,715 in $715, and to do essential repairs and continuation of works on the Magdalena as well.
Senator Mark.
May I ask the Minister just to guide me on this one? The monies that the Minister outlined, are those monies going towards repairing the various infrastructural deficiencies that were highlighted by the visitor and based on what you have outlined? Or is there additional funding required to address those issues? Can you clarify for us?
As I said before in the initial response, that particular infrastructural issue which was highlighted by the social media has already been fixed, and all checks have revealed that there are no such large infrastructural issues regarding the ceiling. What I've highlighted now, in addition to the PSIP projects, are some room repairs and upgrades, and that is in addition to the funding that we've also spent on the golf course rehabilitation, elevator replacement, and so on. So work is continually going on, and there is sufficient enough spend on the hotel to ensure that it remains to standard.
Honourable Minister, what steps have been taken by ETEC to use marketing strategies in order to address whatever fallout the hotel and Tobago and Trinidad and Tobago would have experienced as a result of the negative publicity circulated on social media as a result of the statements attributed to have been made by the U.S. visitor? Can you share with us what marketing,
Minister.
PR?
Yeah, Minister.
A public statement would have been issued there and then, in addition to which we would have responded to the social media as well. But notwithstanding, marketing initiatives remain a substantive matter in any hotel, and it remains so for the Magdalena to ensure that it is as viable as possible.
Madam President, the Minister just did mention the short-term commercial viability of the hotel in her response a short while ago. I'd just like to ask the Honourable Minister whether there is intention on the part of the government to put the Magdalena Grand Beach and Golf Resort Hotel up for sale or partnership arrangements with any local or foreign interest or partnership.
Minister.
Thank you. Well, I'm sure that you would have seen in the national press that there, in April, ETEC would have issued in the international marketplace, that's included locally, a request for expressions of interest for an international operator or investor or purchaser for the Magdalena Grand Hotel. And submissions to date, it has been the response has been quite good. There have been submissions, and at this point, parties have been invited to visit the hotel, and the next step would be the evaluation of the proposals.
That's it. Yeah, finish.
Okay, thank you.
Announcements by the President.
Honourable Senators, I'm now reverting to the earlier item on the order paper, and I am in receipt of the instrument as follows. By Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Ms. Marsha Walker. Whereas Senator Jayanti Lakshmi-Dayal is incapable of performing her duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Marsha Walker, to be a member of the Senate temporarily, with effect from the 30th of June 2022 and continuing during the absence of Senator Jayanti Lakshmi-Dayal by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the Presidents and Anns this 30th day of June 2022. Honourable Senators, a senator is required to take the oath.
I, Marsha Walker, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Public Business, Government Business, Bill second reading.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I beg to move that a bill entitled An Act to Amend the National Insurance Act, Chapter 3201, to provide for the waiver of penalties and interest, to increase the penalty for the provision of false information, to increase the statutory limitation for the commencement of summary proceedings and other related matters, be now read a second time. Madam President, this bill is twofold in its approach, as on one hand, it provides for the waiver of penalties and interest on outstanding national insurance contributions for the period July 31st, 2022 to December 31st, 2022. While on the other hand, simultaneously, it strengthens the enforcement provisions against those mainly false statements or representations to the National Insurance Board. The resultant effects of the above amendments are A, the increase in the collection of outstanding contributions, B, the increase in the representation of employers, and C, the increase in the overall amount of national insurance contributions to be collected by the National Insurance Board. Madam President, this is not a novel approach that this government is taking today. May I remind the Senate and my friends on the other side that in 2012, through the Finance Act 2012, which took effect from October 2011 to June 2012, this country benefited from the first waiver of penalties and interest on outstanding national insurance contributions. Madam President, during the first waiver, a total of 2,310 employers took the opportunity to make outstanding national insurance contribution payments, which brought in an additional $36.8 million in outstanding contributions. However, this was only a small percentage of the contributions income collected in 2012, as the waiver was limited to only employers who were registered with the National Insurance Board prior to October 10, 2012. As such, there was no opportunity at that time for new employers to come into the national insurance system and benefit from this waiver. Madam President, this is where the bill being presented today departs from the Finance Act of 2012, as it is applicable to both registered employers existing prior to June 30th, 2022, and employers who will register during the waiver period, which will extend from July 31st, 2022 to December 31st, 2022. Madam President, as we are all aware, the NIB has been met with some challenges over the years. There has been a deficit between contributions and benefits for the NIS scheme for several years. As the Honourable Minister of Finance stated, the reason for this is simple. We have an aging population, so people are living longer, and therefore the requirement of the National Insurance Board to pay retirement benefits, in particular the National Insurance Pension, that is now placing an increased load on the National Insurance Board. Madam President, let me take a moment to define it for the population exactly how the NIS fund works. Those working now make contributions to pay the benefits for those retired now. Also, the assets in the fund are invested in various equities, various bonds, and the return on those investments are combined with those contributions to make up the benefits that are to be paid. What we have with our aging population is a shrinking workforce, and at the same time, a growing group of persons who require benefits. This is, of course, unsustainable. This is not a phenomenon that is unique to Trinidad and Tobago. This is happening all over the world. And the actuaries for years have highlighted this fact that there is a gap between contributions and benefits. This particular bill assists the National Insurance Board in closing the gap between contributions and benefits. During the period of waiver of penalties, or the amnesty period, the National Insurance Board would be the recipient of additional contribution income, thereby adding value to the National Insurance Fund. This bill empowers the minister to provide for those persons who also were not able to make the necessary statutory payments as a result of the economic impact of COVID-19 on their business. The period of waiver is now an opportunity to make the payments without the imposition of substantial penalties and the enormous interest that breach of the legislation warranted. Madam President, the measure we are passing is to provide those persons who earnestly faltered, those who did not and could not make the statutory payments at a period when the country, in the midst of a pandemic, shuttered and stunted the operations of businesses in order to safeguard the health and well-being of citizens. This amnesty is reflective of a government aware of difficulties faced, especially by our small, medium, and micro enterprises. It is reflective of a government that cares. Further, Madam President, the government is also providing those persons who have consistently failed to make contributions on behalf of their employees with an opportunity to do the right thing. The non-payment of NIS by employers has been a perennial problem faced by our country. This deprives several persons, particularly in low-income groups, of access to much-needed benefits while concurrently enriching the coffers of the employers that avoid making payments. This government is working to address this issue through the introduction of this bill, and when the period of waiver is over, the penalties will be so adjusted to deter the willingness to breach. Madam President, I say to those who have been willfully withholding their NIS contributions that they should get their house in order and pay now, because winter is coming. Madam President, the bill contains 6 clauses for our consideration today. The objectives of these legal provisions are to provide those who failed to meet the NIS obligations in the past with a final opportunity to regularize their affairs in advance of the introduction of more stringent penalties for breach of payments and increase the statutory limitation for the commencement of summary proceedings. Clause 1 of the bill, Madam President, is a short title, self-explanatory. Clause 2 references the Act as the National Insurance Act, also self-explanatory. Clause 3 permits the Minister of Finance to provide for future waivers of interest and penalties under the National Insurance Act by order, and this is a feature of modern legislation. Clause 3 of the bill does so by inserting a new subsection 2 in section 39B, the section under which interest and penalties are charged under the National Insurance Act. Madam President, Clause 3 of the amendment seeks to grant the Minister of Finance the power to grant future waivers of interest and penalties under the existing Act. It is important to note that such powers granted under this amendment is not a new construct, as it presently exists in a number of existing legislation, namely Section 9.2 of the Customs Act, Chapter 7801, Remission and Refund of Customs Duty, Section 6.4 of the Corporation Tax Act, 7502, extending, reducing, or otherwise altering the list of exemptions to corporation tax under Section 6.1 of the Corporation Tax Act, Section 8.4 of the Value Added Tax Act, Chapter 7506, which deals with zero rating of goods and services, Section 14.5 of the Motor Vehicles and Road Traffic Act, Chapter 4850, amends the 4th schedule of the Act for exemption of tax, and finally, Section 72 of the Miscellaneous Taxes Act allows for remission and refund of online purchase tax. Madam President, this list, which is in no way exhaustive in nature, explicitly highlights that legislation passed and proclaimed by this government and those that came before is awash with examples of ministerial authority with respect to the remission of taxes of all types. The main point to note, Madam President, is that a waiver bestows a benefit to individuals, and therefore, since waivers bestow benefits to individuals and persons, they cannot, in any form or fashion, trample on any enshrined rights under the Constitution. It is for this reason that I have referred to the various tax laws, and under these various tax laws, Parliament has ceded its oversight to the Minister for the waiver of interest and penalties. The operation by order of any future waiver of interest and penalties due from national insurance contributions having not been paid in accordance with the Act is reasonable, appropriate, and consistent with numerous other tax laws in Trinidad and Tobago. Clause 4 of the bill repeals Section 39C and replaces it with a new Section 39C. Madam President, this clause is nearly identical to the waiver implemented in 2012 through Section 8A of the Finance Act, Act No. 2 of 2012, with one distinguishing exception. Extending the waiver of interest and penalties to employers who registered during the period July 1st, 2022 to December 31st, 2022. In 2012, it applied to persons who were in the system at the time of the commencement of the amnesty. This one will allow new entrants in terms of registration to register during the period of amnesty. Section 39C1, contained in Clause 4 of the bill, implements a waiver on penalties and interest due under Section 39B of the Act, where the contribution is paid by the employer between July 1st, 2022 to December 31st, 2022. A bona fide employer-employee relationship must be in existence. It cannot be fraudulent, and the NIB will be tasked to be very careful with any employer who seeks registration during the amnesty period. Section 39C2, contained in Clause 4 of the bill, applies the waiver to employers registered prior to June 30th, 2022, and those who become registered during the period July 1st to December 31st, 2022. Section 39C3, contained in Clause 4 of the bill, clearly establishes that the waiver on penalties and interest does not affect the payment, the actual payment of contributions, or the rate of contributions that have to be paid as set out in the National Insurance Act. Section 39C4, contained in Clause 4 of the bill, operates to revive the interest and penalties when an employer fails to pay the same during the period July 1st, 2022 to December 31st, 2022. Madam President, Clause 5 of the bill increases the penalties for associated offenses of, firstly, A, knowingly making any false statement or false representation, and secondly, B, produces or furnishes or causes or knowingly allows to be produced or furnished any document which a person knows to be false in any material particular. This clause will increase the penalties for persons making false representation to NIB, and that is particularly relevant to the opportunity for unregistered employers to now register with the NIB. The increase in penalties is significant. The fine, which was quite minimal in previous years, was part of admittedly archaic legislation. It has not really been increased for a long time. The fine and custodial sentence were quite small, so that this bill is significantly increasing the applicable penalties as a strong deterrent for persons who wish to submit false information during the waiver period and in the future. Clause 6 of the bill seeks to increase the period of pursuing summary offenses under the Act from 12 months to 3 years from the date of the commission of the offense, or from 3 months to 12 months from the date in which the executive director had personal knowledge of the offense. The improvements in Clause 6 of the bill allow the National Insurance Board further time to commence investigations and ultimately proceeding before the court before suspected criminal actions become statute barred. The joint effect of Clause 5 and 6 is to strengthen the enforcement provisions under the Act to ensure that the National Insurance Board is better able to pursue those who submit false information, documents, or statements. There are other mechanisms that exist under the Act to help the National Insurance Board in unearthing fraud, so this is not the only measure. For example, Section 31 of the Act permits the National Insurance Board to request information from employers concerning employed persons and to inspect any record of employed persons. Section 32 of the Act permits authorized officers to enter and search premises to examine books, records, and documents. Madam President, provision is also made for seizure of books, records, and documents under Regulation 6 of the Insurance Act, which contains these existing provisions. Regulation 6 of the National Insurance or Contribution Regulations makes a legal requirement for all employers to provide the National Insurance Board and retain for a period of 7 years until audited by the National Insurance Board with the following information: the names and national insurance numbers of employees in their employ, the monthly or weekly salary or wage of the respective employees, the contribution class in which earnings are paid, and the number and value of contributions due in respect of each employee for every week in the said month, and any other information required by the National Insurance Board. These existing powers, supplemented by the enhanced enforcement powers proposed by Clause 5 and 6 of the bill, will assist the National Insurance Board in pursuing those who are intent on providing false, misleading, and erroneous documentation or statements during the waiver period. As I said earlier, Madam President, winter is coming. Let me conclude, Madam President, by reiterating my support for this bill. Its implementation will, in short term, add to the coffers of the National Insurance Board.
Minister, I think Senator Vieira wants to ask you.
Sure.
Thank you, Madam President. Honourable Minister, winter is coming, and I know that the NIB is under a lot of challenges in terms of income. So, yes, we want to increase these penalties and fines, but can you tell me, not now, but in your winding up, hopefully you'll get the information, how many people have actually been charged under Section 63 with making false statements, producing false documents, or under Section 65 with failing to pay contributions? And also, how many cases have actually been brought by the NIB under Section 66 for civil proceedings to recover sums due to the board? What's the sense? I would like you to be able to convince us that, yes, we need to ramp up the penalties, but we're also going to enforce, because if we don't enforce, it makes no sense.
What I can tell you is that I do not have that information at this point in time, but I can get it for you. But we have introduced a method in terms of detecting the companies that have not been making their contributions. And we estimate there are approximately 4,000 employers in Trinidad and Tobago that are fraudulently not making contributions.
Minister, under this law, you can't hide behind the company veil. You can go behind any director, manager, officer involved in the offense. And also, unlike typical summary offenses, which is 6 months, you have 3 years to bring the charge. So I'm really hoping to hear that NIB is going to get serious with enforcement.
Yes, that's exactly what I'm saying. We have improved detection. We are much better at this point in seeing which employers are not in compliance with the law. And we are absolutely, after the amnesty period, going to go after these delinquent employers. I can assure you of that. Its implementation will, in the short term, add to the coffers of the National Insurance Board and in future place the institution on a better footing to execute its mandate. All of this redounds to the benefit of the people of Trinidad and Tobago, who must avail themselves of the several benefits offered by the NIB. And in case we have forgotten, The NIB is the linchpin of our social safety net program in Trinidad and Tobago. Some of the categories in which they offer benefits are sickness, maternity grants, special maternity grants, retirement, retirement pension, retirement grant, employment injury, injury allowance, medical expenses, disablement grant, disablement pension, employment injury death, widow's pension, widower's pension, child's allowance, dependent parent pension, remarriage grant, and a host of other benefits that I do not have the time to list here today. Madam President, the NIB is determined to provide for future generations of this country post-retirement. Madam President, I beg to move.
Honourable Senators, I shall now propose a question for debate. The question is that a bill entitled An Act to Amend the National Insurance Act, Chapter 3201, to provide for the waiver of penalties and interest, to increase the penalty for the provision of false information, to increase the statutory limitation for the commencement of summary proceedings and other related matters, be now read a second time. Senator Mark.
Thank you, Madam President. Madam President, the bill before us seeks to amend the National Insurance Act, Chapter 3201, to provide for the waiver of penalties and interest, to increase the penalty for the provision of false information, and to increase the statutory limitation for the commencement of summary proceedings under the National Insurance Act. Madam President, the Minister, in his very brief statement on a very far-reaching measure that will impact negatively on the NIB operations and its ability to make its obligations realizable under the act governing this very important social security and safety institution in this country. The Minister gives the impression to this Honorable Senate that this is a very simple and straightforward matter because it was done before in 2012 under the partnership government. But the Minister cherry-picked his language, but I will clear the air for the sake of my honorable colleagues in this House to show the fundamental distinction between what the then Minister of Finance did in 2012 and what this government is seeking to do in this 2022 amendment. Unfortunately, Trinidad and Tobago does not experience winter. So I want to tell the Honorable Minister, it is not winter that is coming. It is heat for the PNM that is coming because of this amendment. Heat. Madam President, you know, when I looked at this thing, it pained me how a government, in this slipshod manner, Madam President, could bring such far-reaching amendments to the NIB and simply, tell the Senate that it is necessary in order to help the poor man or the individuals in the society. But when we look at this whole exercise before us, Madam President, we have to ask the question, why must our Parliament, why must this Senate, Madam President, reward? Why must we reward wrongdoers? If I break the law, Madam President, the government is coming for me through the police, or through the police, I should say, to charge me. If I'm involved in corruption, and the government is aware of that through the police, they are coming to charge me. And I'm ending up before court, facing jail terms. But here you have, Madam President, the government in a very, what I call, slipshod manner, brings an amendment to do what, Madam President? To reward a confederacy of wrongdoers in our nation. We are actually, Madam President, through this amendment, rewarding lawbreakers, people who are supposed to be in jail for not honoring their obligations to the workers of this nation. And you are telling us, Madam President, we must accept this? And Madam President, what is even worse is that the minister is arrogating unto himself a power that in 2012, Minister Winston Dukaran never even contemplated. The minister in this piece of legislation, and I'll bring it to your attention, Madam President, wants to have the power to waive penalties, to waive interest. And not only that, Madam President, those wrongdoers, those lawbreakers can now break the law at will because the minister in the legislation is giving himself the power to pardon them. This is what is called law breaking, illegality in perpetuity. That is what we are being asked to approve today. Madam President, in another country, there might have been action on the streets of this nation, of another nation. I don't know why our people are so quiet. But this is not acceptable in a modern, civilized society. How can a government come with this kind of thing in 2022? When people, Madam President, when we did it in 2012, we discovered there were about 3,000 or thereabout employers who were not making their contributions to the NIB, okay, over a 4-year period. And an incentive was offered at that time in 2012 for them to put their house in order, those who were registered. I do not know how much money they realized at the time, Madam President, but it was for a specific period. It was like what is called a sunset clause was introduced in 2012. And when that time was up, it was up, and we went back to normalcy. This is not what the government is proposing, Madam President. Madam President,
46.6 in 2012, the Minister of Finance unilaterally extended the amnesty at that time.
You must await your ruling on matters.
Senator, I'll just continue. Thanks.
Thank you very much. Madam President, let me just deal specifically with what we have before us. Madam President, the measures contained in this bill will hurt the National Insurance Board. In the main, as a people's social security institution. It will hurt the National Insurance Board. Madam President, employers would have collected, they would have utilized, they would have retained, I should say, collected, retained, Madam President, and utilized the monies from the employees. And they are supposed, Madam President, in accordance with the NIB law, twice the amount, 1/3, 2/3. That is the arrangement, literally. So the employer, Madam President, would have collected, retained, and utilized the monies, Madam President, that they were supposed to submit to the NIB. And we don't know for how long, because the minister was very economical in his contribution today. We don't know how many employers are involved. We don't know, Madam President, what is the value owing to the people and the NIB. We don't know if it is big, medium-sized, small businesses that are involved. We don't know, Madam President, what role the government is playing in this whole exercise. Is the government a lawbreaker in this matter? We don't know, because the minister has not provided us with any details. And he wants this Senate to give him a blank check. How can we give you a blank check and you have not provided the Senate with full disclosure? Where is the transparency? Where is the accountability? How can you expect us to just give you a blank check today? You have to provide this country and the Senate with details. How many employers are at fault in this particular matter? We don't know, Madam President. Madam President, these amendments that we have before us would give the minister what I call, Madam President, and deem limitless powers to give waivers to employers who would have blatantly and brazenly breached and violated the NIB Act. That is what we are being asked to do today. Madam President, I would have thought that a serious government coming to this parliament might have wanted to consider some options available, Madam President. For example, should we not, Madam President, be considering, if the government is seeking to give the minister this power to waive penalties and interest, tell the Senate, listen, those employers who are owing $200,000 or $100,000 to the NIB, up to a maximum of $200,000, those employers, right, would be granted a limited waiver or amnesty for 6 months to pay up. And those who are above 200,000, right, Madam President, these people must pay. And not only must they pay, Madam President, we want to know the names of those companies. Are these companies the financiers of the PNM? We need to know. Madam President, this thing is pregnant with possibilities of manipulation for corruption and corrupt purposes. I'm not saying the minister will do it, Madam President. Any minister of finance with this kind of power can manipulate the system to say, I am discriminating against A as opposed to B. I am giving B a blight and I'm not giving C a blight because, Madam President, the Parliament has no oversight. The Parliament has no supervision. The Minister is an absolutist. He takes all the power
Madam President,
from us.
46.6, please.
Yes. So, Senator Mark, your language is becoming increasingly... No, just hold on. May I just finish my ruling, please, Senator Mark? Your language is becoming increasingly inflammatory, so I'll ask you, please, to dial it back. Okay?
President, if you were in my place, Madam President, you would have been just as me. Very, very passionate about this. But I understand.
Okay.
Madam President.
Madam President,
I'd like
may I
to ask
continue,
Senator
please?
Mark, please. He gave some numbers before. I'd like to know how were those numbers derived in terms of what level person should be allowed to escape.
Senator Mark, are you allowing...
Madam President, I'm not allowing anyone unless they get my permission. Okay? Madam President, I am calling on the Minister of Finance or the Minister in the Ministry of Finance to provide the Senate with a list of all the beneficiaries of these penalties that you are going to waive. We want to know, Madam President, how many, who are there, and what is the sum of monies that NIB will be given up. We want that information, Madam President. We need to get that information. Why must we give the government a blank check to write off or to forgive unlimited amounts owed to the NIB without any form of scrutiny, transparency, and or accountability? Madam President, the bill is seeking to amend, Madam President, the Parent Act. Madam President, go to section 39B of the legislation, because the first thing you would see here, Madam President, in the bill before us, if you go to clause 3, you will see where in 39B, the minister, we are inserting in 39B the following. Madam President, in subsection 2 of clause 3, it reads, the minister may by order provide a waiver of penalties or interest due and payable under this section. This is a new section that has been inserted in this particular legislation. It was never here before, Madam President. The minister inserted this provision or section to give the minister what is called, Madam President, total sweeping and absolute power without any supervision, any accountability, any kind of oversight by our Parliament. Madam President, let's understand what is at stake here. Madam President, in section 39B, and Madam President, may I tell you, I have been advised, I have been informed, and I call on the minister to clear the air on this matter. The NIB is based on the principle, Madam President, or concept of tripartism. Tripartism. It has labor, it has government, and it has business. I have been advised that this matter that is before us today never went before the board of the NIB for its approval. This is a unilateral decision taken by the government of the country without any consultation with labor, without any consultation, I understand, with business, and of course the government is involved, so the government consulted itself. I would like the minister to indicate this because I spoke to the labor movement, JTAM, Faitang, and Natok, and they have all indicated to me that they have never seen this amendment. It was never brought before the board of the NIB. This was a unilateral decision taken by the government of Trinidad and Tobago. And Madam President, if we believe in social dialogue, if we believe, Madam President, in the social partnership concept, you must try to arrive. Senator Vieira would agree with me. When you talk about social dialogue, you must, Madam President, try to bring the parties together. And Madam President, even though they don't agree, because not every time, Madam President, people are going to agree. But at least, Madam President, the record would show that the government brought this matter before the NIB Board of Directors, and there was a majority vote on it. But not to bring it, Madam President, to the attention of the NIB is a crime against the workers of this country. And the government comes here today and they don't tell us that, Madam President. The government must speak when the time comes, Madam President.
46 Ward. How is bestowing a benefit on the people of Trinidad and Tobago attacking workers?
Senator Mark, if I could be allowed to make the ruling, the minister has invoked the standing order, and then you are speaking at the same time. Can I just ask you, Senator Mark, to continue?
Madam President, I go on to this section that talks about the minister may by order provide for the waiver of penalty, that is section 3 or clause 3, Madam President, subsection 2. Madam President, I want to serve notice that we will be circulating an amendment to this particular section of the legislation. So we serve notice on the government that we are not in favor of the current construction or configuration of this clause in the legislation. Madam President, if you go to section clause 3, it talks about 39B of the Act. Madam President, what does 39B of the Act tell us? It tells us, Madam President, and I quote, for your information, Madam President, let's go to what we are talking about. The employers, Madam President, if you go to 39, let me just get this particular section of the legislation for you. Madam President, go to 39B. What does it say? Where any employer fails to pay the amount of contributions payable by him to the board under the provisions of this act by the 15th day after the due date. So, Madam President, if I am an employer and I take from your salary, I deduct from your salary your NIS contribution, I top it up by 2/3, I have until the 15th of the following month. So if we are now on the 30th of June, I have until the 15th of July to submit my contribution to the NIB. That is what the law says, Madam President. He shall be liable if he does not do that, Madam President. If the employer does not do that, you know what happened? If that is not done, he shall be liable to pay the following penalties. And that is what we are being asked, Madam President, to waive. Here are the penalties that the employer will be called upon to pay and to make. Madam President, 1, a penalty of 25% of the outstanding sum. So if you owe after the 15th that amount of money, the NIB under the law must impose a 15% charge of interest on that money. You are asking the Parliament to waive that. So you collect my money, you collected my money, you retain my money, you utilize my money, and then after you do all that, Madam President, and I dare say, Madam President, there are some employers who has invested NIB money for their own purposes and not remit same to the NIB. And then you are telling me, Madam President, we must reward those employers? Look, Madam President, I have respect for employers. I'm a Democrat. But I say there is something called fair treatment. There is something called fair treatment. We demand fair treatment. If you break the law, Madam President, those who do the crime must do the time. You cannot be breaking the law, Madam President, and we are rewarding you for breaking the law. That is not fair. So, Madam President, we go on. 39B, you go to B. So the first thing, Madam President, 25% if you pass the 15th day of the following month. Madam President, penalty, this is B, penalty of 100% of the outstanding
Senator
sum.
Mark, I have to stop you here. You're dealing with Clause 3 of the bill, I believe, and you are objecting to Clause 3. You've stated that a few times. There's no need for you to be going into the Parent Act and setting out all of the provisions of the Parent Act. So, well, I'll give you exactly 30 seconds, Senator Mark, to see if you link what you're saying now, because as I see it, you're kind of repeating.
I'm linking it because we are talking about the minister having the power to waive penalties. And if you go to 39B, A, B, and C, these are the penalties that the minister is seeking to waive. So I need to bring...
No, so I hear you, I understand, Senator Mark, and what I'm saying is all of that additional, what you're saying additionally by going through the penalties and the interest, it's not necessary. And you've made the point already about Clause 3. So I don't know if you want, there are 3 more clauses that you can treat with in the bill as well.
President, I thought you had given me the freedom of speech to exercise under the Constitution.
So, Senator Mark, you know that you have freedom of speech, but you know as well that it is thank you.
Okay, Madam President, I go on with your guidance. Madam President, the employers would have made their contributions to the NIB. That is, the employees, I should say, would have made their contribution to the NIB by way of deductions from their wages and salaries. Madam President, I want to tell this Honorable Senate that my wages and my salaries, which I receive over a period of time, constitute my property. And for any employer, Madam President, to take my property and not remit it to the NIB, that is equivalent to embezzlement. That is equivalent to fraud, Madam President. Any employer that fails to submit my wages through that deduction process to the NIB is embezzling my money without my authorization, is committing a fraud. That is what this is about, Madam President. How can we forgive such people, Madam President? We can't. So, Madam President, I'm saying to this Honorable Senate that it is absolutely unacceptable and indefensible for us to engage in any activity to address wrongdoers by rewarding them. Madam President, you go to Clause 4 of the bill, and you see in Clause 4 of the bill, they are repealing 39C of this bill, of this act, Madam President, and they are substituting the following. Madam President, in this Clause 39C, we are being told, notwithstanding any written law to the contrary, there is a waiver of all penalties and interest due and payable under 39B. Madam President, in respect of any contribution outstanding as at the 30th of June 2022 by an employer under this Act, and where the contribution is paid during the period 1st of July 2022 to the 31st of December 2022. So, Madam President, what is being said here is that you are getting a waiver on all penalties and interest that you owe the NIB and that is payable under 39B. Any outstanding contribution as at the 30th of June, you don't have to pay. There are no penalties, no interest, Madam President. If you go to subsection 2 of clause 4, you will see, Madam President, where the waiver under this applies to an employer who was registered with the board prior to the 30th of June. So, Madam President, yes, an employer who was registered with the board prior to the 30th of June, yes, he is going to be able to benefit from this waiver. But, Madam President, it goes further. It says in B, an employer who registers with the board during the period 1st of July 2022 to the 31st of December 2022 will also be able to benefit from this waiver of penalties as well as interest. So, Madam President, what this is telling us, if you are registered before a certain date, 30th of June, no problem. You will enjoy all these privileges through waivers. But the government goes a step further. The government is saying, Madam President, if you were collecting NIS from workers and you were not registered, Madam President, for several years, you can now register for the first time. Don't pay penalties. Don't be subject rather to penalties and no interest. So on 2 counts, this pro-employer government takes a decision to give the employer a blind. You register, it's okay. You don't register, it's okay. So what is this government is about, Madam President? Is this not a lawful government? Is not this government supposed to be upholding the law? But you know, Madam President, while they are doing all this for employers, they are telling you and me and all ordinary workers under the National Insurance Act, if I reach my 60th birthday and I'm entitled to retire, having paid my 760 contributions, the government is proposing 6% deduction. 61 years, 62 years, 6% reduction. 63 years, 6%.
46.1, this is not relevant to the matter before us today.
Yes, Senator Mark, continue.
Is trying to promote the interests of the employer, and they are not promoting the interests of the working class in our country. They are telling the working class, Madam President, that they must retire at the age of 65. Nothing for you if you go at 60. Meaning, 3,000 is not yours. That is wrong.
Madam President, may I go on, 46.1.
Madam President, may I go on?
What does increasing the retirement age have to do with this?
Minister, I ruled previously I'm allowing Senator Mark to make his arguments, and so I'm going to allow him to continue. Senator Mark.
I don't know if my honorable colleague is suffering from newness. I don't know. He doesn't understand the process, but I am happy that the President is guiding you. Madam President, may I continue, please? Madam President, if you go to the same clause 4, you go to subsection 3 of clause 4. The waiver under this section does not affect the obligation of an employer to pay contributions in accordance with section 38, Madam President. Madam President, it goes on. Where an employer fails to pay his outstanding contribution by the 31st of December 2022, the penalties and interest which would have been payable in respect of the failure to pay the contribution shall be revived and become payable as if the waiver was under subsection 1 had not been granted. That sounds very reasonable. It sounds reasonable. But hear this thing in detail, Madam President. Hear this thing. In subsection 5, the minister enters the arena of the NIB again. And this time, in subclause 5 of section 4, the minister says, the minister, according to this clause, may by order prescribe a later date for the payment of contributions under subsection 1. Madam President, it is as if, Madam President, the government has a death wish for the NIB. Is the government actively promoting measures in this bill to close down the NIB? Because this measure here is telling me that any employer, Madam President, who does not satisfy what the minister has in this piece of legislation in clause 4, if he does not meet the 31st of December deadline, here comes the minister. I want to repeat, Madam President, it's important for you to note. The minister may by order, without any parliamentary oversight, without any parliamentary supervision, without any transparency, without any accountability, the minister may by order. You know, these things happen in France, you know. Under a woman called, you know, I think it was Queen Marie Antoinette. You know what happened to Marie Antoinette with these kind of measures?
Senator Mark,
All right,
please.
Madam President, may I tell this government that it is provoking the population with this kind of measure. They are provoking the population with this kind of measure.
Senator Mark, I still have to caution you, your language.
Madam President, the minister in subsection 5 of clause 4 may by order prescribe a later date for the payment of contributions under subsection 1. Well, we have lawyers here. I am not a lawyer, I'm a bush lawyer. But I think I understand what I'm reading. The minister has the power, Madam President, after the 31st of December 2022 passes, he has the power under this section to extend the time to these friends and financiers of the PNM, Madam President, to do whatever they want. The government can't be serious. So let me serve notice on the government as I'm here. We will not support this. We will be making amendments to this section of the legislation, Madam President. Madam President, I want to indicate that when you examine what we have before us carefully, Madam President, in 5 and 6, Madam President, what is the government doing? Giving you a little slap on the wrist. So the government says, listen, you see the penalties? Instead of $2,000 that was there since 1972, or a little later, and to imprisonment to a term of 6 months, for our friends and our financiers. If you do not straighten up...
Senator Mark, you actually have, and I apologize, 1 more minute.
Madam President, I'm sorry. Madam President, I want to tell this government we reject completely this abomination that is before this House. We say this government is playing with fire, they are provoking the population, and this measure is not acceptable to the working class. It is a pro-employer arrangement. I have no problem with employers, but I need fairness. I need a balance. I need justice for the workers. There are workers who are suffering out there. They have not been able to get their pensions. They have not been able to get maternity grant and leave because, Madam President, employers have failed. Even though we have Section 50 of the NIB Act in play, they have not been able to meet their obligations in accordance with the law. So, Madam President, the government must withdraw this bill, seek proper consultation with the social partners, and come better. And let us bring this thing to a joint select committee or select committee of the Senate so we can go through it thoroughly and comprehensively. I thank you very much, Madam President.
Senator Deonarine. While we await Senator Deonarine to begin her contribution, I remind members that if there are amendments, they must be put in writing and circulated prior to the commencement of the committee stage. Senator Deonarine.
Thank you, Madam President, for the opportunity to contribute to the debate on an act to amend the National Insurance Act, Chapter 3201, to provide for the waiver of penalties and interest, to increase the penalties for providing false information, and to increase the statutory limitation for the commencement of summary proceedings and other related matters. Madam President, this bill is a simple bill. It offers waivers of penalties and interest to employers. It offers an opportunity to delinquent employers and employers who experienced economic hardship over the past several years to settle their outstanding national insurance contributions. What it also does, Madam President, is it gives an opportunity to these employers not registered with the national insurance system to now register, potentially increasing the number of contributors to the system. While I agree with this amnesty, I do so with some concerns, some reservations, some concerns that I would speak to during the course of my contribution. Madam President, as opposed to Senator Mark, I actually think offering this amnesty is long overdue and indicative of a starting point to deal with the long-term sustainability issues that we have with the National Insurance Fund. Now, expenditure on the fund, on the National Insurance Fund, first exceeded contribution income to the National Insurance Fund 9 years ago, in 2013. Actuarial reviews for several years have highlighted and brought to the attention of several policymakers during this government and previous governments of the widening gap between contributions made to the National Insurance Fund and the benefits paid out. The deficit has been an ongoing issue which policymakers over several administrations have been slow in responding to. For fiscal year 2021 alone, Madam President, benefit expenditure was $5.5 billion. When we take into consideration non-contributory senior citizen pensions for the same period, fiscal 2021, expenditure was $4.2 billion. Madam President, that is a total of $9.7 billion in expenditure to sustain the elderly in Trinidad and Tobago. That is approximately 7% of GDP and 36% of government expenditure on transfers and subsidies. Madam President, this is not sustainable. Madam President, as I continue to set the context for the points that I will make later on the different clauses of the bill, it is important to understand that this increasing demand has been as a result of demographic changes to our population. Trinidad and Tobago is characterized by an aging population, as several speakers before would have indicated. There's a higher life expectancy, a declining labor force, a high old age dependency ratio at about 19%, and declining fertility rates. The problem is being further exacerbated by declining labor force participation rates, stagnating economic conditions characterized by slow growth, increasing unemployment, and inadequate understanding by policymakers of the size and the evolution of informal employment and the informal economy. In other words, Madam President, this problem has been a slow burning fuse for some time. So, Madam President, this bill before us via Clause 4 offers a temporary coping mechanism to assist the National Insurance Board in closing the widening gap between contribution income and benefit expenditure. The gap is currently valued at just over $1 billion. Clause 4 applies a waiver of penalties and interest to employers registered with the National Insurance Board as of today, the 30th of June, and those who register with the board over the next 6 months. So those are employers who have never been registered or received a certificate from the National Insurance Board, have never paid any contributions of national insurance for their employees. So the question is this going to achieve the intended objective of narrowing the gap between contributory income and benefit expenditure? So it is important to remember and remind everyone what the objective is. The objective is to narrow that gap and increase the quantum of national insurance contributions. Now, as I said, this measure presented in this bill is a short-term one. It certainly would assist, but it is not the be-all and end-all. It is a temporary measure, and the problem will continue to persist. Even with the amnesty coming into effect bright and early tomorrow morning, until the end of the year, a close look at the estimations provided by the Minister of Finance, and I refer to an article by the Trinidad Express, which the Honorable Minister of Finance would have provided details on the estimated contributions that they expect to receive from this amnesty. I didn't hear the Honorable Minister in the Ministry of Finance mention these estimates. So the estimates are 10% of errant. Currently, there are 4,000 employers who are currently not registered with the National Insurance Board, as per estimation by the National Insurance Board. And the NIB is estimating that 10% of those 4,000 employers would take advantage of the amnesty, which is a rather very conservative estimation. But when we take a close look at these estimates and what we expect to yield from this tax amnesty, Madam President, it is easy to see that the National Insurance Fund will continue to be under pressure, and the long-term sustainability of the fund will continue to be under pressure. So the expectation is that at the first year, according to this article, and this is also validated with the Hansard, in the first year of this amnesty, we expect to receive $161 million. This is with respect to unregistered employers who would now become registered. That is the 400 persons, the 10% of the 4,000 persons who the NIB currently estimated are unregistered. So the estimation is that 161 million in additional contributory revenue would be earned, followed by 79 million annually for the next 10 years. So for a total of 790 million over the next 10 years. Madam President, this is this increase works up to an annual increase of about 2% increase in the contribution income in the fund for the next 10 years. And if we look at the rate at which the fund has been, and using a conservative estimate of benefit expenditure increasing by about 3%, because actually the benefit expenditure has been increasing by about 5% annually over the last 6 years, then we will still be in the same problem. By 2030, if we run a quick estimation, we'll see that the fund would be at a deficit of $2 billion. At 3%, if the fund continues to, if the change in benefit expenditure continues to grow at a rate of 3%, and if the rate of growth in benefit expenditure continues to grow at the rate of 5%, which it is currently growing over the past 6 years, then by 2030, our deficit would be about, the deficit on the fund will be about $3.3 billion. So we all have to agree that there is a problem. The problem is going to persist, and we need to find a solution, which is where the parametric changes recommended by the NIB comes into play. But, Madam President, I know that is not the subject of discussion today, so I would move on. But apart from that, with respect to the matter that is before us today, waiving interest and penalties to employers, I have a concern as to why the NIB's estimated uptake is so conservative of 10%, knowing that there are 4,000 persons, 4,000 employers who are estimated to be unregistered with the NIB. Perhaps the NIB is really being so conservative because maybe consideration is being given to the dent on businesses' cash flow that this measure would bring in terms of taking advantage of the amnesty. And it may very well, to some extent, serve as a deterrent to employers to register with the NIB and derail achieving the objectives. Now, let me clarify, Madam President. Let us look at the impact of the amnesty on employers. Let us take an example. If a sole trader who has been in operation for the past 10 years, employing one person at a salary of $10,000 per month, that person automatically, that employee of the sole trader falls under class 12 of the NIB contribution rankings. And in that case, when this person takes advantage of what is being provided in clause 4 of the bill, a previously unregistered employer who is now going to take advantage of the amnesty that is being provided, so therefore he registers. As he registers, he is expected to pay his portion, which is one 2/3 of the contributions to the NIB for the past 10 years. Now, we're looking at an employer who has this employee had a salary of $10,000. The employer's NIS contribution at that point in time, when he decides to take advantage of this amnesty, is $155,000 for that one employee. And that is assuming that this is a very small business, a micro business, and assuming that the employee have not paid any contributions as well, because we very well know, as Senator Mark would have indicated, there are some instances where employers would receive contributions from employees and have not been paying to the National Insurance Board, and as a matter of fact, in some instances, have not even been registered with the National Insurance Board. So we are talking about $155,000 an employer has to find cash to pay this amount of money in order to take advantage of the amnesty. Now $10,000 may sound as a lot. Let us think about a micro business who might be employing somebody for $5,000. In that case, the amount that will be due and the amount of cash that would have to be paid, the amount of liquidity or the cash flow that is required for that employer to pay to the National Insurance Board is $66,000. And that is providing that he employs one person at $5,000. Let us break it down even further. Let's say a sole trader employs someone at minimum wage. That is a monthly salary of $2,800. If he has been errant for the past 10 years and has employed this person for the past 10 years, then the amount that is due to the National Insurance Board would be $37,000. Now, in the definition of a micro business, it is understood that a micro business employs between 1 to 5 employees. A small enterprise between 6 to 25 employees. The sales of a micro enterprise, the sales revenue of a micro enterprise is around $250,000, less than $250,000. So for any small business hiring 5 employees at minimum wage, it will cost that firm some $187,000 to take advantage of this amnesty. If they were errant for the past 10 years, and if they were errant for, let's say, 5 years, then it will cost that firm $93,000. This is a firm that is categorized as micro, who has sales revenue of less than $250,000. This is almost all of this micro business sales revenue. This is not taking other expenses into consideration. So, and it also depends on the number of years that this person has been errant. Now, Madam President, the point that I'm trying to make is that I am really not sure that the liquidity or the cash flow position of micro and small businesses would allow for such large payouts in 6 months. Because this is a large chunk of money that these businesses would have to dish out to take advantage of this amnesty, especially coming out of a period of severe economic hardship, and coming out of a pandemic where many businesses had to be closed, many businesses had to pivot their operations. Many businesses are actually, to this day, battling challenges of rising prices, rising cost of inputs, rising cost of doing business in general. So, Madam President, to achieve the objective that we are trying to achieve, I see this actually as this challenge that micro and small businesses would encounter would actually serve as a deterrent from taking advantage of this tax amnesty. And serious consideration should either be given to maybe extending the amnesty to a period of 1 year so that cash-strapped businesses are able to pay increments of the amount that they would owe to the National Insurance Board within a very clear defined criteria. Now, it may very well have the medium and the larger businesses who has the cash flow flexibility to make these payments. But for micro and small businesses, we need to be considerate as to their ability to take advantage given severe economic constraints that they would have experienced over the past couple of years. So, Madam President, just to reiterate, there is an incentive to be dishonest upon registration. So, let's just say, I am a sole trader. I've been in existence for 12 years. I've hired someone for the past 10 years. I want to register with the National Insurance Board. I register with the National Insurance Board, but my cash flow and my accounts does not show that does not allow me to pay the amount that I owe to the National Insurance Board at that point of registration. But I really want to register with the National Insurance Board and take advantage of this amnesty. It encourages me to want to be dishonest on the application and say, well, you know, I've hired X, Y, and Z for only 2 years. And there's nothing in the legislation that establishes a criteria which would prove that a bona fide relationship exists between the employer and the employee. So this is entirely now up to the National Insurance Board to say that, to define a criteria that would allow the employer to provide sufficient information, justifiable information, to prove that a bona fide relationship exists between the employer and the employee. But I assume that in this case, the National Insurance Board compliance procedure would pick up. And this is where Clause 6 of the bill kicks in, because Clause 6 increases the charge for provision of falsified information from $2,000 to $50,000 and to imprisonment for 3 years. So now, initially, I explained the trail of thought that one sole trader may entertain. They may initially think that, well, no, I cannot afford to pay for the 10 years that I hired this person when I register. So I'm going to say that and provide documents and say that I have hired this person for 2 years. But from what I understand, Madam President, the National Insurance Board has been increasing the number of audits, the number of compliance procedures. They have been strengthening their compliance units. And they are going about increasing the level of compliance. And with this piece of law in place, with this clause coming into effect, Madam President, any employer seeing that the risk that they would have to run $50,000 and imprisonment for 3 years for providing falsified information, which is actually the thought that they were entertaining, may very well end up just not bothering and just not taking advantage of the amnesty and not registering with the NIB and continue to be part of the informal economy. So, Madam President, while I understand the logic in increasing the fines to deal with the risk of fraud and that is highly probable with the inclusion of unregistered employers, it is meant to force compliance, but would this be sufficient of an incentive to get persons to want to register with the National Insurance Board? And that is what we are trying to do. We're trying to get persons to enter into the system so that there can be an increase, a sustained increase in the number of contributions to the fund. So this is why I am thinking that the NIB is being so conservative with their estimations on the number of employers who would actually take advantage of this amnesty, because it could go either way. So as I was saying earlier, Madam President, I understand that the NIBs has stringent audits that they take place. They have some compliance procedures that they have been increasing. But Madam President, to improve compliance, it is important to take into consideration several factors. Now, increasing penalties and fines are one thing, but we also have to take into consideration the financial ability of firms to take advantage of the amnesty, which is what I established earlier on. It may not, there's a high likelihood that many employers, especially the ones who we are providing this amnesty for, may not have the financial ability to take advantage of this amnesty. And there is also another factor that has to be taken into consideration is understanding the national insurance, the NIB program, and how the insurance works. Now, I understand how the insurance system works. Now, I understand that the NIB has been on a drive to increase public awareness and public education about the benefits, the contributions, and how they work. I think a lot more needs to be done because there are a lot of persons who do not understand how this national insurance fund works, how the benefits work, what you get for your contributions, and so on. Actually, Madam President, there are so many employees who do not know that even though they are contributing, that their employer should also be contributing on their behalf. They do not know that the employer is responsible for 2/3 of the contribution, and that is something that came to light at the onset of the pandemic, and when I forget what they call the grant that was offered by the Ministry of Finance. There was a grant that was being offered by the Ministry of Finance, and a lot of persons could not have qualified for that grant because even though they were making their contributions, their NIB contributions, the employers were not. So they automatically had to be redirected to the Ministry of Social Development and Family Services and apply for that grant there. So we really need to improve or increase on the understanding on the public education programs and so on. Now, another factor we need to take into consideration, Madam President, is self-attitude. And this is where building voluntary compliance comes in. Self-attitude, Madam President, is dependent on several external factors. Equity of the national insurance system. Right now, you make 750 contributions, regardless. At 750 contributions, without consideration for the quantum of contributions that you make, and you are entitled to the same retirement. Another external factor is the quality of healthcare received. So yes, we have employers coming on to becoming registrants and contributing, but what about the quality of healthcare received, both in the public and the private healthcare system? In terms of, Madam President, you're paying this national insurance. What am I to get out of it?
Deonarine, I have to caution you here. I think you're moving beyond the ambit of the bill. Okay?
Madam President. So, Madam President, what we are trying to do with Clause 4 is we are trying to increase or improve on compliance. Clause 4 seeks out to have unregistered persons the opportunity to become registrants with the National Insurance Board. So we were trying to improve compliance to the National Insurance Fund. So the point that I'm trying to make, Madam President, is that we cannot simply think about Clause 6 by increasing the fines to deal with this compliance problem. Increasing fines is not sufficient. It may help, but it is certainly not the solution. We have to create conditions to encourage voluntary compliance as well. So I am concerned that what may end up happening, and I've said this before, and just to repeat, I am concerned that what may end up happening is that the cash flow constraints of micro and small businesses, coupled with the increased penalties, may in fact serve as a disincentive for unregistered employers to get registered with the National Insurance Board. Madam President, as a result, to increase the likelihood of unregistered employers entering the system, I would recommend that the amnesty be extended for a period of 1 year until June 2023 to allow firms with constrained cash flow positions to make these payments in small increments. Further, looking at Clause 4 as well, and Senator Mark spoke at length about it, the Minister of Finance is given the power to extend the duration of the amnesty period. Madam President, I would highly recommend that this power for the Minister of Finance to extend the amnesty period be done upon the recommendation of the National Insurance Board, because it's not stated in the subclause. It should be stated clearly that this is being done upon the recommendation of the National Insurance Board. So, Madam President, as I begin to wrap up, I would like to say that in the interest of the long-term sustainability of the fund, which is the objective that this bill partially is setting out to achieve, policy making to deal with this ongoing issue cannot endure a further delay. The policy response to ongoing challenge of this NIB fund in the bill before us today may not necessarily reflect all of the parametric changes that are recommended by in the 10th actuarial review. However, so I would urge the government to quickly respond with carefully considered policies that strike a delicate balance between the sustainability of the National Insurance Fund and the social welfare of contributors and eventual beneficiaries of the fund. Because, Madam President, each of those recommendations, while they may improve the sustainability of the fund, such as freezing or reducing pension, increasing contribution rate, increasing retirement age, we have to take into consideration that they do have social repercussions on beneficiaries and contributors. And these repercussions must be carefully managed when we are considering these policy changes. With those few words, Madam President, I thank you.
Honourable Senators, at this stage, I will revert to item 8 on the order paper.
Urgent questions?
Senator Mark.
Yes, thank you, Madam President. Madam President, to the Minister of Public Utilities, given that approximately 200,000 WASA customers are at present without a potable water supply, can the Minister indicate what contingency measures have been put in place to address the needs of said customers?
Minister of Public Utilities.
Thank you very much, Madam President. Madam President, the heavy rainfall experienced throughout Trinidad and Tobago over the past 24 hours has negatively impacted the operations of WASA as flooded rivers have increased the turbidity of water in water treatment plants and river intakes, as well as clogging screens and reducing flows to pumps at these facilities. As a consequence, Madam President, several water treatment plants in North Trinidad, which is heavily dependent on surface water sources, have had production flows reduced or had to be temporarily shut down. WASA has advised that the following areas have been impacted: in Northeast, Cora, La Pastora, Mark David, Ukono; in Northwest, Rincon, Grand Kurukai, Pipiol Reservoir, Susconusco; in South, Trinity, Biche, Petrotrin, Guayaguayari; in Tobago, Hillsborough West, Highlands Road, Corland, and Richmond. Madam President, WASA has advised that as at 11 a.m. today, 15 out of the 28, or 54%, of water treatment facilities affected have returned to full operation. And that with the exception of Matura and Tampere, which are experiencing high turbidity, the operations at all other water treatment facilities are expected to be fully operational by 6 p.m. this afternoon. Matura and Tampere are expected to be restored overnight. The authority has further advised that it has dispatched teams to all facilities in order to restore service at the earliest opportunity, and that it has increased water trucking service to all affected areas in order to supplement the lack of supply to some customers. Madam President, I wish to commend the WASA workers, the management, and the board for their prompt action in this regard.
Senator Mark.
Madam President, can the Honourable Minister indicate the 46% that are still without water? The Minister has indicated that, is it by 6 p.m. this evening you expect a full resumption of water supply to the remaining 46%? Could you clear the air again on that matter?
Madam President, as I've said, at this point in time, at 11 a.m., 54% of the facilities that were down have been brought back into operation. The remaining percentages, or rather the remaining plants, most of which will become operational at 6 p.m. But with respect to the Matura area, the Toko area, the river levels continue to be high, the weather conditions are improving, and we expect those two plants in the Toko and Matura area to be brought back into operation by 12 midnight.
The Minister,
Senator
through you, Madam President, when the Minister said they have been fully operationalized or brought into full operation, 54%, can the Minister indicate whether the residents and or customers of WASA are now in possession, or are now in receipt, I should say, of a regular water supply, which would have been disrupted as a result of the matters identified earlier by the Honourable Minister?
Minister.
Thank you very much, Madam President. Madam President, let me take the opportunity to educate Senator Mark. When a plant is in operation, Madam President, I do apologize, it takes pressure to build before water is distributed to several areas. Depending on the location of a community, it may require at some point to shut off water from some areas in order to get the requisite pressure to build to communities on higher elevation. And therefore, when a plant comes back into operation, water is now distributed to the various communities served by that plant in accordance with the schedule provided by the Water and Sewerage Authority.
Next question, Senator Ma.
Thank you. Thank you, Madam President. To the Minister of Rural Development and Local Government. Yes, thank you. To the Minister of Rural Development and Local Government. In light of persistent rainfall in northeast Trinidad, resulting in the Matlot and Grand Riviere communities being disconnected from the rest of the country owing to flooding and landslips, can the minister indicate how is this situation being addressed?
Minister of Rural Development and Local Government.
Thank you, Madam President. Madam President, I thank the Senate through you for allowing us the indulgence of coming after question time. We were at the post-cabinet press conference. I thank Senator Mark for the question. Madam President, as you are well aware, we've been watching the weather system since Sunday, and we went into high activation levels. I'm pleased to say that as I stand before you now, all 10 landslips have been completely removed. The Ministry of Works and Transport, the Ministry of Rural Development, Local Government, and the Regional Corporation and volunteer contractors all went to work. We monitored the situation since yesterday, as at 9 o'clock last night, electricity and water were returned. 40 residents who were affected were removed, put to shelter areas. They are now back on site cleaning homes with the assistance of CPEP and the ministry in supervision. Rivers are being monitored, bridges and drains are being dealt with by the Ministry of Works and Transport. So there's an entire collaborative effort. But I'm extremely pleased that the plan of the government to spot assets nearby resulted in us being able to deal with what would normally take days to be done in a matter of hours. So I wish to thank especially the residents of the area for also turning up. God willing, many of the residents will be back home tonight.
Senator Ma.
Yeah. Can I ask through you, Madam President, to the Honourable Minister, whether any bridges would have been damaged or require urgent repairs as a result of the flooding that they experience, that is the people of Grand Riviere, during the last few hours? Can the minister indicate whether any bridges have been damaged and require urgent repair to reconnect the village of Grand Riviere
Minister.
to Togo?
Thank you, Madam President. Madam President, the Ministry of Works and Transport, they have a very efficient team that is on site. They are literally conducting assessments now. Whilst there were no obvious signs to the naked eye, and whilst all access has been reopened, I understand that the Ministry of Works and Transport is engaged in that very exercise of proper engineering surveys. May I add, Madam President, we are keeping a careful watch upon two weather systems that are forming as we speak right now, and that there is a real risk, even though the system is currently disorganized, it is on the meteorological map right now, and we are asking people to remember that with continued rainfall, there's continued risk. We remain in constant high priority mode, and we'll do the very best that we can.
Can I ask again, Madam President, through you to the Honourable Minister? Minister, can you tell the Senate or explain to us or give us some indication as to what kind of assistance that the 40 families would have required, and whether the government through its agencies have been able to provide same?
No. Senator Mark, that question does not arise. Okay?
Public Business, Government Business Bill, second reading.
Attorney General. Yes.
Madam President, thank you for allowing me the opportunity to speak on a bill being an act to amend the National Insurance Act, Chapter 32, Number 1, to provide for the waiver of penalties and interest, to increase the penalty for the provision of false information, to increase the statutory limitation for the commencement of summary proceedings and other related matters. Madam President, I subscribe to the view that it is always useful when one is undertaking a legislative exercise such as that which we are about today, speaking to the long title which I have just read, to have an appreciation of the history which has brought us here, because it is through that history that we will form an appreciation and have a proper understanding of the focus and purpose behind any legislation. And this amendment and its parent act is no exception. And in understanding the significance and relevance of the historical sequence of events which led to the enactment of the parent act, the National Insurance Act, Chapter 32, Number 1, which this amendment seeks to improve, I am of the view, respectfully and on behalf of the government, that it is appropriate to take some cognizance of that history. So we remind ourselves that as far back as 1958, a small unit of public servants were assembled by the Ministry of Finance and set up in 1966 under the direct supervision of the Parliamentary Secretary to undertake preparatory work for developing a comprehensive system of social security for Trinidad and Tobago. Two major developments resulted from the work of that unit, Madam President. Firstly, a division of pensions and national insurance was established in the ministry in 1968. Secondly, a white paper on social security for Trinidad and Tobago was prepared and circulated for public comment in September 1968. Following on this, a tripartite conference on social security was organized to examine in detail the contents of the white paper and comments associated therewith, as a result of which, at the conclusion of that conference, a new document was published incorporating the combined views of government, business, and labor. So it is relevant as we appreciate the history of the legislation which we are now seeking to amend for its improvement, to appreciate that the tripartite exercise of government, business, and labor is what has contributed towards providing the social security net which this government is committed to and always seeks to improve for the benefit of the citizens of this republic. The next stage in the development of the national insurance system, Madam President, related to the drafting of the relevant legislation. The first step required enactment of registration laws which put an obligation on employers to register themselves. And that is what we are about here today. We are about examining the prospects of increasing the breadth and scope of the registration of employers as permitted by this amendment. and to ensure the registration of workers in their employment. The intention being to provide a social security net for the benefit of the workers of this country who would be required to contribute through compulsory deductions from their insurance, as well as the employers, so that at the end of the day, the people of this country will benefit from the pool that is gathered and invested out of the savings derived from this social security net, the national insurance system. The next step, Madam President, involved the enactment of the principal legislation providing for the establishment of a national insurance system, deriving income, paying benefits from compulsory contributions paid by employers and employees. The principal instrument, that is to say Act number 35 of 1971, made provision for the management of the system, its mode of operations, the proclamation of appointed days for bringing the system into operation, and for the introduction of several benefits and other related matters. As today, we come once more before this House to seek to improve on that national legislative package. It is immediately and readily appreciated, Madam President, that the introduction of a system of such magnitude directly affected the lives of a substantial percentage of the citizens of Trinidad and Tobago. And not only was that legislation introduced legislatively, but it was preceded by a significant education system, education campaign, which took place over a period of almost 2 years and involved every member of staff of the government, relevant arms, seminars, lectures, discussions, and informal talks, all geared towards the inclusive involvement of the citizens of this country to appreciate and to value the national insurance scheme that was being brought into being. And law, Madam President, must be pragmatic as well as visionary. And against that historical reality of the legislation, what do the amendments now seek to do? They provide for a waiver of penalties and interest due under Section 39B on interest in respect of any contribution outstanding at June 30th, 2022 by an employer where the contribution is paid during July 1st to December 31st, 2022. The amendments provide an amnesty on penalties and interest on national insurance contributions for the period July to December, which will also allow errant employers to register with the National Insurance Board. This is not, Madam President, about giving a bly to persons who have failed to register. This is about allowing, by an enabling provision in the legislation that is being amended, allowing registration of employers who have not previously registered under the National Insurance Scheme. And what is the benefit that is derived from that? The benefit that is derived from that, the entire package is estimated to earn $161 million for the National Insurance Board in the very first year, and a further $792 million over the next 10 years. The Minister of Finance, in his earlier contributions in the other place, has spoken to that. And today, Senator Deonarine, Independent Senator Deonarine, spoke of that again. We can't lose sight of that substantial benefit, because at the end of the day, what is happening is that the government is passing legislation asking this House to endorse its intention and its efforts to pass legislation to broaden the base, the monetary and financial base of the National Insurance Scheme to benefit the citizens of this country. Not to forgive persons, but to broaden the base, because those employers who are not currently registered, who take advantage of the amnesty that is going to be provided under this legislation when we pass it, will become registrants under the system and able to be regulated into the future by the National Insurance Legislative Scheme, whilst bringing into the treasury of the National Insurance Board the sums of money in the immediate short term. That is a substantial benefit that is going to endure for the people of this country. And it is not a benefit that doesn't come without a burden. So again, it is not forgiving persons for not having previously been registered. What this government is asking this August House to do is to pass amendment legislation to increase the penalties for the provision of false information by Section 63(1), which is currently $2,000 and imprisonment of 6 months, to an increase of $50,000 and imprisonment for 3 years. Similarly, an increase in the statutory limitation for the commencement of summary proceedings within 12 months from the date of the commission of the offence to a period of 3 years. So these are incremental steps that are being taken in the interest of addressing proportionality in the legislative scheme that the government brings to this House, in the public interest of providing benefits to the population of this country, and with the requirement of careful balancing of the interests, which is the hallmark of democratic governance. Additionally, improvements to be effected will strengthen the provisions of the substantive legislation to ensure effective enforcement of the Act, thereby ensuring that the NIB is better able to pursue those who submit false information, documents, or statements. And this would allow for accountability and the robust and comprehensive management of the National Insurance Board by internal processes and the procedures adopted. And then there is the provision that allows the minister to make an order, Madam President, to exercise the making of an order in light of the benefits aforementioned, which enables the efficient and effective operation of the NIB in furtherance of its functionality and the improvement of our national insurance system. In reading, as I tend to do, around the subject, I had the privilege, and I will end on that note, Madam President, I had the privilege to look at the 2020 annual report of the National Insurance Board of this country, which is now chaired by former independent Senator Mrs. Helen Drayton. And it is instructive, one of the highlights that has been provided by Madam President in that, by Madam Chairman, former Senator Drayton, in that statement in her opening remarks. She spoke to the resilience of the National Insurance Board in the face of the pandemic. And she says our response was guided primarily by the core values of resilience and resourcefulness. The strategic plan 2020 to 2024 was reviewed and reworked, taking into consideration the new constraints and threats posed by the pandemic. To this end, in August 2021, we concluded the revision of the plan, which features 5 major strategic themes, namely governance and legal, empowered, engaged, and enabled workforce, customer experience, compliance and collections, and leveraging technology. Madam President, it is my privilege and my pleasure to commend this legislation to this House and wholeheartedly to embrace it on behalf of the government. Thank you very much.
Senator John.
Yes, thank you very much, Madam President, for this opportunity to join the debate. And as Senator Mark would have stated, the NIB, National Insurance Board, is a unique organization led by a tripartite board comprising government, business, and labor. Madam President, this organization serves the working class of our country, and the minister in the Ministry of Finance called it the linchpin of the social safety net. Madam President, in looking at the 6 clauses before us, which represents the amendments, one cannot see how this helps the National Insurance Board to solve the problems they have been flagging to their reporting ministry and to the population as a whole. The NIBTT has an urgent problem, one which they refer to as fund unsustainability, meaning, Madam President, if the status quo is maintained, if no reform of the system is undertaken, the revenue of the NIBTT will eventually not be sufficient to cover the expenditure, meaning the benefits and the administration of the system. Madam President, accordingly, in the NIB 10th actuarial review, they said it is projected that by year 2024, well, they say between 2 to 4 years, there's a growing shortfall, which is currently being supplemented by investment income. And in the next 2 to 4 years, the assets may very well have to be liquidated to ensure that the benefits can continue to be paid, Madam President, to these folks who are working class. And Madam President, yes, I'm making a point here. So in addition to the Fund on Sustainability by 2024, the assets of the NIB are projected to be exhausted also, and the actual review is saying by 2036. So consequently, unless there's a change and the amendment before us, Madam President, does not signal that there's an intervention to impact upon the impending crisis. Because, Madam President, Clause 3 of the amended bill will read in its entirety, that's 39B in the Parent Bill, or Parent Act, where any employer fails to pay the amount of contributions payable by him to the board under the provisions of this Act by the 15th day after the due date, he shall be liable to pay, and that is what is now existing. So the NIB, as they are now, they are compelled, one, to demand a penalty of 25% of the outstanding sum, be a penalty of 100% of the outstanding sum, where the period for which the contributions were retained is in excess of 5 years, and see interest on the entire sum, penalty and on the outstanding sum at the rate of 15%. And as Senator Mark would have indicated, this now is being waived, and by by the minister, because 39B2, the new clause, the new insert, is that the minister may by order provide for the waiver of penalties or interest due and payable under this section. Madam President, I cannot see how these amendments before us helps the NIB with respect to their fund on sustainability. If it is the minister is given this power to, in an open-ended, unexplained power to waive penalties and interest for businesses. Now, what has been stated by the minister in the Ministry of Finance is that this is to help the vulnerable companies, or to give them a break. And if that is so, maybe that is a good thing, but we don't know, because the minister did not present to the Parliament a list of the potential companies, because it will be before the NIB's database, the companies which are now delinquent. And I think that would have helped the cause, and one will not have been suspicious about this carte blanche waiver, Madam President. Currently, the NIB had a list as at 31st January 2022. That could have changed by now, and perhaps the Honourable Minister in his winding up will indicate, because there were, is it that, I want to ask a question first, that this waiver will be attributable to government organizations also, meaning not state companies perhaps, but government departments, government ministries, because as at 31st January 2022, there were 113 public entities who had outstanding contributions due. Well, not only contributions, penalties, and interest owing to the NIB. And this is as at 31st January 2022. And totaled a sum of $267,229,529.08 cents. Madam President, this is, as I said before, contributions, penalties, and interest owed by government agencies, government departments. And one wonders if the number of employees who will be affected if these departments are not paying their contribution to the NIB. Is it that when these the workers present their requests for whether it's funeral benefits or maternity benefits or retirement benefits, what happens to them in a case like this? Because we're talking about in excess of $250 million. So, Madam President, as much as businesses must honor their statutory commitments to the NIB, part of the solution is not only by, okay, you're going to give a waiver, but what the NIB would have said in one of their own review, the last review of their business model, I think they call the report on operational and financial, their financial operations for the year. The last one I would have seen was the 30th of June 2020. I don't know if there's one that is more updated, but they reference the fallout from COVID, and the businesses that would have shut down, because when businesses are not paying contributions, then of course that impacts the NIB. So therefore, there's a role for the government in this in terms of expanding the economy, ensuring that people feel confident in expanding their own businesses so that they can grow their businesses, and which will reflect in more contributions to the NIB. And of course, that is not here before us now in terms of some of the ideas and the suggestions or the recommendations from the actuarial review, and these are not here, and they should have been before the Parliament, maybe 7 years ago, 5 years ago, even 2 years ago, and even today. What is coming is this waiver in terms of the NIB giving up money again in this scheme where the minister has sole jurisdiction and authority. So, Madam President, the gap between the NIB's revenue and expenditure is projected to be about $6 billion in 2036. And one will want to know, how will this bailout, or whatever the ministry wants to call it, how will this help in this gap that is approaching, that they know it's projected? And again, nothing is being done because, this NIB really is, the people, the working class, really depend on this social safety net. I've heard people, when someone dies in the family, talking about going to the NIB for the funeral grant or the funeral benefits. And this is paid, it appears, very promptly to them, and it helps, it mitigates against the worry that the family will have at that time. Sometimes workers, employees who have become pregnant and they have the baby, the company does not pay maternity benefit, but the NIB does that, and again, does it, it appears, promptly, and people really depend on these benefits. So basically, this is not something that we can take lightly, that if there's a gap and the NIB is signaling that whatever it is that will be recovered during this period of waiver, that it is enough to close that gap. So Madam President, the three main recommendations within the 10th actual review, I think there's an 11th one, was the NIB would have put before the ministry. And what I've been reading subsequently is that up till now, they have not heard anything from the ministry, and perhaps the good minister in the ministry will be able to tell the Parliament if it is that they have flagged these recommendations and that they are working on them, and they've put them on the front burner, because we can ill afford to be without the benefit of the NIB, as it were. Madam President, what has been suggested for the Section 39C, Clause 39C of the bill, again, this is this has to do with the period of the waiver, but notwithstanding that, I think it goes further, where 39C is now saying that notwithstanding this waiver between July 21st July 2022 to December 31st December 2022, that where an employer fails to pay his outstanding contribution by the 31st December 2022, and I'm just moving ahead, summarizing, in Section 5 of that clause, Madam President, the minister may by order prescribe a later date. Again, this kind of open, very expansive powers to the minister, that he could decide, even after this period of waiver, that into perpetuity, that basically employers can continue to enjoy this waiver. And one wants to know, why is this necessary? If it is the NIB is flagging that they are trending in the wrong direction, and it's not because they are not trying based on their records, Madam President, because NIB has, and I think the question was asked here earlier, NIB as of December 31st, 2021, and of course we are now in mid-2022, but they had 1,029 files with debts totaling 73.34 million, which they had forwarded to major debt collection. In December of last year, notices of intended legal action were sent to 381 employers in respect of 43.61 million in indebtedness, while 240 matters valued at 26.61 million were submitted for referral to the legal services. So they are working. What maybe the ministry needs to do is to strengthen the NIB's ability to collect in terms of their collection, and not to give away, because they could ill afford, Madam President, this giveaway at this time. What is needed, what the NIB is calling for in their documentation, is institutional strengthening to ensure that they can audit on a timely basis and follow up, not only audit because they've been audited, but follow up on these audits and assist businesses with resolutions to pay. Because, of course, we understand that businesses will fall on hard times. And during that period of COVID, some of them would have been, some made supernormal profits, but some would have been very challenged. And but the answer is not to give the minister power to waive without any oversight, because this cannot be viable. This is not what the NIB had asked for. There's nowhere in their documentation that they asked the Minister of Finance to waive these what is due to them in terms of their fees or their contributions, and of course by now the penalties and the interest, Madam President. So again, in the NIB Corporate Strategy 2020 to 2024, they have said the major challenges will fund sustainability, employers' compliance in terms of getting employers to comply. They are looking at their internal processes. So basically, this form, as far as the knowledgeable people who run NIB, they are saying this is what is ailing us. This is what we need your supporting. But it appears as if this is all sitting on the minister's desk, and they cannot care less about that. They also need legislative amendments to the law. They've called for that too. They did not say they want there to be amendments, which only has to do with waivers, Madam President, Mr. Vice President. They said the NIB has said they continue to engage their stakeholders and to conduct the employers' audits. But of course, that is one of the measures implemented to secure increased contribution. What they need is increased contributions, not less, by way of these waivers. Because what the waivers will do is just give them less. And on top of that, even when the period of the waiver, that 6 months, would have expired, the minister has this authority now, which will be given to him, I suppose, by the Parliament, to go on in forever, it seems, in terms of allowing this employer to not honor his commitment. And one really wants to know what happens to the employee should they need to call upon those benefits at the point in time whilst the employee is trying to sort themselves out. Mr. Vice President, the last two sections of, I think it's 63.1, sorry, am I correct? Yes, 63.1, which would have changed, and the speakers preceding me would have spoken about this, the enhanced period of time in terms of the punishment, which will be attributable to someone who is found in contravention of the policies of the NIB, whether it moves from $2,000 now to I think $50,000, and from 6 months to a jail term of 6 months to 3 years. Now, you first have to catch people and really get them to the court through the system, etc. So this, I don't know how that will help and whether that will be a deterrent in any way, and how that helps the NIB in closing that gap and ensuring that they have fund sustainability, Mr. Vice President. So consequently, Mr. Vice President, unless there's a change, the eventual inability of the NIB TT to cover its benefit and administrative expenditure and the resulting social and economic impact to the country without any significant fiscal bailout, because that is not before us and the time is still running. They have indicated that the gap between revenue and expenditure is projected to be to be more than or just about $6 billion by 2036. So they have their recommendations, which have been outlined in the pension reform, in the 10th actual review. And again, I reiterate, the three main recommendations were an increase in the contribution rate, the introduction of early retirement factors, and of course, for persons retiring before age 65, and the freezing of pensions payment. But, I mean, one is not arguing whether this is right or wrong, but certainly it has not been brought before the Parliament, and basically it seems as if it is not attracting the attention, the urgent attention of the Minister of Finance at this time. And Mr. Vice President, I think this is where the Ministry of Finance need to be attributing their time and energy to ensure that that gap can be closed and that the NIB can remain viable in the interests of the working class. Mr. Vice President, I thank you for this opportunity.
Senator Charrise Seepersad.
Mr. Vice President, thank you for the opportunity to contribute to the debate on the National Insurance Amendment Bill 2022. The bill seeks to amend the National Insurance Act, Chapter 3201, to 1. Provide for the waiver of penalties and interest on outstanding national insurance contributions as of June 30th, 2022, clauses 3 and 4. 2. Increase the penalty for the provision of false information, clause 5. And 3. Increase the statutory limitation for the commencement of summary proceedings, clause 6. Mr. Vice President, clauses 3 and 4 of the bill provides for the waiver of penalties and interest on NIS contributions due as of June 30th, 2022. These outstanding contributions must be paid between July 1 and December 31st, 2022. Further, the amnesty applies to existing employers and those employers registering between July 1st and December 31st, 2022. These amendments do not waive penalties and interest on contributions due between July 1st and December 31st, 2022. Mr. Vice President, the objective of the amnesty proposed in this bill is to balance the need to increase the collection of outstanding NIS contribution and increase the number of registered employers and the imposition of severe penalties and interest for non-compliance. This is a business decision to deal with the serious underfunding of the National Insurance Fund. Further, the employer will benefit because they become compliant, and the employee will benefit because they are now entitled to all the benefits offered by the National Insurance Board, including pensions. The National Insurance Act, Chapter 3201, defines employer as a person who employs at least one person under a contract of service or to whom another person is apprenticed. An employed person means a paid apprentice, a self-employed person, or anyone who is employed under a contract of service. These definitions are relevant, especially during the 2 years of COVID-19, 2020 and 2021, when businesses were forced to operate below capacity or not at all. During this period, revenue inflows were reduced to a trickle, and many employees were furloughed or terminated. Further, several small businesses would have shut their doors permanently. Contribution year means the period of 52 weeks or 53 weeks, beginning with the first Monday in July in any year and ending on the Sunday immediately before the first Monday in July of the succeeding year.
Mr. Vice President, I am of the view the amnesty should waive penalties and interest on all national insurance contribution payments due up to July 2023, and the amnesty should be effective from July 2022 to July 2023. Therefore, the amnesty will include the 2 years when business operations were negligible, 2020 and 2021, and 2 years, 2022 and 2023, a period of business recovery. Also, Mr. Vice President, any further extensions of the amnesty, as proposed by Clause 4, should be done in consultation with the National Insurance Board. Clauses 5 and 6 of the bill provides for the strengthening of the enforcement provisions against those persons and employers making false statements or misrepresenting information to the National Insurance Board. The fine is $50,000 and 3 years imprisonment on summary conviction. Mr. Vice President, it goes without saying that the increased penalties alone will not achieve the desired result without vigilance by the National Insurance Board. The track record of convictions in the past is not encouraging. Like Senator Vieira, I'm interested to hear what the Honourable Minister of Finance has to say on this matter in his winding up of the debate. The National Insurance Board is expected to be extremely vigilant to determine, identify, and deal with unscrupulous employers and employees who try to commit fraud in the registration process. During the amnesty, the National Insurance Board should also continue its auditing exercise and pursuit of the collection of contribution arrears from employers. The National Insurance Board also has a database of all the people who claimed unemployment relief benefits as part of the COVID-19 unemployment relief benefits. That data can be used to find people who should have been paying NIS contributions but were not. Mr. Vice President, again, the key question here is the ability of employers to pay. The last NIB amnesty in 2012 resulted in the collection of $36.8 million in outstanding contribution and the registration of 2,310 employers. In 2017, the National Insurance Board estimated that 84% of employers were registered and contribution income of $906 million was lost because of unregistered employers. Given the reduced business activity in the past 2 years, it is reasonable to expect that this proposed NIB amnesty will not yield the same results. Therefore, it's conservatively estimated that $161 million will be collected during the amnesty and $792 million will be collected over the next 10 years. Mr. Vice President, the growing problem of declining contributions and increased pension payments from public pension funds is a problem that exists all over the world, not only in Trinidad and Tobago. This issue needs critical attention, and while the Honourable Minister of Finance is attempting to enforce timely payments and the provision of accurate information through this bill, more needs to be done. For example, the 10th NIB actuarial review projected that by 2066, Trinidad and Tobago's 60-plus population will be almost double its current size, while the number of people in the 16 to 59 age group will decrease by at least 25%. The review estimated that the ratio of contributors to pensioners will decrease from 4 to 1.6 over the projection period. This means that the current problem will only get worse if the necessary adjustments are not implemented. The problem of the aging population and declining contribution base is compounded significantly by the pension subsidy. When the minimum pension of $1,000 was implemented in 2003 and subsequently increased to $2,000 and then $3,000 without a sustainable source of funding, the National Insurance Fund subsidized this minimum pension. The average calculated pension is approximately $1,600 per month per pensioner, and the fund adds approximately $1,400 per month per pensioner. Approximately $20 billion has already been paid out in subsidies. Mr. Vice President, the proposed amnesty is a temporary fix. From 2013 to date, investment income required to cover annual expenditures and the gap between contribution income and benefit expenditure has grown each year. This is estimated to be $6 billion by 2036. Mr. Vice President, given these real problems, I have 4 recommendations. 1, the retirement age. The NIS retirement age is 65 years, but an employee has the option to retire at 60 years and receive a monthly pension of $3,000. Consideration should be given to formalizing the retirement age at 65 years and a prorated pension be paid for each year a retirement benefit is claimed between 60 and 64 years. Many countries are changing their retirement rules by increasing the retirement age. Some examples are the United Kingdom and Barbados, 67 years, St. Lucia, Antigua and Barbuda, 65 years. 2, minimum number of contributions. The minimum number of contributions required to be paid to receive a full pension is 750. Mr. Vice President, this equates to 14.42 years. This should be reviewed to determine if this is a realistic threshold. 3, domicile. People who have migrated and already made their mandatory 750 contributions contribute nothing further to the fund but are due a full pension. Consideration should be given to imposing a domicile rule similar to what applies to the government pensions. 4, widen the net of working persons who contribute to the National Insurance Fund, whether through formal, informal, self-employed, or cottage industries. While the proposed amendments waive the penalties to achieve the objectives of collecting NIS contributions and enforcing the provisions of accurate information by both employers and employees, due consideration must also be given to the period of business inactivity and the ability of employers to pay. The current economic situation also weighs heavily on business performance, as the Honourable Minister of Finance is aware. Some logic, leniency, and reasonableness therefore must be brought to bear in enforcing the amendment to waive penalties and interest for NIS payments. Mr. Vice President, I thank you.
Minister of Public Administration.
Thank you, Mr. Vice President, for the opportunity to contribute to this debate. Mr. Vice President, in the executive summary, last paragraph of the executive summary of the Roadmap to Recovery Report number 1, the report stated as follows: the strategy required for rebooting the economy and the wider society require partnership among the government, private sector, labor, and civil society, agility in the support institutions, and a culture that fosters productivity, efficiency, performance, and harmony. And why am I referring to that quote, Mr. Vice President? We will remember that in every budget and media presentation since the onset of the pandemic, the government has acknowledged the significant impact that the pandemic has had and continues to have on the economy as a whole and on the financial well-being of our individual and corporate citizens. While this is not unique to Trinidad and Tobago, and in fact is impacting all countries around the world, exacerbated as it is by the fallout from the war in Ukraine, We in Trinidad and Tobago continue to do what we can to alleviate the negative economic impact on the citizens of our country within the limits of our means. We will recall, Mr. Vice President, that the government was obliged to take several measures in an attempt to mitigate the impact of the pandemic on our citizens. Our driving focus being on saving lives and livelihoods. The most significant of those measures, Mr. Vice President, were the lockdowns of the economy and of social activity, other than those activities conducted by what were defined as essential services. All businesses other than those essential services were required to close their doors and cease activity. At the same time, Mr. Vice President, very importantly, the government encouraged employers in those sectors, to the extent that they were able to keep their employees on the payroll. So we were saying to people, please close your doors, please cease all economic activity, but if and to the extent that you can, please continue to pay at least something to your employees. A very big ask. We sought to support these employees, but these employers in this endeavor by providing them with support either directly or through their financial institutions, by encouraging and supporting credit card and loan moratoriums, soft loans, interest moratoriums, and/or interest reductions. These measures allow the vast majority of businesses to weather the storm while we navigated our way out of the worst of the pandemic. Many businesses, thankfully, heeded our call to retain their employees on the payroll and continue to pay them at least a percentage of their salaries so they could keep body and soul together and continue to feed their families. And God stepped into any gaps left by those businesses through its several relief programs, most especially the Salary Relief Grant Program and the Income Support Grant Program run respectively by the Ministry of Finance and the Ministry of Social Development. But, Mr. Vice President, we were obliged to acknowledge that while employers quite laudably did what they could to keep employees on their payroll, they were bearing the burden of paying salaries in circumstances where they were earning little or no income. This applied even to those businesses that continue to operate as essential services. In this context, it could come as no surprise to us or to anyone that in seeking to manage their significantly depleted resources, that many of those businesses paid their employees but deferred settlement of the related PAYE and NIS obligations arising from those salary and wage payments. However, the law on these matters is clear. Once a payment of salary or wage is made, an employer is required to remit to the Inland Revenue on the one hand and to the NIB on the other the relevant PAYE and NIS due from both the employer and the employee in respect of those salary and wage payments. Failure to remit those payments within the statutory timeline results in the imposition of a penalty of 25% of the tax due in the first instance in respect of NIS, and interest of 15% on both the tax and the NIS, both the tax /NIS and the penalty. So this is a heavy burden on employers in normal circumstances. Imagine how difficult it would be for them in circumstances where they are carrying employees who are not in fact working. While we introduced the amnesty in mid-2021 to provide relief to those employers in respect of any taxes, including PAYE, that would have accrued during the lockdowns and previously, no such relief was provided in respect of NIS contributions. We are seeking to address that today. We are seeking to do that by repealing the existing Section 39C of the National Insurance Act and replacing it with a new Section 39C to waive penalties and interest due on outstanding national insurance contributions, provided they are settled by December 31st, 2022. This will allow those employers who adopted the responsible and patriotic position of retaining their staff on payroll during the lockdowns while the employers themselves were not earning income and were therefore out of pocket. We applaud those employers, Mr. Vice President, who adopted that approach and allowed their employees to continue to support their families during those difficult periods. And this bill seeks to provide them with some relief by relieving them of the burden of the penalties and interest that would otherwise be due on outstanding NIS contributions. But it goes further than that. It seeks to provide relief also for delinquent employers who, outside of that lockdown period of worldwide strife, have failed for whatever reason to comply with their national insurance obligations. So this bill gives us the opportunity to do several things. It gives the opportunity for persons who have not registered and complied with NIS to do so and regularize their position. It gives the opportunity for persons who are registered but have outstanding obligations to regularize that position. Hopefully, it will fill some of the contribution gap that the NIB has been complaining about for quite some time and has not been able to adequately address and bring up to current. Hopefully, also, it will bring on board employers and employees who will then be guaranteed, the latter, who will then be guaranteed an NIS pension and reduce the chance of those employees being a burden on the social security system, which is already straining under the weight of its senior citizens pensions program. And finally, it will allow us to more accurately gauge the obligations that need to be met by the NIS system as we seek to address the deficit that exists in funding and plan for retirement obligations going forward. I have sought to get an idea of what our current circumstances in NIB versus Board of Inland Revenue look like, because we will acknowledge the fact that both the NIB and the Board of Inland Revenue collect contributions in respect of salaries. So, since that is the case, they should, at least in theory, be able to match their records in terms of how many employees and how many employers I have in my system, and there should be some relationship between the two. So what do the actual statistics show? In respect of the NIB had 20,714 employees employers on its system in 2019, 20,274 in 2020, and at the end of 2021, its employer register had dropped to 19,281. So it is obvious that during the lockdown, there was a fall off in employers registered with the NIB. How many employees do they have on the system? In 2019, the number of employees registered with the NIB, 420,000. In 2020, 404,000. And in 2022, interestingly, an increase to 446,000. How does that compare with the Board of Inland Revenue figures? Whereas the NIB has, at the end of 2029, 19,281 registered employers. The NIB, the Board of Inland Revenue's estimate of its number of employers is more in the region of 30 to 35,000. A huge discrepancy, and having regard to the fact that under the Board of Inland Revenue system, the persons earning less than $7,000 a month are not required to pay tax at all. One would expect more employees to be on the Inland Revenue system than on the more employers to be on the NIS system than on the NIB system, and that is not the case. When one compares the number of employees registered under the IRD, it is closer, 450,000 under NIB versus 446,000 under the 450 under Board of Inland Revenue versus 446,000 under the NIB. So there are obviously some discrepancies, and obviously there is room for ensuring that everybody who's required to be registered is registered, and everybody who is required to contribute is contributing. It is my view that this amnesty will allow us the opportunity to have employers who are off of the system regularize their position, increase the number of registered employers and employees, which can only work for the benefit of employees. It is not, contrary to the comments made by Senator Mark, something to benefit employers at the expense of employees, not at all. The more employers we have registered is the more contributions they make on behalf of their employees, which will then allow those employees to receive the benefits due to them. So, as I indicated, there are some discrepancies in the system, and my vision is that as both organizations gather information from their amnesties, Inland Revenue would have had theirs a year ago, NIB, we're proposing to have one now, as they also gather information that arose out of the relief programs that the government would have introduced during the lockdown, as we paid out the salary relief grant, as we paid out the income support grants, the government would have gathered information from the applications and can use this information, the combined information, to put us in a better position going forward to ensure better compliance and enforcement. So the NIB has an enforcement and audit requirement, as does the Board of Inland Revenue. And in my view, having worked with both entities in different capacities, they have different strengths, and they can benefit from supporting each other. There are synergies which can be explored, and I'm hoping with the full rollout of the TTRA and the increase in expertise that those synergies can be further explored to better provide for the funding of the NIB, which is where the real focus is this afternoon, to allow us to address all the other issues that were raised by senators today about the longevity and sustainability of the NIB fund, which we understand is under challenge. And let me just make it clear that this bit of legislation that we're seeking to pass this afternoon is by no means the Ministry of Finance's response to that problem. It really has to do with providing relief to employers who have been having a difficult time on the one hand, and to provide an incentive to those employers who have in the past ignored their NIS obligations to come on board. We clearly understand that there's a challenge with respect to the NIB funding, and that is being addressed, but don't take this bit of legislation as our response to that issue. So let me address the specific comments made by a couple of our earlier contributors. Senator Mark, in his usual gaslighting fashion, made a couple of outrageous comments. the Minister of Finance is being given the ability to waive penalty and interest and to benefit employers at the expense of employees, and that's not correct, and that's too much power. The provision in the legislation, which is in Clause 6 of the bill, clearly gives the Minister of Finance only the authority to extend the amnesty period. This is not new. It has been given in the past, and one can look at the circumstances in which the power was given and how it was exercised. So the last couple of amnesties, the legislation included a power for the Minister of Finance to extend. The Minister of Finance monitored how the amnesty was proceeding. He would look out his window and see lines curled around the Board of Inland Revenue on the last day because Trinidadians and Tobagonians like to wait until the last minute to act. And he would call the Board of Inland Revenue at the time and say, how is the amnesty going? Have you had any challenges? Yes, Minister, we have tons of people who want to pay and have been able to. And in those circumstances, he would extend the amnesty by 2 weeks, not 2 years. So the apparent hysteria which we are trying to cause here is so unwarranted, I cannot understand it. It is something that has been given, it has been tried, it has been tested, it has been properly used, and so all we are seeking to do is repeat that extension of power to the minister to exercise it in those limited circumstances. As Senator Mark said again, it's pro-employer and anti-worker. A worker, for example, is not entitled to an NIS pension unless he can satisfy the NIS that he has made 750 contributions to the 750 NIS contributions to his account. If he cannot establish that, he has difficulty getting his pension. And so if we get those employers on board and have them contribute, then the employee is guaranteed or more guaranteed to get his pension without difficulty, as well as his other benefits. So I don't see how regularizing the positions of employers who are the ones responsible for remitting contributions to the board on the employee's behalf is pro-employer and anti-employee. That makes absolutely no sense. Senator Deonarine mentioned that this is a temporary measure and it can't solve the problem. And as I indicated, this is not the attempt to solve the problem. We understand there's a problem and that is being addressed. Senator John indicated that the waiver will give the NIB less. In that context, I would like to remind Senator John that in the tax amnesty before the last, the Minister of Finance estimated recovery of $500,000. We actually collected $2.3 billion. And that indicates that there is money out there that is due to the government of, when I say the government, either the Treasury or the NIB, of which the administrators are not even aware. So giving the amnesty allows the opportunity for the people owing this money to voluntarily come forward and hopefully increase the collections of the administrator so that they can better perform their duties. In those circumstances, I cannot see what the objection to this program is. The group of employers of whom I am most supportive in respect of giving this relief, as I indicated before, are those employers who heeded the government's call to continue to pay their employees during the lockdown while they were earning no income. I applaud those employers without reservation, and I am sure that this measure is something that is more than due to them for the contribution that they made in helping us to fight the pandemic and to support the employees during that period. With respect to the others, this, as I indicated, will allow us to bring at least some of them on board and recover money that we are not now recovering to contribute to the NIB's fund. It works in everybody's favor. It certainly works to the benefit of the workers, and it is something that I fully endorse. Mr. Vice President, I thank you.
Senator Lyder.
Thank you, Mr. Vice President. And Mr. Vice President, I thank you for the opportunity to contribute to this bill, the National Insurance Amendment Bill 2022. And I appreciate this chance to make a very small contribution, having come so low in the batting lineup. I want to, and having this bill so narrow in its nature, I will attempt, Mr. Vice President, to keep it within that narrowness and will have some very pertinent questions to ask the government on this side, on the other side. And Mr. Vice President, at first glance of this bill, and as a businessman, I can understand why business people will welcome an amnesty. I can understand that. Not that I would need to avail myself of one, of course. But I welcome an amnesty because there are people who at one point in time may be going through challenges in their businesses. But let me also say to you, Mr. Vice President, that I agree with Senator Mark, that I don't support an amnesty for those companies that have been acting wrongly and illegally and being delinquent in paying their contributions to the INS for their workers, are now being given a bly through this bill. But there are other companies, Mr. Vice President, that may be barely getting by, as many have been struggling under this PNM for the last 7 years of government. Not during the pandemic, Mr. Vice President. In this last 7 years, we have seen companies struggle. There's no doubt that many of these companies will welcome this amendment and this waiver and amnesty today. And that is, of course, Mr. Vice President, if they are in a position to take advantage of it at all. Because even with this amnesty, many will not be able to participate. And I will expand on this a bit later in my presentation. But for the benefit, Mr. Vice President, of these struggling, near to bankrupt companies that really want to pay, really would like to pay, I support Senator Mark's recommendation that this bill should stop today, should go to a joint select committee or a special Senate select committee so that we can separate those who've been acting illegally, intentionally holding back monies from workers, and those who truly suffer from the PNM pandemic of the last 7 years. So that is what I believe. And then, Mr. Vice President, I can support what the acting Prime Minister and Minister of Finance in the other place, and now the Minister of State in the Ministry of Finance, who is piloting this bill here today, then I could support this bill. And Mr. Vice President, just for clarity, I don't want to be in breach of any standing orders. Am I still correct in assuming that I can still refer to the Minister of Finance as the acting Prime Minister? I can still refer? Yes, okay. Thank you. So I assume the Prime Minister is still away. All right. Well, we wish him a speedy return to the country. Hope all is well in foreign on all accounts, and that he will return quickly because the country is banking on him to return.
Senator,
46-1, please.
Yes.
53-1
Yes.
of relevance.
Oh, okay. No,
You
I just
promise to stick to the narrow part of the debate, and I hope you stick to it.
Yes. Thank you, Mr. Vice President. I will do. I just was wishing all the best. I want to encourage, Mr. Vice President, delinquent employees to come up to date and make right on their obligations to the National Insurance Board. But I will point to some of the challenges to the government in this occurring. You see, Mr. Vice President, when I look at Clause 4, I see that the beneficiaries of any national insurance payout will be the employees and the retirees who need their insurance payment to be made in whole. The challenges with this government is a lack of implementation of anything that they bring. Therefore, despite companies being given an amnesty on fees and on interest charges, the big question that arises is whether or not these employers will be tasked by the state to meet their payments during this waiver. You see, Mr. Vice President, some really good questions came here today. I heard Senator Vieira ask some pertinent questions earlier. He asked how many people have been charged under Section 63. Senator Vieira asked how many cases have been brought forward by the NIB. And he stated if we don't enforce, it makes no sense. I agree. I agree with that. Minister West, in her contribution, stated that she rambled a lot of statistics, numbers, discrepancies in the system. But there's still very pertinent questions that have not been answered here today, or that have not been presented by Minister Manning here today. Because I have some questions I'd like to ask for the record. What is the quantum of funds owed to the National Insurance Board by these employers? We heard Minister Manning come with an estimate of over 4,000 who they think is non-compliant. So they estimate 4,000 non-compliant. But I am asking, if you know 4,000, you're estimating that 4,000 is non-compliant, how do you not know how much is being owed to the state right now? How is that not being presented here in numbers? Another question I have is what percentage of these funds owed by employers and companies that are now defunct, that are also operating as a going concern right now? In other words, what is the probability of recovering the funds owed? Has anybody done that assessment before we come with this amnesty? An employer could have died without settling outstanding balances, or companies have shut down. I also would want to know, has any research been done to see whether there are a minority of employers that will be responsible for a majority of the funds being owed by NIB? And has the state obtained confirmation that they will be able to be repaid? And how much of these funds are owed by state enterprises, Mr. Vice President? I'm not going to go at length at that. But I want to know. It's not being presented here. And are there employers with the willingness, but not an ability to settle their outstanding balances in cash during this period? Will these employers be offered any credit facility in the way of those offered to companies via banks, as has been done in the pandemic, relating to loan facilities, to companies for working capital support? I heard Mr. West speak about all that the government, boasted about all that the government did during the pandemic to assist with special loans, etc. Has anything changed now, after the pandemic? Have all these companies have mysteriously fallen into a boom? They're still struggling through this PNM pandemic, Mr. Vice President. So we come to bring a waiver, but there's no support by the government to assist to take advantage of this waiver. These are the questions that are of most importance in my mind when I contemplate the challenges to the success of this NIB waiver. Because I have to ask myself the question, is this the case of too little too late for many? Lest we forget, it was reported by various chambers of commerce, Mr. Vice President, that over 6,000 companies shut their doors in August as a result of this pandemic and the lockdown measures. I'm hearing 4,000 haven't complied, but we're hearing 6,000 companies have been shut down. How many of those 6,000 companies have not contributed? Do we know? These 6,000 companies that locked down, small and micro enterprise businesses, and I heard another Senator Deonarine speak about the small and micro businesses, all who have struggled and suffered. During these lockdown measures that were foisted upon businesses in an ad hoc manner and without following any science. This signifies this government's absolute and now proven and measured failure with regards to management of the COVID-19 pandemic. But we're not debating that today, so I will just move on. But the failures pronounced especially on these businesses that are required to contribute to national insurance, hopefully to come up to scratch now during this period of waiver. So it would be remiss of me to not point out that many of these companies have not since reopened, Mr. Vice President. Many haven't. And the Honorable Minister of State in the Ministry of Finance, in piloting this bill in the Senate here today, stated that there's a shrinking workforce. Well, I'm absolutely glad that he's confirmed that. Why is there a shrinking workforce? Companies are shutting down under this government, Mr. Vice President. So I agree with him. The jobless rate has skyrocketed under this government. The last report was over 112,000 up to 2020, based on the National Insurance Board statistics. 112,000 lost their jobs. And this is relevant to the bill because I heard Minister Manning speak to the gap in contribution and benefits. The biggest contributor to the widening gap is the collapse of the labor force and the resulting decline in contributions in income.
Mr. Vice President, 46.6, please. We have a shrinking workforce due to the fact that people are having less children, not for the reason that you are stating.
Senator Lyder, kindly guide your discussions accordingly and move on.
But I'm saying there's a shrinking workforce according to the NIB. Yes, you can skew numbers if you want. Because we note that the formula for counting the loss in contributors to the National Insurance Scheme changed in 2021, coincidentally, after the government was dragged over the coals for the 2020 job loss statistics, informed by the same NIB report. So yes, it's a shrinking workforce. Companies are exiting this country. Thousands losing their jobs. We as the opposition have stated it publicly, any measure that could bring relief to the average citizen is a necessary measure at this time. The challenge we have is that the government waited till post-pandemic to finally wake up and smell the coffee that many businesses need this waiver. This is a measure that for some companies, that's why I say it is too little too late right now. For the 6,000 unclosed and the many more that are going to close day by day in this country. Some may even refer to it as administering medicine after death. So I have pointed out that the government must detail to the Parliament what is the potential for employers to be able to meet the window of 6 months to fulfill their NIB obligations. Why I say it's too little too late for some employers is that these companies that have already closed their doors as a result of the lockdown measures instituted by this government during the last 2 years, there are many companies that a waiver will not assist. The government, if they actually care about workers of this country, will ensure that those companies that are unable to make their payments because they have shut their doors or on some level of life support now, get the help that they need. Again, Minister West, I refer to what Minister West stated in her presentation, that the government boasted about assisting during the COVID pandemic with some relief through soft loans and interest reduction is what she stated, what the Honourable Minister stated. But again, we are still in a PNM pandemic. The pandemic may have or may be passing, but we are in a PNM pandemic. Companies still need this level of support. Therefore, it's incumbent on this government and the Honourable Minister of Finance and Acting Prime Minister to extend targeted credit support to those companies that will not be in a position to service their contributions in full, but can qualify for financing with some government guarantee behind them. That might be forward thinking. Maybe too much for some to think, but remember that the government guarantee is the key differentiating factor in whether a company with the right management, market opportunity, and client base can qualify for a loan or not. The guarantee goes beyond collateral. It's as good as gold, Mr. Vice President. You know how many banks will jump at this opportunity if it is backed by the government? I could think of several of them. One in particular, I could think of NCB Global. They may wish to partake in this. They may sign up for this if the government gives a guaranteed loan program to settle NIB payments, especially given their growth under this administration. The government can use the relationship with banks like NCB Global that have gotten major loans taken from the government. You can use this opportunity
Senator Lyder.
Yes, Mr. Vice President.
53(1)B, relevance to the debate and the three narrow parameters at hand. Kindly stick to it, please.
So no problem, Mr. Vice President. I mean, I just felt that in order to achieve the objectives in Clause 3 and Clause 4 of this bill, that the government may consider assisting these ailing companies with government-backed financing through institutions. One in particular I just mentioned. But anyway, I'll move on. Mr. Vice President, I have another question. What about some of those companies and employers that are owing, for instance, $100,000, but are only able financially and without upsetting their cash flow and putting them out of business, they're able to pay half the sum in this 6-month period? Will the government not also see the importance of its assisting with financing measures for those who are actively attempting to pay? Or will the government be willing to offer an extension at least to those who would have demonstrated commitment to settle a substantial part of their outstanding obligations? I heard nothing about that. Because this makes a difference between a company making the effort to provide half a loaf during this 6-month period versus continuing to evade the government without a slice of bread to share amongst the current employers. And we already know how expensive bread has gotten, so. But Mr. Vice President, as I move on, the Minister of Finance in another place, because I didn't hear anything be mentioned by the Minister of State in the Ministry of Finance here. But the Minister of Finance in another place is recorded as stating that he does not know how much the figure is owed to the NIB by state organizations. Can you believe that? And he went on further, when I looked at it on television, he went on further to state that this is a result of disputes over amounts owed. So I don't know what my left pocket or my right pocket. Can you imagine that, Mr. Vice President? How are you expected to run a government for the people if you don't even know what the left hand doing and your right hand doing? Mr. Vice President, the Minister of Finance stated that this was a submission from the NIB at the Public Accounts Committee earlier this year. That's what he stated. And although the Minister of Finance may feel comforted by this response from the NIB, those citizens and contributors of the NIB fund certainly cannot be satisfied with that response. The Minister could mandate the NIB to indicate how much funds are owed, including the portion that is being disputed. This would at least assist the Parliament in understanding the approximate, if not the precise exposure to the state that the NIB is carrying on its books right now. Imagine they don't even know what the state owes. Mr. Vice President, I heard Senator Mark speak about the minister's overarching powers once again seen in this bill. And I'm not going to go down the road of Senator Mark. I'll take a different approach. You see, Mr. Vice President, in this bill, clauses 3 and 4 grants onto the Minister of Finance powers with regards to the waiver and to do so by order. We all heard that. So the Minister can therefore extend the period without recourse to Parliament. And the defense of this by the government was that they would not want to waste parliamentary time. That is what I heard when I looked at this debate in another place. I think, if I'm not mistaken, nobody mentioned this, but the Minister of Energy in the other place was recorded on Hansard as stating this was to avoid, I quote, this was to avoid the need to utilize parliamentary time for these administrative matters, close quote. So I find this very curious that a minister who has as much call as an attorney as Minister Young is, would state that such a substantial change to the core function of the NIB is a mere administrative matter. That's what I find very strange. What does the NIB exist for if not to enforce payment of beneficiary contributions by employers? This is the very rock upon which the entire system of national insurance stands. Yet, granting the Minister of Finance, who is a politically appointed individual, Mr. Vice President, representing the political arm of the state, not a permanent secretary, not a public servant, a politician, the ability to treat with this as he desires, as he sees fit. And this is considered a trivial administrative matter. One would think that the government was referring to the possibility of the opening and closing times of the NIB branches, or whether an NIB should be opened on public holidays. That sounds more like administration. This is yet again another example, a multiple of examples of governments taking power, this government taking powers onto itself and bypassing the Parliament, and by extension bypassing the people of Trinidad and Tobago. Mr. Vice President, the Minister of State in the Ministry of Finance, in piloting this bill today, stated that this bill will assist the NIB in closing the gap between contributions and benefits. That's what he stated. However, this will only be during this 6-month period of amnesty. The Minister spoke at length about the sums collected by NIB from arrears in the past years outside of an amnesty. But the Minister fell decidedly short on giving any indication as to the expected quantum of arrears to be collected as a result of this amnesty. So we know, as the Minister stated, that the last amnesty, they would have collected 36.8 million in outstanding NIS contributions and was bought in by some 2,310 employers. So are we to simply use that as a yardstick without any concern for the total value owed today? If so, that is simply not good enough in my books. The Minister of State in the Ministry of Finance and the acting Prime Minister needs to level with the Parliament and the people of Trinidad and Tobago as to the extent of the gap that they seek to close with this current amnesty. You come without a plan? The Minister of State in the Ministry of Finance submission on the National Insurance Amendment Bill and the attendant waiver was strewn with half answers. I think my colleagues on my side, on the opposition bench, who've spoken so far, has clearly given examples of this. To me, it was an exercise in deflection today. The Minister of Finance basically indirectly told the Parliament and this nation by extension that I don't know how much money is owed to the NIB overall. I don't know how much the state owes to NIB. I don't know how much companies are in a position to comply with the waiver. Nor will I be able to make steps to clear up this grey area. And you know, Mr. Vice President, as the local saying goes, nothing from nothing leaves nothing. What are we to expect here today? This bill has nothing in place to measure the potential success or failure of the waiver on the collection prospects of the NIB. As the old adage goes in business management, if it cannot be measured, it cannot be managed. And if you fail to plan, plan to fail. Yes. Yes. No planning, a normal thing with this government. This presentation of the government in this debate on this bill simply lacks connection to planning, lacks adherence to objectives that are SMART. I know, through you, Mr. Vice President, the Minister of Trade knows the acronym SMART. It must be specific. It must be measurable. It must be attainable. It must be realistic, and it must be time-bound. I've heard nothing here that shows SMART objectives coming from an unsmart, no, non-smart government. Yes. I think the only thing they got correct is the time-bound. But even that, the minister has reserved himself the right to extend by order.
The member apparently just discovered fire with his smart measures.
What? Mr. Vice President, that's a standing order.
If I may, ask the member to repeat the standing order for your clarity.
46-6, please.
What? You don't agree with SMART objectives? Mr. Vice President.
Imputing improper motives is what he's coming to.
To who, Mr. Vice President? Who?
The SMART
Who in the government am I imputing improper motives? Who?
Continue. I'm just clarifying.
Yeah, okay. Order. Thank you, Mr. Vice President. I see you realize
so, Mr. Mark asks, Mr. Mark, I wanted clarification, and I ask you to continue your presentation.
Thank you, Mr. Vice President. I see that your ruling shows that that standing order makes no sense whatsoever. Because clearly I have imputed no improper motives to anyone. I spoke about this PNM government.
Senator Lyder, yes. I have made a ruling, and yes. I have taken the standing order from the member, and I've asked you to proceed.
Okay.
There's no reason for you to explain my ruling or not.
Yes, thank you. Thank you for your wise ruling, Mr. Vice President, and I move on your advice. So it is in this vein that I say the government is setting themselves up for an easy ride in an endeavor that requires rigor and clear management oversight. I ask my colleagues to reflect on these submissions with a view to improve this legislation before the Parliament, as my colleague, Senator Mark, has already indicated that the opposition will be bringing amendments to this bill to assist the government to improve on a half-baked bill brought to this Parliament. So my short intervention today is a reflection of the lack of thought and vision that has gone into this bill. This has become synonymous with the actions and performance of this government. As such, without this minister's ability to answer most basic and fundamental questions here today, that myself and my colleagues and I, and even those on the independent bench have asked, that we've all raised today, I hold little hope and expectations that this amnesty will be impactful, will maximize the outcome, or be concluded successfully to the benefit of the citizens of Trinidad and Tobago. I hold little hope. The Honourable Minister of State in the Ministry of Finance mentioned that winter is close. My colleague, Senator Mark, said, no, it's heat. Let me set the record straight. The winter has been biting for the past 7 years under this PNM government, and now the country is getting heated and giving this government heat. That is what is going on here now. We're still in the winter. So, the Minister of State, the acting Prime Minister, and the Minister of Finance needs to go back to the drawing board. You need to go back to the drawing board and create a more detailed plan, one that is transparent, one that involves consulting with all stakeholders. Because I heard Minister West say that in the roadmap for recovery, which I don't seem to see being implemented, but the Honourable Minister stated that in that roadmap for recovery, there was partnership, or supposed to be partnership, and consultation between the government, labour, and private sector. And Senator Mark most ably indicated and proved that there was no consultation with Labour in this. So they need to go back to the drawing board and consult. Take this to a joint select committee. Mr. Vice President, if any minister, and I don't impute to anyone, but if any minister was in the private sector working for me and came to me with a plan or came to me with an objective without a plan, without smart objectives, they'd be fired immediately. Just as how this country will soon fire this government. I thank you, Mr. Vice President.
Senator Anthony Vieira.
Thank you, Mr. Vice President. I really wasn't planning to speak on this bill, but having heard the contributions, I feel I have to put some concerns I have on the record. My first concern, of course, is that the NIB is not a company. It is a fund. And so I'm very uncomfortable tampering with the NIB's fund this way. My second concern is I really find this law is unfair to the law-abiding. You know, there are employers who have struggled through the past few years. They have stood by their employees. They have done right. They have made the sacrifice. And what are we telling them? You know, that you could just ignore the law and you get obliged? I am uncomfortable about that. There should be no payoff for wrongdoing. Another point that troubles me is this. Why do we need legislation for this 6 months period of safe harbor? If you owe the NIS money, why can't you go to the NIS, negotiate with them a settlement agreement, and they will give you time to pay what you owe? And it wouldn't be in 6 months. You could negotiate a year, 2 years, longer, as suits the circumstances of the case. I also have very serious concerns about giving the Honourable Minister, and I'm not speaking about this particular minister, I'm speaking generally, about giving the minister power to waive penalties and interest. First, as I said earlier, because we are tampering with a pension fund. And secondly, we should really know who the beneficiaries are. So, for example, I don't know if any proceedings have ever been brought against any government agency or any ministry, but I would be very concerned for, on the one hand, for the minister to be waiving penalties and interests for people who we don't know are getting this largesse. And on the other hand, we are also increasing the penalties today substantially. Other people getting the big stick. To me, unless we set up some sort of criteria, some sort of transparency, there is room for mischief. And even if there is no actual mischief, there's a perception for the possibility of mischief to occur. And I'm very uncomfortable about that. That a minister can have power to waive for one, while a similarly situated employer feels the full brunt of the law with these increased penalties. Cannot be right. I agree with Senator Mark and with Senator Deonarine. And I think if I were to characterize it, I think this bill is flawed on both ends. It's flawed on the incentive end because what's the use of trying to give this incentive if people really don't have the money and the capacity to take advantage of the incentive being offered? This 10%, I mean, that's a very, very low bar, and it mightn't even be that. So the incentive idea may not work. And then on the other end, we're talking about ramping up the penalties. But what's the sense of ramping up the penalties if we are not aggressively prosecuting the infringers? You know, are we going to scare them into compliance because the penalties are now bigger? It doesn't work like that. We really need to create a culture of compliance. And I think that has to be achieved by a mixture of both carrot and big stick. I don't think this legislation meets that objective. We really need to dig deep into how to create the conditions to ensure voluntary compliance. And that is why I tend to support Senator Mark's request, his suggestion for a joint select committee or some sort of colloquium, because I think on something as fundamental as this, where we're talking about contributions, the safety net for our employees and our workforce, and people have sacrificed all their years, I would like to hear from the employers, I'd like to hear from the trade unions, I'd like to hear from the NIB, I'd like to hear from actuaries, economists, from TARP, from the chambers. So I don't have much more to say. To summarize, I'm uncomfortable with this legislation. I'm uncomfortable about giving wrongdoers a bly. And in my view, there should be no bly for anyone who has taken contributions from employees under the guise of the NIS and then failed to remit it to the NIS. That sort of person is a thief. As far as I'm concerned, that is white-collar crime. No bly should be given. And again, I will not support this legislation unless we have some criteria to make sure that that is not going to happen. What this law is saying is, don't pay your NIS and your liabilities will be waived. That's not fair. And we are interfering. This is my real concern. We are interfering with a statutory trust. Money due and payable by employers and employees are deemed to be held in trust under the Parent Act. It's held in trust for the board, Section 39A. It is the board's duty to operate and manage the national insurance system. So, under the Parent Act, the minister can approve powers and functions that the board may exercise and function, but that is subject to affirmative resolution. And so to me, this amendment at Clause 3 seems to fly in the face of that. You just waive penalties and interest? No. I have to say, I think we need to revisit this. I am not happy with it. I thank you.
Senator Renuka Sagramsingh-Sooklal.
Mr. Vice President, I thank you for the opportunity to join in this debate.
Coming at this stage in the batting order, Mr. Vice President, my contribution in this debate is not going to be very long. But I believe it was critical to, of course, rise to the occasion, having the opportunity to speak, to, of course, again, to jump into this debate, to try to debunk some of the misinformation and the propaganda that the opposition in this place is known for. Mr. Vice President, I am not surprised at all by the misconception of the members of the opposition. Sometimes I often think, Mr. Vice President, that is what they do best. You know, I want to remind this country and this Honorable Senate, Mr. Vice President, that amnesty periods in this regard, it is not an entirely new concept at all. As a matter of fact, Mr. Vice President, the government of 2010 to 2015 brought an amendment under Act Number 2 of 2012, a finance bill sought to amend the same Section 39C1 to cater for outstanding contributions, which would have become due and payable, Mr. Vice President, until October 9, 2011, as the amnesty period was from the 10th of October 2011. Now, Mr. Vice President, in listening to the contribution of the other side, I had the benefit of pulling some Hansard records of the House of Representatives. And for the purpose of this Hansard, Mr. Vice President, Madam President, it was the House of Representatives debate dated the 8th of February, 2012, at page 471. The former Minister of Finance, Mr. Vice President, in his piloting of the Finance Act Number 2 of 2012, explained a similar amendment to Section 39C, subsection 1. The Hansard at page 471 of that debate, Mr. Vice President, which took place, as I said before, on the 8th of February, stated, the then Minister of Finance stated, the NIS waiver we expect would indeed increase the revenue base of the National Insurance Board and also allow individuals to put their books in order. All outstanding contributions payable by the employer to the board must be paid before the expiry date of June 30th, 2012. So there is a sunset clause. The waiver shall only be available to employers who are registered with the board before October 10th, 2011, in respect of penalty, interest, and contributions for the insured person registered as their employees prior to October 10, 2010. The waiver only applies to penalty and interest payments which accrued before October 10, 2010. So this is another attempt to provide an incentive for those who have, for one reason or the other, not paid up their NIS contribution to do so and get their books in order. End quote, taken from an Hansard of a 2010 government. And I need not remind this country who was in power, Mr. Vice President, at that point in time. So it begs the question, Madam President, it begs the question, if members of the side opposite even understand the concept of a sunset clause, when this amendment that we have brought, this amendment is clear as to when the amnesty period would end. I want to respectfully submit to this Honorable Senate who stands to benefit from this amendment. Madam President, Senator Mark, throughout his contribution, throughout the length and breadth of his contribution, would have insinuated that only a particular group stands to benefit from this amnesty. Madam President, I want to take this opportunity to indicate, as we are all aware, that this government is an all-encompassing government. And the purpose, as was already mentioned, is for the benefit of all citizens of Trinidad and Tobago to fulfill their now statutory obligations. So, of course, for Senator Mark to come and then promote the idea that this amendment, of course, is for a particular group or potential P&M financiers and friends and family, I think that's how they constantly put it to the population. It is absurd. Because once we have this amnesty, we are going to have SMEs who are going to benefit. Once we have this amnesty, we are giving an opportunity to every single class of citizens in this country to put their house in order. And that is simply what we are here to do. Madam President, the past is evidence that amnesty periods benefit both citizens and the government. As citizens, Madam President, is given an opportunity to once again be on the right side of the law, while the government would benefit from monies that was once due and owing to the state, so that the obligation of the state, Madam President, can be met. And mind you, when I speak of the government benefiting, I'm not speaking about government benefiting and money hitting our pockets, you know. I'm talking about the government is able to accrue sums, of course, that could then be reinvested into other areas of development, Madam President, in this country. So that is just one of the major things that I wanted. Having looked at the Hansard, having seen a UNC Minister of Finance brought a similar provision in the past in which the UNC supported, and now have the gall to come here today and criticize this government for trying to implement something that was similar. Madam President, as I promised, I would not be long, but I want to briefly look at Clause 5, proposed Section 63(1) of the bill, of the National Insurance Bill Act. Now, Madam President, Clause 5, proposed Section 631 states, any person who, for the purpose of obtaining any benefit or other payment under this Act, whether for himself or some other person, or for any other purpose connected with this Act, A, knowingly makes any false statement or false representation, or B, produces or furnishes or causes or knowingly allowed to be produced or furnish any document or information, and of course the clause goes on. So that is my focus now would be on Clause 5, paying specific attention to subsection A and B. Now, Madam President, I am of the opinion, and the government is of the opinion, that NIBTT has been continuously improving its services and operations in meeting the needs, Madam President, of the people of Trinidad and Tobago. And the purpose of doing this, Madam President, is to add a further layer of protection to persons. And when I speak about that, I'm talking about what we hope to achieve, Madam President, in the amendment that Clause 5 now brings. Our intention in the amendment that Clause 5 brings, Madam President, is my respectful submission, is also to address and bolster the national insurance system and legislation. And thirdly, this amendment brought in Clause 5, Madam President, I respectfully submit, is also to provide a critical tool to law enforcement in relation to the national insurance provision. Now, in looking at this particular amendment, it is very, very important, Madam President, for me to respectfully take the Senate to Section 3, subsection 1 of the Forgery Act of Trinidad and Tobago, Chapter 1113. Now, Clause 5, proposed Section 631 of this bill, deals with fraud and forgery of documents and the production of false information. So I believe for us to also get a greater understanding of this clause, it would also be critical for us to bear in mind the Forgery Act. Now, Madam President, under Section 3, subsection 1 of the Forgery Act, forgery is defined as the making of false documents in order that it may be used as genuine. The section goes on to say that forgery with the intent to defraud or deceive. And then, of course, in that particular bill, in that particular act, there is then Section 3.2 that goes on into detail about persons and basically the criteria that the court will have to satisfy for someone to be deemed as guilty of committing this offense. Now, Madam President, This means that, pursuant to the Forgery Act, what this means is that a document is false where there is any material alteration, whether by addition, or erasure or removal. What it also means is that the whole or some material, part of its purports to be made by or on behalf, is fictitious or probably of a deceased person. That particular section of the Forgery Act is also said it's made in the name of an existing person, or it is made by him or by his authority with the intention that it should pass as having been made by some person real or fictitious, other than the person who made or authorized it. Now, let us look at what I know. So that's what the Forgery Act speaks to, and it's that area, that piece of legislation that deals with a similar offense that is now created in this particular amendment. What I now want to look at, having put on the record what the Forgery Act states, I want to look at the consistency, Madam President, that exists in national insurance in this bill with the Forgery Act. Madam President, Clause 5, proposed Section 631 of the bill, a person who is found guilty is liable on summary conviction, and Section 17 Section 17 subsection 2 of the Forgery Act states, Madam President, that where an offense against this act is by any other act, whether past or after the commencement of this act, made punishable on summary conviction, proceedings may be taken either under such other acts or under this act. The point that I want to make, Madam President, is that the Forgery Act seeks to allow a person to be held liable for acts of fraud and forgery, which is punishable by summary conviction. So therefore, the fraudsters and smart men can be dealt with under that Forgery Act. What we have done in this amendment is very similar to what we have already, what is currently present, or how fraud is dealt with under the Forgery Act. So the reason why, Madam President, I just wanted to bring to the attention of this Honorable Senate the Forgery Act is so that we can understand that the amendments that we have brought today is also in alignment with other existing law as it relates to the treatment of fraud. And by applying what we have done, or by making the amendments which we have made to this particular act by virtue of the bill that we are debating, is consistent with the Forgery Act. So we have not departed significantly. We have not departed from how this offense is treated in other pieces of law. Now, it is critical. I know Senator Vieira, and that has always been my concern. I know Senator Vieira, and I don't want to misquote the Honorable Senator, but I believe he asked a question about, or he made a statement relative to the importance of enforcing the law, right? Yes, we have increased penalties, and yes, critical is how is this going to be enforced. Now, when I was looking at this bill and looking at the act in its entirety, of course, the point of enforcement came to me, and I reminded myself, Madam President, of the department responsible for fraud under the NIBTT. Madam President, it would be remiss of me if I don't make mention in speaking of the enforcement of whatever amendments we have brought to this bill. It would be remiss of me if I don't mention the Investigation and Controls Department within NIBTT. And it is this department, Madam President, which is responsible for investigating and reporting of fraudulent activities within the National Insurance Board. So in essence, the amendment, my respectful submission, is that what we have done is simply given greater teeth to this investigation body, who, of course, when I say greater teeth, of course, this body, is going to be responsible, of course, for using the law that is now in existence, for accruing all of the evidence and all of the information that is necessary to ensure that there is successful enforcement of the new provisions or the amendments that we have brought to the law. Now, Now, the main objective, so like the Honorable Senator, being concerned about enforcement, it took me, again, as I said before, to looking in detail at this investigation and controls department. And even within the Act, it's clear what their roles and their main objectives and their functions are. So this investigation and controls department, Madam President, just for the record, the main objective of this department are to execute the day-to-day operational activities in support of the fraud control framework, 1. 2, to support the organizational efforts to ensure compliance to fraud and all related policies. And 3, implement preventative, detective, and response procedures that will manage fraud. So by looking to answer my own concerns, when I asked the question, okay, how is this? How are we? What mechanisms are in place to ensure that all of these amendments we are able to enforce it and really catch those fraudsters? I want to believe, my respectful submission is that we have within NIBTT, Madam President, the Investigative and Controls Department, and I've already listed what are their core and critical functions. In essence, what this department will be doing is serving a function by assisting in the collection of evidence that may exist within NIBTT that, of course, can assist in the enforcement and, of course, bringing to justice persons who are guilty of offenses committed under this Act. Madam President, by carrying out these objectives, the objectives that I respectfully submitted above, the Investigations and Control Department of NIB has a mandate, and I want to repeat that, has a mandate to collaborate with the Trinidad and Tobago Police Service, the Board of Inland Revenue, and the Ministry of Legal Affairs as necessary to report and or to provide support in the prosecution of fraud matters encountered during their day-to-day operations, thereby embodying an ethical culture with zero tolerance to fraud. And I was very, very much interested. I mean, not being a mathematician and not being very much into the finance world. I shouldn't say a mathematician, but not being very, very much in tune with the finance world. I really had to find myself reading to fully understand how the NIBTT operated. And I have to reiterate that I was pleased as a citizen, not as a minister of government, not as a member of the government, but just as a citizen of Trinidad and Tobago, to know that this investigation and control department that exists within the NIBTT is responsible and will be responsible for assisting all of the key players, whether it's the Office of the Attorney General, whether it is the TTPS, the Trinidad and Tobago Police Service, and more so the Board of Inland Revenue. This body is responsible for working with these entities in order for us to treat with the issue of fraud that may exist within the National Insurance. NIB. Now, Madam President, to that end, with this amendment, I want to reiterate that as a government, we are remaining committed to taking a zero tolerance approach to fraud. With this being said, we are placing stiffer penalties, Madam President, for acts of false information where persons try to obtain benefits or other payments under this Act, whether for himself or for some other person. Madam President, we are therefore making these amendments, and I want to say to the people of Trinidad and Tobago, we are making these amendments for the benefit of all citizens of Trinidad and Tobago, for all of our people. And we are taking a hands-on approach and a no-nonsense approach, Madam President, in trying to deal with fraud as it exists and instances of fraud as it may come to the fore. So this is really the crux of my contribution, my very, very short contribution to this debate, Madam President, where I just wanted to remind the public who, like the Honorable Senator Vieira and even like myself, who may have been concerned about the enforcement enforcement processes, I wish to say that within the ambit of the Act itself, there is this investigative body that is now charged and has a mandate to work with some of the key players who are, of course, responsible for the investigation and more so the prosecution of fraud as it exists. Madam President, with those few words, I thank you.
Acting Prime Minister and Minister of Finance.
Thank you very much, Madam President. I will be quite brief. I'm glad I came in at the time I came in to hear Senator Vieira. I was informed that Senator Deonarine had a suggestion that perhaps the amnesty could be for a longer period because of the difficulties some persons who are currently not in compliance or not within the system may have in complying within a 6-month period. And that is precisely the purpose of the provision that allows the minister to extend the period of the amnesty, because in all of these amnesties, it is not clear what the response will be. In the amnesties that this government has implemented, that I have implemented, it is a feature of these amnesties that you always find a huge crowd in the last week of the amnesty. Always. And I guess that's a societal thing. You always get people trying their best to comply. I have found that with tax amnesties in particular. People genuinely want to comply for one reason or another. Business problems, difficulties, problems with paperwork, discipline in terms of their accounts and so on. Persons have difficulty complying with amnesties, easily complying. And there are many persons who request an extension genuinely, and they don't really need more than a couple of weeks. Their accountants are finalizing their accounts, auditing their accounts and so on. So the purpose for an extension is very practical, but you never know how long it should be. And therefore, that is why we have the provision for the minister by order to extend the amnesty. And I can assure you that if it is necessary, if it becomes necessary, because I'm going to come to a point that Senator Vieira made, put it in context, that if it becomes necessary to have a fairly lengthy extension, then a decision will be made along those lines. But you would never know until you get to that point. One of the features of this bill is that it not only provides an amnesty for existing companies that are already within the national insurance system, it also allows for persons who are outside of the system but operating in breach of the law to enter the system and become compliant. So it is persons who, by rights, should be registered with the national insurance system, but for one reason or another, many of them not good reasons, they are not registered. So an innovation in this legislation as compared to the previous one is that it
allows persons who are not currently registered with NIB to register. And I would think that those people might fall into the category, by and large, that Senator Deonarine has spoken about, that will have difficulty in complying within the 6 months. So that's why we have created this flexibility. And that's a feature of amnesties, whether they are tax amnesties or other amnesties. That's a feature of legislation where the minister is given the authority to extend. And what the minister is actually doing is extending a benefit. And let me just give some history, because I noticed Senator Mark went down same rabbit hole that the Honorable Senator is always going down. If Senator Mark had his way, everything would be by affirmative resolution. It doesn't matter if you're changing a full stop. So let me go now into the history of the concept of a ministerial order. When I look in particular at the period in which Senator Mark was in government, or the period in which Senator Mark's party was in government, I looked at Act number 11 of 2010, the Interception of Communications Act, that was passed by a special majority. So this was an act that was felt to infringe the rights of citizens, the constitutional rights of citizens. So it was passed by special majority. And in that act, the minister, the relevant minister, has the power to do things by order, even though the minister would be doing that without a special majority. Then you have a very interesting one, the Purchase of Certain Rights and Validation Act, that is Act number 17 of 2011, the CLICO Act. I don't know if you all remember that, where you had short-term investment products, I think they call them STIPs. They were converting the premiums, the policies into these STIPs. Again, that act involved billions of dollars. In fact, I think the amount was $10 billion or $11 billion. And again, the minister was given the power in that legislation in 2011, under the government of which Senator Mark was affiliated with, the right to make extensions and to make orders without affirmative resolution. So it appears that what is good for the goose is not good for the gander. Act number 5 of 2012, the Administration of Justice DNA Act, again passed with a special majority, regulating the use of DNA evidence with respect to criminal offenses. Again, the relevant minister is given the power to do certain things by order without affirmative resolution. Then you have Act number 11 of 2012, Administration of Justice Electronic Monitoring, again passed by a special majority, and again makes provision for ministerial orders without affirmative resolution. And there's a reason for all of that. The Parliament felt that it was administratively unnecessary to come for a minister to come to Parliament and debate in both houses what is essential and administrative action. And I want to correct a bit of misinformation I heard from Senator Mark, where he said that this bill will give the minister the power to waive. It does not. It gives the minister the power to extend an amnesty, which the Parliament will have already agreed to. So the Parliament will already have agreed to the amnesty, and this simply gives the minister the power to extend the deadline date for the amnesty. So that it is quite ridiculous for an argument to be made that this bill, which is bestowing a benefit on the public through an amnesty of interest and penalties, is egregious or ridiculous when a previous government did exactly the same thing, quite correctly, with a number of laws that were inconsistent with the Constitution and had a far more profound effect on Trinidad and Tobago. But let me give a real-life example to show you what we on this side are subjected to on every occasion that I have to come into this honorable house to deal with misinformation that is put into the record by Senator Mark. Let me give a real-life, pertinent example. In 2010, the then government implemented a tax amnesty. And by law, by Section 16H of the 2010 Finance Act, the amnesty period commenced on September the 8th, 2010, and ended on May the 31st, 2011. After May the 31st, 2011, the law indicated that the previous paradigm would apply and the waiver would disappear. The then Minister of Finance, not a P&M minister, the then Minister of Finance visited some government offices. And one of the offices in particular that the then Minister of Finance, UNC Minister, visited was the Inland Revenue Division. And after visiting the staff at the offices of the Inland Revenue Division to thank them for the work they had done during the amnesty period, the then Minister of Finance, not a P&M minister, decided, based on the feedback that he got from the staff in the Inland Revenue Division, that he would extend the amnesty for a month. I have the press release right here. Look at it. It's still on the Ministry of Finance website. Still on the website. To all individuals and companies who have not yet filed their returns of income for any year up to 2009, all interest will be waived if taxes are paid during the period 8 September to 31st May 2011, and then goes on to say this is now extended to June the 30th, 2011. So the Minister of Finance in the party of which Senator Mark was associated with extended the amnesty in 2011, not by coming to Parliament, not by negative resolution. He just did it. So this is the problem that I have with all of this. Every time I come here, I have to hear this misinformation from Senator Mark. And I want to repeat, all this minister will be doing is extending an amnesty already agreed to by the Parliament, if the Parliament so decides. Now let me come to a point made by Senator Vieira. I'm reading from an article called Tax Indulgences, the Scope and Effect of Tax Amnesty. And this is a document published by the United States Internal Revenue Service in 1992, September 11, 1992. And it makes these points. It's very interesting. From a societal perspective, an amnesty, a tax amnesty in this particular case, has three primary benefits and one disadvantage, at least one. One benefit is that an amnesty allows individuals who violated the tax laws and continue to evade them, and in this case it would be the national insurance laws, because of a fear of being penalized for non-compliance, to become law-abiding citizens again. So that's benefit number one. It allows persons who have evaded paying their fees and charges and their taxes and continue to evade them because they're afraid that if they own up, if they walk into the National Insurance Board, for example, in this case, and say, look, I want to confess, I haven't been paying my national insurance for the last year or so, that they will be prosecuted. So it allows, that's benefit number one. So it allows citizens who have breached the laws to comply without fear of prosecution. The second benefit, which is one of the principal motivations for this particular NIS amnesty, it allows the authority to collect some back payments that it would presumably be unable otherwise to collect. Because let's be practical. In many cases, if there isn't an amnesty, the payments will not be collected. People will continue to evade. Some of them will be caught. Some of them will be prosecuted. But quite a few of them will not. The third measure, and this is very interesting and important and relevant to this bill, is that by coupling the amnesty with reform or new compliance measures, the amnesty may encourage greater future compliance. What are we doing here? In this particular piece of legislation, Madam President, we are increasing the fines and the penalties. So that's a significant reform. Because if you looked at what the penalty was before, it was ridiculous, $2,000. So it's no wonder, and I mean, I'm surprised over the years that a previous administration hasn't dealt with this. Yes, Senator Seepersad? Or you want to say something? Oh, sorry. It's no wonder over the years that if the fine is only $2,000, that's why. It reminds me of the Commission of Inquiry fine. That the fine, I don't know if it still applies, for not attending a Commission of Inquiry to give evidence if you've been subpoenaed, is also $2,000. It used to be. I don't know if that has been changed. And therefore, you find in those situations as well, there are quite a few people who just don't show up. You know, they're subpoenaed to appear in a Commission of Inquiry, and they don't show up because they're quite willing to pay the fine of $2,000. So, by coupling the amnesty with a reform, which is what we're doing, increasing the penalty to a reasonable amount, 50,000, and of course that's up to 50,000, so it depends on the severity of the offense, and also increasing the custodial sentence, you are reforming the system. But the other reform we're doing, and this is a unique feature of this legislation, is we're allowing persons who are outside of the system. It's not that they're registered and they fell behind in their payments for some reason. These are people completely outside who should be inside and know that they should be inside, but just like the first set, are afraid of coming in and registering because it may be discovered that they have been operating businesses in breach of the act and not paying contributions on behalf of their employees. So it allows that category of persons to enter the system without being penalized. So those are the three advantages. And the disadvantage, very interesting, is as if Senator Vieira wrote this. The disadvantage is that an amnesty may annoy honest taxpayers. I found the words quite interesting. Some may conclude it was foolish to comply with the law in the first place. Others may be less inclined to comply in the future. Others may go further and choose non-compliance planning to avail themselves of a future amnesty. So there is no saying these truths. An amnesty is always a difficult decision to make. It's always on the margin. If you continue to have amnesties, people may continue not to comply. But I think these advantages are very important. And all over the world, various governments use amnesties. Yes, Senator Vieira?
Thank you, Minister. No, I totally get it with amnesties, and I've supported amnesties in the past. But my concerns really are, this money is a trust fund, it's a statutory trust, and whether the minister, as opposed to the NIB, who are the persons for whom all money is collected, are held in trust, should really have any waiver or intermeddling with that. That's number one. And even if we say, okay, let's give the minister that power, there must be, in my view, transparency and criteria, because we don't want it to feel or to look as though the minister has given a blighter, friends and family, and on the other hand, other people get the full brunt of the law. I'm not going to say this is going to happen, but we should satisfy ourselves that we have built in those protections.
Well, this is why the penalties are being increased. That's an answer to that, Madam President, through you. And I mean, this amnesty applies to everybody. So there's no blight to anybody per se. I mean, it's just like a routine tax amnesty, income tax amnesty, value-added tax amnesty. There's no personalization of the amnesty. There's no indication that any particular group or individual is being singled out or favored in an amnesty. You could apply that argument to any amnesty. You know, any tax amnesty applied in any country by any government, you could say is designed to favor a particular group. Yes. So any amnesty of penalties and interest on payments, whether they are tax payments or in this case, insurance payments, that argument can be mounted, Madam President, through you, that argument can be mounted on any amnesty. Because the amnesty does not distinguish. It doesn't say this is an amnesty for John and it is designed for Mary. It's simply an amnesty across the board. I don't think you can legislate that. I think what you have to do instead is to be very, very careful going forward. And this is why the penalties have been increased in this substantial manner. So that I don't think there's any measure you can put in place to deal with what Senator Vieira has just raised, Madam President. So I simply wanted to say, and I want to also make the point, Madam President, that it is the minister who has to come to Parliament to amend the legislation. As a member of the legislature and the minister named in the Act, it is the minister's responsibility to make amendments to the Act. The National Insurance Board is not a creature of this Parliament. It is not a creature of the Constitution. It has no lawmaking power. So as is the case with all of these matters, even going outside of finance matters, even going into national security matters, on many occasions, even though you might be dealing with a national security agency, police, immigration, whatever, it is the minister who is accountable to Parliament, and it is only the minister that can bring legislation to Parliament to create penalties and benefits. So I don't agree, Madam President, with that concept that the National Insurance Board should somehow be clothed with the authority to create an amnesty or not, as the case may be. And I'll give an example. When I was first made Minister of Finance, one of the first things I did was increase the contribution rates. Now we could take the arguments of Senator Vieira to that extension and say the National Insurance Board should be given the authority to increase contribution rates, should be given the authority to increase the retirement age. These are matters of policy. And with respect, that is not a matter for an entity that has no constitutional presence, has no constitutional authority, has no constitutional form, and has no responsibility to the Parliament. Ministers are responsible and accountable to the Parliament. So I simply wanted to come here today, Madam President, and point out that once again, Senator Mark has led us down the garden path, pretending that the idea of a minister extending an amnesty is something that is abhorrent. Madam President, I don't know why Senator Mark is doing that. I'm speaking to you, Madam President. I don't know why he's shouting at me like that. Is it because I have revealed that for yet another time he has misled the country and the Parliament? Is it because for yet another time I have revealed that a minister associated with his party has done exactly what we are seeking to do in this legislation? Maybe. So, Madam President, I thought it was necessary to come and reveal the truth that the UNC did this without any qualms whatsoever. It was right for them then in 2011. It cannot be wrong now. And I hope I have answered some of the other points in terms of, Madam President, I am not speaking to Senator Mark. I'm speaking to you. I don't know why he keeps shouting at me like that. So I hope I have answered the other points, such as the points made by Senator Deonarine. I'm afraid I wasn't present for Senator Seepersad's contribution, but I understand she made a number of recommendations. And also, I hope I have been able, in some way, to address some of the concerns and the points raised by Senator Vieira. I thank you, Madam President.
Senator Walker.
Senator Walker.
Thank you, Madam President, for the opportunity to contribute to this very important bill. Before I get into my presentation and speak about my concerns with the bill, permit me, Madam President, to just respond to the Minister of Finance. Very quickly, the acting Prime Minister, One, in 2011, you, based on your own admission just now, these bills were 3/5 majority. Is it a habit of the PNM to support legislation inside the Parliament and then when it's convenient, say, well, you know, you did it too? We are here, and obviously the independent senators are also in disagreement with this bill. This is not a situation where Senator Vieira said he was not supporting. Whether it's a no or what, he said what he was not supporting. Let us go on now to Senator Vieira. Senator Vieira asked specifically about Clause 5. Actually, no, he asked about Clause 3, and I quote, "The minister may, by order, provide for the waiver of penalties or interest due and payable under this section." The acting Prime Minister conveniently came and spoke about Clause 5, which says the minister may, by order, prescribe a later date for the payment of contributions under subsection 1. There are 2 clauses in this bill that gives power to the minister. And what is going on the other side is they are continuously, conveniently referring only to Clause 5 and saying, hey, well, you know, it's normal. People always extend amnesties. Governments extend amnesties. When we are raising an issue specifically to Clause 3, Section 39B, 2. Let me repeat it for the benefit of the listening public. The minister may, by order, provide for the waiver of penalties or interest due and payable under this section. Is the minister saying that this has something to do with extensions? Because it certainly sounds that this allows the minister at any point in time to start a whole new amnesty. It certainly sounds like the minister can go specifically to one company and offer a waiver, and he does not need parliamentary oversight to do this. This is the clause that we are asking about, not an extension. Now that I've dealt with the acting Prime Minister, let me deal with the minister in the office of the Attorney General. It's ironic that she quoted Wednesday, February 8th, 2012's Hansard. And she said, I quote from...
Members, please. I know a lot of you all are having fun. I'm happy for you. But can I please hear the senator as she makes a contribution, and can you all be a little quieter?
Thank you, Madam President. The minister in the office of the Attorney General came hot and sweaty to talk about page 471. So I am going to quote page 485 of that same Hansard, Wednesday, February 8th, 2012. I quote, Madam President. So we are still talking about waivers for people who do not comply. It is either we have a culture of one kind or we have a culture of another kind. We cannot talk about increased penalties on documents. People are going to sit there and wait because they know waivers and amnesties will come.
permit me, Madam President, to repeat that line, quoted from page 485 of the same Hansard, page 471, quoted from. We cannot talk about increased penalties on documents. People are going to sit there and wait because they know waivers and amnesties will come. That is what has been happening in the recent past. I wonder if the Honourable Minister stopped at page 471, because had she read on to page 485, she would realize that these words were uttered by her very leader, the Honourable Keith Christopher Rowley. The Honourable Keith Christopher Rowley, in 2012, in his typical fashion, opposed any talk of amnesty. So I wonder if the minister in the Office of the Attorney General and the minister in the Ministry of Finance are at odds with their own leader. Because, again, we can see, using Hansard records, that their leader was opposed to waivers. So one talking about winter has come, but the other one saying, no. You don't give amnesty, you don't give waivers. That's not the culture. I think somebody needs to get their house in order. So now that I've dealt with her, we'll move on, Madam President.
Senator Walker, when one is making a reference to a member of this chamber,
my apologies.
One does so with respect, so you are referring to the Honourable Minister, okay?
My apologies, Madam President. Madam President, the minister spoke, the minister in the Ministry of Finance spoke about closing the gap between contributions received and benefits paid out. In typical PNM fashion, the government has sought to blame the citizens. The minister passed all blame on our aging population. But, Madam President, I would like to argue that the inefficiency to collect arrears is really where the blame ought to start. Madam President, the minister spoke about a 2012 amnesty and indicated that some $36 million would have been collected during that amnesty. According to NIB-TT Report 2021, just over $424 million are in arrears. Madam President, in February of this year, let me make sure I am quoting correctly because misinformation is not a thing we do. At a Public Accounts Committee hearing in February 2022, a question was posed to the Executive Director of the NIB as to how much is owed to the government. The Executive Director could not answer. So in essence, the NIB said to that Public Accounts Committee that we do not know how much the government owes. The government being the single largest employer. So it is fair to assume that they probably owe a vast majority. This is the information that's important because the Honourable Minister, the Minister in the Office of the Attorney General, stressed that this government benefits all. She stressed that this was to benefit all citizens. Yet, if we were to dig, will it be our very own government that stands to benefit the most from this amnesty. And so the government has a duty to tell this House how much money they owe and how much they will save. Because, to be honest, if the government paid up their own arrears, maybe we will see that that gap of which they speak will be closed. The Honourable Senator West said, there is clearly money out there and the relevant agencies are not even aware. I found that statement to be very worrisome. Once again, this government does not seem to know what is going on. How can you expect to close the gap if you do not know what monies are out there? So I have to join with Senator Vieira when he says, this is not the way. If a gap has to be closed, we do not need to come to Parliament to do it. What we need to do is conduct more audits. I was watching the acting Prime Minister in the other place on television, and he spoke about some 17,000 audits that were conducted between 2019, 2020, and 2021. And he said, in that little activity, the NIB was able to collect more than $1.3 billion in arrears. He didn't need to come to Parliament for that. $1.3 billion to me sounds like a really good place to close the gap. And that was done through measures that are already here. You go, you do audits, you collect the money. Let's go into this issue of COVID, and the government cares, and the government is aware. I want to use the words of Honourable Senator Minister Manning, where he said, what are his words? They are a government that is aware of challenges. If you were truly aware of challenges, then you would understand, Madam President, right now is not the time. Small, and I want to use a new term, you make sure and give me credit, nano enterprise. Because when you look at the definition of an employer, they just need to employ one person. So that means the person who's selling pylori and has somebody cash in, that is smaller than micro. These are the all that we speak about. And if you think that these types of businesses can come up to scratch with this amnesty at this time, I'm sorry, but you are obviously not aware of the challenges being faced right now. Businesses are now catching their breath. They're trying with everything that they have. They are trying. I would suggest that if this amnesty at all were to take place, maybe take place in another 6 months, when, let's judge the economy, right? We have supply chain issues. We are seeing the cost of goods are increasing. There are a lot of international factors. There are a lot of different things that's going on right now. So yes, we may be opening up, but we are still at a stage where these businesses are struggling. They are trying. And the amnesty doesn't say, well, here's what. You see, if you didn't pay for the last 2 years that we were in COVID, just scrap the whole thing. These businesses still need to come and bring their actual payments, that part of it. They still need to come and bring that to be able to benefit from the waiver of penalties and interest. Madam President, I am suggesting that I mean, yes, that's great, but it's not good enough right now. If a government was truly on the ground, if they were truly aware of the challenges of the, and I'm going to quote the acting Prime Minister from what I heard on television as well, the little people, if they were truly aware of the challenges, they would understand that even to bring their payments up to date would be a mammoth task at this very point in time. So I have to agree with Senator Deonarine with her suggestion of incremental payments. So either we defer the waiver on the whole, the amnesty, and we say, look, we're going to bring it at the beginning of next year, get your house together, whatnot and whatnot, or we sit and we treat with this on an individual basis, and we offer some of these businesses who we establish are not just, they're not just delinquent for delinquent's sake, they're genuine. We sit with them and we offer them some sort of payment plan. So maybe instead of them coming and bringing their payments up to date, they can at least bring their file up to date. They can come, they can say, look, this is what my file looks like, this is what I should pay, but as at right now, look what my books look like. This is what my books look like. Can I have some time? Because then we will find that instead of the 10%, maybe it would be 50, 60%. So you're looking at, okay, well, instead of $30 million right away, we may get $10 million at the end of the period, but it will be $10 million every single month for the next 5 years or whatnot, and there would be an overall increase. So I would like those on the other side to really genuinely consider the challenges of that nano enterprise and say, let us waiver that, even that payment, but I don't want to use the word waiver, sorry, my apologies, but bring the file and let us work something out. We need more of a relationship approach than this punitive way of, well, we're just going to raise the fine. And so I'm going to get to that. I want to get to that now, actually. Section 33(1), where we're now saying, okay, we want to raise the fine from $2,000 to $50,000. Madam President, in Trinidad and Tobago, the hangman is still a thing. And as at yesterday, we were at 260 murders. So it stands to reason that we can raise it from $2,000 to $50,000 to $50 million. If criminals in this country do not believe that we have the political will to enforce the law or to convict, then raising the fines will do very little. And the minister used the word, it will be a strong deterrent. There is no stronger deterrent than the hangman. And it's not deterring anybody from murdering people at a rate. So what would $50,000 do if there is no confidence that the government has the will to prosecute, to enforce the law, to convict? So I'll leave that there. Clause 6, Section 64(3). The minister is asking for more time. For the purpose of the viewing audience, I'm going to read it. Section 64(3) is amended by deleting the words within 12 months.
Senator Walker,
Sure.
I've taken the view that there's no need to read the entire clause.
Not a problem. Not a problem, Madam President. So I'm speaking on Section 64(3), where the minister wants to move from 3 months to 3 years. Madam President, we have cases before the courts for the last 22 years, and they have to start over, and we have nothing coming out of it, and all that's doing is costing the taxpayers billions of dollars in legal fees. If we cannot convict in 22 years, then how are we going to convict in 3 years. How did the minister decide, well, 3 months is not good enough, we want 3 years? How did they come up with that? Madam President, if we were really serious about closing this gap, then we'd be asking for less time. We wouldn't be asking for more time. We would put the resources in the hands of those who need it, and we will say, go and get our money. Go get it. Aggressively pursue our accounts receivables. Madam President, that carries me now to a statement that was said with regards to the the genius clause that they've included that makes this waiver, this amnesty, different to the 2012 amnesty, whereby they are encouraging people to register. The acting Prime Minister, in the other place, as I said, I was viewing his contribution on television, and he raised the issue that NIB had concerns that this particular initiative would raise, it opens up opportunity for fraud. Even today, when the Honourable Minister in the Ministry of Finance read the bill and made his contribution, he said that the NIB would need to be vigilant in dealing with any unscrupulous and fraudulent activity during the registration process. Madam President, what I heard from this, what I took from this, we are creating yet another scenario where the NIB will have to work on finding fraud. They will have to be all eyes on, all eyes on, hands on deck sort of approach. If it is that we are barely able to collect what's outstanding now, the 2017 report showed that some 16% of persons are not registered, which is why they've included this clause. So some 4,000 businesses are delinquent in just registering. We've not been able, and that figure came from a 2017 report, 2018, 2019, 2020, 2021, 2022, so that's 5 years. In 5 years, we've not been able to use the tools available, and there are tools available. Senator Vieira spoke about one of the major tools available with this particular fund is the fact that people can be personally targeted, their land, their assets, etc. They don't escape that business, what's that word? Like a bubble. That's not the word. Senator Vieira, help me. Corporate veil. And so he knows what I'm speaking about because he spoke about it and he questioned why were we not using that. That was one of the greatest tools that we had. So if in the last 5 years we've not been able to get these 4,000 businesses to even register, how do we propose to be vigilant in a six-month period? We had 5 years to have these 4,000 businesses come one at a time, deal with them, make sure, investigate, do everything. Now we're asking for the NIB to monitor them strictly, vigorously, vigilantly, where we're expecting them to all come at once in a 6-month period. I just don't see it, Madam President, as making any sense. Madam President, I want to make sure that I do not repeat, because I know that a lot was raised before I came. I do support the call for a special joint select committee. I do support the call for the publications of the list of persons who benefit. And of course, I spoke about it. Is the government going to benefit? How much is the government our number one delinquent payer? And yes, will this benefit the hands of a few rather than the all? If someone is getting a benefit from the state, and I understand that people have rights to privacy, but once someone breaks the law, once someone is going to benefit after breaking the law, I think that right to privacy can be waived. Just like the penalties and the interest are going to be waived, I think their right to privacy can be waived. The government, the citizens of Trinidad and Tobago have a right to know who are being delinquent, because that is taking away money from us. That's what it is, and we need to know it. So I do support that call that the list must be made public. Madam President, I believe that is it for me. Everything else will be repetition, and I would hate to do that. Thank you very much, Madam President.
Minister of Tourism, Culture and the Arts.
Thank you very much, Madam President. Thank you. I certainly wouldn't be long, Madam President, but I can tell you the honourable member must now recognize that it's much easier to sit before a microphone on Douglas politics than to come to this honourable Senate, understand legislation, and understand and be able to put forward logical argument. Madam President, I want to thank the Acting Prime Minister and the Minister of Finance for coming to this chamber and all my colleagues on this bench and pouring cold water on all of the arguments of the opposition. Senator Mark promised, Madam President, Senator Mark promised to bring the heat, but that heat was incapable of melting the frigidity of illogical argument here today, Madam President. And Madam President, I'm very surprised about Senator Mark and Senator Lyder, especially because Senator Lyder is an employer himself. Senator Mark puts himself out as a man of the people. He represents the man of the ground. All the man on the ground, he is a man of the people. His arguments today lacked compassion, lacked the love, lacked the care for the people of Trinidad and Tobago, including the employers and the employees. Madam President, let me touch on Senator Walker. Senator Walker is new to these precincts, but I would tell Senator Walker, through you, Madam President, that the Honourable Senator cannot speak for the independents. In fact, sometimes I don't think the Honourable Senator could even represent the views of her own bench. Madam President, I would touch on Clause 3. The Honourable Senator made heavy weather about Clause 3 as though we're hiding something. Madam President, Clause 3 is not unknown to our jurisprudence. In the Value Added Tax Act, Madam President, the Minister with responsibility for finance has the ability to allow for the waiver of penalties and interest. Also in the Corporation Tax Act, the Minister with responsibility for finance has the ability to waive penalties and interest. And Madam President, we have done that in the past. And we have done that in the past with the support of the opposition. So I am not sure what is their objection here today. The Honourable Senator quoted the Hansard and quoted the Honourable Prime Minister, as he then was leader of the opposition, about the objection to waivers and amnesty, etc. But Madam President, in 2011, when the then Minister of Finance under the People's Partnership government came to the House through the finance bill to give a waiver of penalties and interest under the National Insurance Act, there was no underlying policy. The minister simply said, there are a number of individuals, and I'm quoting from the Hansard here, page 471, Wednesday, February 8, 2012. There are a number of individuals who have stopped paying the national insurance contribution. The information we have is that as of June 30th, 2011, some 2,000 employees had not paid contributions owed over the last 4 years. End of story. No policy underpinning, simply we come, we give people a blight. And that, Madam President, I would respectfully submit, is rewarding wrongdoing. That is totally dissimilar to what we are doing here today, because our policy, underpinning our policy, is that both employers and employees had gone through incredible hardship over the last 2 years through the pandemic. And I'm listening to members opposite, and it seems as though that totally escapes everyone. Madam President, we all are beneficiaries inside of here. We have been paid our salaries throughout the pandemic. We have made our contributions. Contributions have been made on our behalf. But we have to understand that not everyone was in a fortunate situation like we were. Persons were furloughed. Industries, the hospitality industry, bars, restaurants, the entertainment industry, the clerk in the store selling clothing, selling shoes, they were all closed for a number of months. And what was supposed to happen? I am a business owner. Not even I knew what was supposed to happen. You go by the NIB to make a payment, the NIB is closed. They say, okay, put it in a box there. Do you put check or do you put cash? You simply did not know how to make your payments or what quantum to make your payments. This is a timely measure and it is a compassionate measure. And I pay tribute to the Minister of Finance for bringing this measure to bring relief to the people of Trinidad and Tobago. Madam President, there's constant speculation about government owing arrears. And it's unfortunate. You come into this house, you cannot rely upon conjecture and just speculation. Where is that written about the government owing arrears? You cannot just make those statements, and I refute it unless you prove it. Madam President, the honorable member opposite and honorable members on the opposition bench keep talking about the deficit, the gap between contribution income and expenditure. And everybody on the opposition side is very, very much concerned about this gap. But where was the concern in the gap in 2014 when the Apsara property was bought for $37 million when it was valued at $16 million? Where was the concern then? Nobody had concern about the value of the fund and the ability of the fund to earn interest income to support the gap. And to Senator Lyder. Senator Lyder, the labor, through you, Madam President, the labor force relates to able-bodied persons under the age of 60 who are able to work. Where the labor force has contracted, as is indicated in National Insurance Board annual reports time and time again, it is due to an aging population. Thank me later. Madam President, the Honorable Senator Walker indicated that we are moving to increase the time to bring action to convict. The reason why we are moving the time is to bring action. It is an even bigger stick to errant employers to ensure that they make their payments. That is the purpose for it. It is not you giving persons just 3 years to make a conviction. No. We are increasing the amount of time where the infraction, where the misfeasance has come to the attention of the director. We're increasing the amount of time for that director, for the National Insurance Board, to bring action against errant employers. And Madam President, this thing about this call for, we need to know who are these persons. Madam President, the records of the National Insurance Board and the record of the contributors is private. Why you want to be in the business of the people who contribute to the National Insurance Fund? It is private, and Madam President, the minute you speak about that or the minute you attempt to accede to that request, the next thing you will hear from the opposition is that they're going into the private affairs and into the private business of citizens. It is confidential and private. Well, Madam President, I wish to state that something is being missed, and I just want to touch on it before I take my seat. During the course of the pandemic, a number of entrepreneurs, employers, small, medium enterprises, they were unable to earn, they were unable to remit their contributions. A number of them. And credibly, some of them continued in a compassionate measure to pay some of their workers.
Minister, I just have to interrupt you for a procedural motion. Yes. Leader of Government Business.
Madam President, I beg to move that this House do now continue to sit until the conclusion of the matter at hand.
Senators, the question is that the Senate continue to sit until the completion of the business at hand, inclusive of the matters on the adjournment. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate will continue to sit until the completion of the business at hand, including the matters on the adjournment. Continue, Minister.
Thank you very much. We have to put ourselves in the shoes of those persons. Some simply were not able to make their contributions. We tend to stress on the wrongdoers. Yes, there are wrongdoers, Madam President. If you understand, as I do in the business world, and I'm sure Senator Lyder understands as well, both employers and employees tend to be errant. Some employers, they simply do not remit the contributions on behalf of their employees. And then too, Madam President, some employees in the construction sector, some employees as clerks in stores, etc., they simply do not see the benefit of remitting an amount of money that could be properly spent by them to the National Insurance Board in the form of a contribution. And that is the reality. Employers cheat, but employees as well cheat the system. Until, of course, Madam President, when some of those very employees are confronted with a pregnancy or they confront their own mortality and they realize that, listen here, I need to make my 750 contributions so that I can have a little pension so that I can take care of myself, take care of my grandchildren, etc., when I reach of age. And that is the fraud that the Minister of Finance is seeking to prevent. Because one of the dangers within that period is for people to come and hit us at a backdate backdated contributions to try and cheat and game the system. But, Madam President, I want us to please pay attention and to please pay mind and to engage in a balancing exercise that, yes, we need the national insurance system to work in the long term. We know and we understand it is our social safety net. We need it to work. But on the other hand, Madam President, we also need the economy to work, and we also need the micro, small, and medium enterprises, because they are the lifeblood of our economy. So, Madam President, I wish to commend this amendment bill to the House. I wish to thank the Honourable Minister of Finance. I wish to thank all the members on our side who have spoken in support of it, and the independent members. I wish to thank them all. I commend this. I am grateful for this, and I am sure the people of Trinidad and Tobago, the employers of Trinidad and Tobago, are also grateful for this. I thank you, Madam President.
Minister in the Ministry of Finance. Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I sat here today, and I have not been a participant in this August chamber for very long, but I have to marvel at Senator Mark's attempt to bend light, his ability to try to warp reality into a form that suits his own purposes, Madam President. Senator Mark came here today, and he said that this amnesty is, in one point, he said, a violation of the NIB Act. Yet in 2012, when they passed a similar amnesty in a government that he was a part of, he didn't think so. He didn't think it was a violation of any law back then. Back then, the Minister of Finance also unilaterally decided to extend this amnesty without any support, any legislative support from this August House or any other. Yet Senator Mark also had no problem with that back then. But today, we have brought this bill to the Parliament, have done the right thing, and are passing a bill that I believe is in the best interest of business people in Trinidad and Tobago, especially small, medium, micro business people who are looking for a break. Senator Mark, who has called himself a champion of the people, one who looks out for the small man, on this occasion is attacking a bill that is designed to protect those persons. It's difficult to understand or believe. He came with a list of arbitrary numbers at one point, saying that if one group owed $100,000, they should get this length of amnesty. If another $200,000, 6 months amnesty. Where do those numbers come from? Why would he make the system so complicated? We are saying on this side that if your house is not in order and you owe contributions, we understand that we just came out of one of the sharpest economic downturns in the last 100 years. We are giving you an opportunity to come to us and say, look, we need assistance. You don't have to pay any penalties. We will help you. Also, if you have been non-compliant in the past, here's your chance to do the right thing by your employees. And if you don't, it's going to be followed with a sharp increase in penalties. As I said earlier, winter is coming. For those who are intentionally and willfully non-compliant and taking advantage of their employees in this country, this government will no longer tolerate that. We have the means now of identifying these persons. The NIB is well equipped in terms of doing its due diligence and policing. We are going to be coming after those delinquent people. Madam Speaker, Madam President, there seems to be some confusion in terms of what is being done to improve the longevity of the National Insurance Fund. This is but one of the measures that we're implementing to ensure that the National Insurance Fund is around for future generations. So let me say some of the others. One, we're trying to get more persons within the system. We have proposed that daily rated workers will also be included within the NIS. Also, the self-employed at some point will eventually be brought under the NIS umbrella. We've also, the NIS fund has a portion which is 20% in US dollars. This is used for international investment because the possible returns on investing internationally are higher than domestic investments. It's 20%. We propose to move that up to 30%, Madam President. In the last year, the NIS, in terms of its return on investment, gave a record 14%, Madam President. A record 14% return on investment. At the same time, the HSF offered a 13% return. So that gives you a fair idea of exactly how well the NIF fund performed in terms of its investment strategy. So that's another one. As we've been saying and meeting with various stakeholders involved with the NIS system, that the NIS fund is like a water tank. We have funds coming in on one end, which are contributions. They go into an overall fund, which is then invested, and the returns on those investments, along with the contributions, are used to pay benefits. But therefore, another strategy that we've been using, of course, is one where we propose to increase the retirement age. Now, why would we do that? Madam President, we have an aging population. It is not a domestic or local phenomenon. We see it throughout the entire world. All of these various Social Security funds are designed in a similar manner and need to be adjusted. What is happening is that in past generations, my parents' generation and before, parents would have 6, 7, 8 children in some cases. That is not happening today. We have a shrinking workforce because people are having less children. Not what Senator Lyder proposed earlier about falling out of the workforce and people not working or whatever he came up with. The fact is, and the studies have shown, that we have an aging population, people having less children, so our workforce is shrinking. But at the same time, people are living longer, healthier lives. So they, of course, are receiving more and more benefits from the NIB fund. That is the major problem in terms of what is attacking the longevity of the National Insurance Fund. That is what we are seeking to address for the most part. Yes. So, I wanted to speak more on some of the opinions of Senator Mark and Senator Lyder, but I'm not sure I would have the time to go into that now. I just wanted to inform Senator Lyder and Senator Mark that what exactly the aging population issue is, so that they can actually understand what is going on. Senator Walker spoke earlier, and she seemed to be justifying the need for an extension in terms of this amnesty, saying that it should be pushed back 6 months. That's exactly the reason why the Minister of Finance reserves the right to have an extension on this amnesty. Because we cannot for certain know exactly how well it will work or function. So we implement it, we see how it works, we meet with stakeholders, and then a decision will be made at the appropriate time. Let me also mention, Senator Vieira spoke earlier. He had asked a question about how many persons had been prosecuted. That information is not readily available, but it's something that I will get for you and send to you in writing at a later date. Now, we expect that from this amnesty, within the first year, an approximate return of $161 million. And over a period of 10 years, we expect to see an increase in contributions of $792 million. Now, that is just 10% of the possible 4,000 delinquent employers that we have in Trinidad and Tobago. So that's a pretty conservative estimate. And that's the point we're trying to make, that this is just one leg in our entire policy in terms of improving the functions of the NIS fund and securing the longevity of the fund for future generations. But let me go into more detail. We anticipated that those opposite would be crying foul as it relates to the use of subsidiary legislation in the bill, namely the power for the Minister of Finance to make orders, as they already raised in the other place, in relation to this bill. Permit me to briefly address that matter. Madam President, the use of subsidiary legislation in the laws of Trinidad and Tobago is not new. It has existed since time immemorial and was directly inherited under the Westminster system. To quote from the Parliament Secretariat, the making of statute law is a function of Parliament and not the executive government or cabinet. However, Parliament frequently delegates to the executive government a limited power of legislation, namely the power to make regulations. This is often referred to as delegated or subsidiary legislation and done by means of a provision in an act empowering the executive government, minister responsible to make laws in the form of regulations, bylaws, orders, and rules for matters prescribed in the act or which are necessary to give effect to the act. All subsidiary legislation has to be tabled in both houses and must be published in the Trinidad and Tobago Gazette when laid, passed, or approved, as the case may be. Now, earlier someone had mentioned that there should be some agreement coming from the board of the NIB before it is presented, before the Minister of Finance presents to this House. The Minister of Finance is an elected official. The board of the NIB is a tripartite committee, and sometimes they don't always agree. The Minister of Finance has the ability and the right to come to this House to pass legislation that he believes is in the best interest of the fund and the people of Trinidad and Tobago. Madam President, the last statement that I made by the Parliament Secretariat finds its force of law in Section 12(1)(a) of the Statutes Act, Act No. 1 of 1962. Madam President, as a result, any argument that alleges that there is absolutely no parliamentary oversight or orders that may be made under the bill is simply not accurate. It is both hypocritical and a perversion of the truth. The orders must be tabled in both houses. Members of Parliament and senators alike will have sight of the order as well as the public. From my research, there have been a number of acts passed between 2010 to 2015. That's during the dark ages when little national development took place, Madam President, which permit the relevant minister to simply make orders without regard to affirmative or negative resolution of Parliament. And one has to wonder whether this issue concerning order-making power under this bill is disingenuous at best. And Madam President, earlier, I believe it was the acting Prime Minister who went through a host of legislation that was passed by special majority of the then government between 2010 and 2015 concerning various aspects of our governance. I will not repeat that. Madam President, to give one last example that is very relative to the issue of amnesties, this Senate may recall that there was an amnesty on various taxes as implemented by Section 16H of the Finance Act 2010, Act number 13 of 2010. If one looks at Section 16H of the 2010 Finance Act, one would see that the amnesty period commenced on September 8, 2010 and ended May 31st, 2011, after which taxes and levies shall be revived and become payable as if the waiver in subsection 1 had not been granted. Madam President, this is also evidenced by a media release from the Ministry of Finance entitled Tax Amnesty for the period 8th September 2010 to 31st May 2011. The excerpt from the Senate response by the Minister of Finance, Mr. Winston Ducaran, to question number 7 on December 14, 2010, which is still available on the ministry's website, as the acting Prime Minister said earlier. What is most curious is that a media advisory entitled Tax Amnesty Deadline Extended to June 30, 2011, issued on May 31, 2011 by the Ministry of Finance, which is still available. The Ministry of Finance wishes to advise that the tax amnesty deadline has been extended to Thursday, 30th June 2011. This decision came from the then Minister of Finance. Madam President, after being appraised by commissioners of the Inland Revenue Division about the amnesty status, a decision was then taken by the Finance Minister to extend the deadline in light of the overwhelming response by the citizens, and also to allow persons who haven't previously met the previous deadline date the opportunity to comply with this due date. There was no debate or dispute of this in 2012, but Senator Mark is coming here today to say that we are violating the law. How can that be? Madam President, we also heard earlier talk from Senator Mark and several other senators that we should bring private information which has been lodged within the NIB to this House and make it public. Now, there was already one, I would say, financial professional who made that mistake, and he paid for it. The legislation, Madam President, is not on the side of those who are willing to violate the privacy of the people of this country. Senator Walker had challenges with an amnesty that would allow struggling businesses to become compliant and get their homes in order, but had no problem in attempting to waive the right of privacy, a constitutional right, simply to overturn this simple amnesty. How can that be? But let me inform all of the exact legislation that supports the right of privacy. It's 32A. Section 32A of the National Insurance Act is applicable here. Any employee of the board, on being designated by the executive director to so do, may furnish or disclose any information pertaining to the national insurance contribution records of any insured person under this Act to any governmental department, agency, or statutory body. 2, every director, officer, or other employee of the board whose services are utilized by the board shall not communicate to any person not legally entitled thereto any information relating to the affairs of any person having any dealing with the board or relating to the affairs of the board, or any information furnished by an employer to the board under any regulation made under this Act. That seems pretty clear, Madam President. Madam President, I've read and reread provisions of the Finance Act 2010. Act number 13 of 2010. I have looked high and low for an amendment through an act of parliament or subsidiary legislation that purports to extend the amnesty period of June 30, 2011. I can find none. Yet this opposition would accuse the government of egregious behavior because we are aware of the trends. We know that people will pay at the last minute. We've seen that over and over. We apply common sense and say, let the Minister of Finance have the power to extend or grant a new amnesty period by order so that the situation can be monitored and the public can have certainty. We are granting a benefit to individuals, and as such, there is no question of deprivation of any rights, and the order must be laid in both Houses of Parliament and published in the Gazette for all to see. That is exactly what we are doing now. This is the act of a caring and supportive government. We are giving those who have fallen behind an opportunity to catch up, and those who have been flouting the law the opportunity to do the right thing. Madam President, I am fortified in my view, given the events of 2011, that the mechanism of the order is the right thing to do, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the National Insurance Act, Chapter 3201, to provide for the waiver of penalties and interest, to increase the penalty for the provision of false information, to increase the statutory limitation for the commencement of summary proceedings and other related matters, be now read a second time. Those in favour say aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the National Insurance Act, Chapter 3201, to provide for the waiver of penalties and interest, to increase the penalty for the provision of false information, to increase the statutory limitation for the commencement of summary proceedings and other related matters.
Minister in the Ministry of Finance.
Madam President, in accordance with Standing Order 66-1, I beg to move that the National Insurance Amendment Bill 2022 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the National Insurance Amendment Bill 2022 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause. Those in favour say aye. Those against say no. No. I think the ayes have it. The Senate shall now go into Committee of the Whole to consider the bill clause by clause. Minister, you ready? Minister. Honourable members, may I ask if everyone has the list of amendments as circulated on behalf of Senator Mark? Yes? It's all there on the rotunda. Honourable Senators, I remind you that there are 6 clauses to the bill. Yeah, go ahead.
Clauses 1 and 2.
The question is that clauses 1 and 2 stand part of the bill. The question is that clauses 1 and 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 and 2 now stand part of the bill.
Clause 3.
The question is that Clause 3 stand part of the bill. Senator Mark?
Yes. Madam Chair, we are absolutely clear in our position that the executive arm of the state needs supervision and oversight. There's huge overreach, and we need accountability and transparency in action being taken by the executive. I heard earlier on the minister making the point that some order will be brought to the parliament. I don't know where he got his information from, but all I can tell you, Madam President, we believe that if the minister is going to extend this period of time, that ought to be subject to a sunset clause. We are proposing that it be brought to Parliament and let the minister justify why he's seeking to have this period extended, even though it is in the legislation. He must come before the Parliament and explain and justify his rationale for extending this particular arrangement, which is the people's monies, and we are the representatives of the people, and therefore we need to have some degree of oversight. So that is our position, Madam President.
May I be permitted to speak, Madam President?
Yes.
This provision finds its place in the Customs Act, the Income Tax Act, the Corporation Tax Act, the Value Added Tax Act. It's standard. It's a bit of a legal nonsense to subject an order to affirmative resolution. You just might as well come and change the law. It doesn't make any sense. The purpose of a ministerial order is for administrative efficiency. And as I said, for 50 years, our tax laws and our money laws have had these kind of provisions in it. So I'm sorry. I can't agree with Senator Mark. When Senator Mark's government was in power, they did this. They applied similar things. They brought laws with the exact same provision in it. So it can't be that because the PNM is in government, it's bad, and when the UNC was in government, it was good. We do not agree on this side.
I disagree fundamentally with the minister and acting prime minister for so many weeks, I should say. I just want to indicate, Madam Chair, that what the minister made reference to as it relates to legislation, none of those pieces has any similarity with what we are dealing with. We are dealing with labor, we are dealing with business, and we are dealing with government. And there has been absolutely no consultation with the NIB and with labor. So we reject that completely.
No, Senator Mark, I need to stop you there. We are treating with your proposed amendment, and your proposed amendment is to replace the word order with affirmative resolution of Parliament. So you're going beyond the scope of your proposed amendment. Senator Vieira.
Thank you, Chair. The Honourable Minister of Finance, when he, Acting Prime Minister, in his contribution, I think cleared up some of the concerns that people may have had on the wording of the amendment. The amendment gives the impression that the minister could waive penalties and interest on a personam basis. But when you read 39B, what 39B is really talking about, that where an employer fails to pay the amount of contributions payable, penalties are fixed. So for the record, what the amendment is seeking to do is to say that the minister could say, you see all of these 25%, 100%, they can be waived. It's not personam, but in rem.
So, Honourable Senators, the question is that Clause 3 be amended as circulated. Those in favour say aye. Aye. Those against say no.
No. Division.
Mr. Armour?
No.
Ms. Gopi Schoon, Mr. Sinanan, Mr. Hussain.
No.
Ms. West,
No.
Mr. Mitchell,
No.
Ms. Cox,
No.
Mr. Bacchus,
No.
Dr. Ibrahim, Mrs. Sagramsingh-Sooklal,
No.
Dr. Brown,
No.
Mrs. Lazama Lee Singh,
No.
Mr. Hislop,
No.
Miss Bethelmy,
No.
Mr. Boris,
No.
Mr. Mark,
Yes.
Ms. John,
Yes.
Mr. Naked,
Yes.
Mr. Lyder,
Yes.
Mr. Roberts,
Yes.
Ms. Walker,
Yes.
Mr. Richards,
No.
Mr. Vieira,
No.
Dr. Diyal Singh,
No.
Ms. Deonarine,
No.
Ms. Seepersad,
No.
Mr. Timal,
No.
Mrs. Thompson-Nai,
No.
Madam President, the result of the division is as follows. 22 senators voted against, 6 senators voted for, and there were no abstentions.
Honourable Senators, the result of the division is as follows. 22 senators voted against the proposed amendment, 6 senators voted in favour, and no one abstained. The amendment was therefore not supported. Honourable Senators, the question is that Clause 3 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 3 now stands part of the bill.
Clause 4.
The question is that Clause 4 stand part of the bill. Senator Mark.
Yes, Madam Chair. This particular amendment where we are seeking to insert subject to affirmative resolution of Parliament is even more egregious in the sense that the minister is being given the power to extend the time for the payment of contributions, which, Madam President, if you check the legislation, the deadline is the 31st of December 2022. This amendment that we have before us is actually going beyond the pale of that date, which we find very repugnant and unacceptable, indefensible, inexcusable. Therefore, the minister must be brought to account, must be brought to book, and we are saying that the Parliament must have supervision over any decision on the part of the minister to extend the payment contribution time period. And that must be approved by the Parliament. So that is our position, Madam President. Hence the reason we are calling for affirmative resolution so there can be accountability and transparency.
Minister.
Thank you very much, Madam President. I don't think I need to repeat the reality with respect to the first section, but is it that Senator Mark has abandoned B?
Well, that's what, Senator Mark, you didn't treat with B.
You remember, is this, okay. I thought, Madam Chair, that might have been a subsection.
Clause 4.
Sure.
Big speaker like
All right.
Yeah.
Madam Chair, to be guided, we are saying, Madam Chair, that we need some clarification and accountability and transparency. If the government is saying in accordance with the law that we cannot get the names of these people owing to privacy purposes and reasons, then there is a duty that the government has to at least inform the Parliament via a report on the number of companies involved in this matter. We can always amend, if you want to leave with the names of the companies, if possible, the categories, whether it's large, medium, or small, the value of the penalties, and the total value that the NIB would be actually not receiving, given the fact that these penalties and interest would be waived by the minister. So we believe that there's need for us to have some degree of accountability through the submission of a report. Madam Chair.
Madam President.
No, just one sec, Senator Richards.
Madam Chair, thank you. Could the Honourable Minister just remind us of the section that refers to the confidentiality clause, please, in the NIB Act?
In the NIB Act, I'm afraid I don't have it at hand.
No, the Minister in the Ministry of Finance referred to it.
Section 32A of the National Insurance Act.
Minister.
It carries a penalty of imprisonment for 1 year and a fine of $10,000.
Thank you very much, Madam President. But quite apart from that, this amendment would be unconstitutional unless passed with a special majority because it offends the right to privacy. So that's the first and most important element of all of this. The other point is that the National Insurance Board reports to the Parliament. It submits an annual report every year, and also it submits its financial statements. And in these financial statements, it gives a full disclosure of all of the contributions it has received and the benefits paid out. And certainly in the case of this amnesty, that would, all of that information that Senator Mark is asking for, certainly not the names, that's a complete breach of privacy, but certainly the details of the collections from this amnesty would be contained in the NIB annual report.
Senator Vieira.
Thank you, Chair. All right, 32A, 2. Every director, officer, or other employee of the board whose services are utilized by the board shall not communicate to any person not legally entitled thereto, any information relating to the affairs of any person having any dealing with the board or relating to the affairs of the board or any information furnished by an employer. That's fine, standard. But I agree, we are talking here about waiver of penalties and interest by persons who have broken the law in a matter, I think, it's a matter of public interest and deserving of scrutiny. This is not an intrusion into people's private business. It's not about if you're giving people a pardon, which in effect this amnesty is doing, you're being pardoned, that should be subject to scrutiny. I think the administration of justice requires transparency, and there can be no legitimate expectation, there can be no reasonable expectation that money due and payable to the board can be varied in private, that persons who have committed offenses, persons who have defaulted on their compulsory contributions, I don't see how they can expect that they should be kept that in secrecy. I don't really see 32A2 as cited as preventing us from saying, no, there should be some disclosure and transparency of the persons who have had these waivers, these persons who have been pardoned. So I agree with Senator Mark on this one.
But Senator Vieira, through you, Madam President, that will also apply to tax amnesties, because we give tax amnesties all the time. There's never been any request or any requirement to name the persons who have availed themselves of an amnesty, not having paid income tax, corporation tax, value-added tax for many, many years. And I mean, I'm not a lawyer at all, and I certainly don't have legal knowledge anywhere close to Senator Vieira, but I am of the firm view that we cannot name persons in this way. You cannot reveal that sort of information. I am of the firm view that that would be struck down as unconstitutional. I wish to reiterate that in the annual report of the National Insurance Board, you can get the number of companies, the categories, the value, all that sort of thing. But I am certainly cannot agree respectfully that you could name people. That is an egregious breach of the Constitution. In my view, I'm not a lawyer, but I'm just saying that.
Senator, and I'm not going to get into the minutiae of privacy law, so I respect your view, but I do feel that in this case...
Senator Mark?
Yeah. Madam Chair, Senator Vieira did indicate earlier, it was a very fundamental point he brought to our attention, that the NIB is not a company. We are talking about a fund, and we are tampering with a fund. And you have people who are duty-bound under law to meet their obligation to expand this fund so that people can gain benefits.
But Senator Mark, if
so,
I may...
So I'm just saying, Madam Chair, that I do not support the viewpoint being expressed by the Minister, and I believe that, for instance, there ought to be some system of accountability whenever these things are being done.
All right. Yes, Attorney General.
To say that I support the submissions of the Minister of Finance. I don't think it is for us at this stage to be seeking to put people's names and private information unless it goes to a special majority. I think that would be unconstitutional. We can't go there.
So, Honourable Senators, the question is that Clause 4 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no.
Mr. Armour? No. Ms. Gopi Skoon? No. Mr. Sinanan? No. Mr. Hussain? No. Mr. Hussain? No. Ms. West?
No.
Mr. Mitchell?
No.
Ms. Cox? No. Dr. Ibrahim?
No.
Mr. Bacchus? No. Mrs. Sagramsingh-Sooklal?
No.
Mrs. Lazama Leasing?
No.
Mr. Hislop?
No.
Ms. Betelmi?
No.
Mr. Boris?
No.
Dr. Brown?
No.
Mr. Mark?
Yes.
Ms. John?
Yes.
Mr. Nakid?
Yes.
Mr. Lyder?
Yes.
Mr. Roberts?
Yes.
Ms. Walker?
Yes.
Mr. Richards?
Abstain.
Mr. Vieira?
Yes.
Dr. Deonarine?
Yes.
Ms. Deonarine?
No.
Mr. Timal?
No.
Mrs. Thompson-Nai?
No.
Mr. Richard? Abstain. That's 18721.
No.
case 18, right?
I'm the last person to vote.
18.
Are you calling Senator Seepersad?
And you didn't call Senator Seepersad?
She's here?
Yes.
But she came.
You want to do it over?
I'll do it over.
Yeah. We have to do it over because we're at odds.
We're at odds.
Honorable Senators, we are about to redo the division.
Mr. Armour? No. Ms. Gopi Skoon?
No.
Mr. Sinanan? No. Mr. Hussain?
No.
Ms. West?
No.
Mr. Mitchell? Ms. Cox?
No.
Dr. Ibrahim?
No.
Mr. Bacchus? No. Mrs. Sagramsingh-Sooklal?
No.
Mrs. Lazama Leasing?
No.
Mr. Hislop?
No.
Ms. Betelmi?
No.
Mr. Boris?
No.
Mr. Mark? Yes. Ms. John?
Yes.
Mr. Nakid?
Yes.
Mr. Lyder?
Yes.
Mr. Roberts?
Yes.
Ms. Walker?
Yes.
Dr. Brown?
No.
Mr. Richards?
Abstain.
Mr. Vieira?
Yes.
Dr. Diyal Singh?
Yes.
Ms. Deonarine?
No.
Ms. Seepersad?
No.
Mr. Timal?
No.
Mrs. Thompson?
No.
Yes, she said no. Yeah. Division was as follows. 8 senators voted for, 19 voted against, and there were no abstentions.
Yes.
Sorry, there was one abstention. My apologies. There was one abstention. I have it right in front of you.
Honorable Senators, the result of the division is as follows. 8 members voted in favor of the amendment, 19 members voted against, and 1 member abstained. The amendment has therefore not been accepted. The question is, therefore, that Clause 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
Clauses 5 and 6.
The question is that clauses 5 and 6 stand part of the bill. The question is that clauses 5 and 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 5 and 6 now stand part of the bill. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. Minister in the Ministry of Finance.
Madam President, I wish to report that the National Insurance Amendment Bill 2022 was considered in Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that the Senate agree with the committee's report on the National Insurance Amendment Bill 2022. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Minister in the Ministry of Finance.
Madam President, I beg to...
Senator Mark? Yes. Minister in the Ministry of Finance.
Madam President, I beg to move that a bill entitled An Act to Amend the National Insurance Act, Chapter 3201, to provide for the waiver of penalties and interest, to increase the penalty for the provision of false information, to increase the statutory limitation for the commencement of summary proceedings, and other related matters, be now read a third time and passed.
The question is that a bill entitled An Act to Amend the National Insurance Act, Chapter 3201, to provide for the waiver of penalties and interest, to increase the penalty for the provision of false information, to increase the statutory limitation for the commencement of summary proceedings and other related matters, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Dr. Brown.
Yes.
Mr. Armour.
Yes.
Ms. Gopi Skoon.
Yes.
Mr. Sinanan.
Yes.
Mr. Hussain.
Yes.
Ms. West.
Yes.
Mr. Mitchell.
Yes.
Ms. Cox. Yes. Dr. Ibrahim.
Aye.
Mr. Bacchus.
Yes.
Mrs. Sagramsingh-Sooklal.
Yes.
Mrs. Lazama Leasing. Yes. Mr. Hislop.
Yes.
Ms. Betelmi.
Yes.
Mr. Boris.
Yes.
Mr. Mark.
Abstain.
Ms. John.
Abstain.
Mr. Nakid.
Abstain.
Mr. Lyder.
Abstain.
Mr. Robert.
Abstain.
Ms. Walker.
Abstain.
Mr. Richards.
Abstain.
Mr. Vieira.
No.
Dr. Deonarine.
No.
Ms. Deonarine.
Yes.
Ms. Seepersad.
Yes.
Mr. Timal.
Yes.
Mrs. Thompson Aye.
Yes.
Madam President, the result of the division is as follows. 19 senators voted for, 2 senators voted against, and there were no abstentions. Sorry, there were 7 abstentions.
Honourable Senators, the result of the division is as follows. 19 senators voted yes, 2 senators voted no, and 7 senators abstained. The bill has therefore been passed.
An act to amend the National Insurance Act, Chapter 3201, to provide for the waiver of penalties and interest, to increase the penalty for the provision of false information, to increase the statutory limitation for the commencement of summary proceedings, and other related matters.
Leader of Government Business.
Madam President, I beg to move that this Senate do now adjourn to Monday, July 4th, 2022 at 10 a.m. when the government intends to debate the Bail Amendment Extension of Duration Bill 2022.
Honourable Senators, Senator Mark. Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised. Senator Nakid.
In the name of God, the most gracious, the most merciful. Madam President, I would like to open with a quotation from one of our modern-day philosophers, Jordan Peterson. And he says, if you betray yourself, if you say untrue things, if you act out a lie, you weaken your character. And if you have a weak character, then adversity will mow you down. When adversity appears, as it will, inevitably, you will hide. But there will be no place left to hide. And then you will find yourself doing terrible things. Madam President, I raise this matter not only because of the obvious economic and social implications, the ramifications that will be brought to bear upon the citizens of this country by the hike in flour prices, which I will go into briefly, but because of the flippancy, indeed the sheer mendacity by which the ministers of this PNM government addresses the people of this country on the most salient of matters. Madam President, the Minister of Trade and Industry stated publicly that a hike in flour prices is temporary and linked to future market conditions. The obvious and clear inference being that market conditions in the future would ameliorate, whether through the war in Ukraine coming to an end, wheat production restored to previous levels, whether supply chains would face no further disruptions, transportation costs would go back to previous levels, etc. We, the people of Trinidad and Tobago, cannot, however, benefit from that increased price of oil that we have seen because some economic incompetent government official closed down Petrotrin, and subsidies under this pretext were removed. But if that is indeed the economic case that the Minister of Trade and Industry will soon proffer for the 33% hike in flour prices that has literally brought the poor and working class people of this country to their knees, having to choose which meal to skip because flour is indeed a necessity and is used for everything, especially in a poor man's diet. Not only in bread and pastries, but pasta and a meal that is common among the poor, maybe none of us know it here, called flour pap. So, Madam President, the Minister of Trade and Industry must reveal to the Senate from whence did she obtain this highly privileged information that no other economist globally seems to have. It was not in The Economist, I checked. It was not in the Washington Post, I checked. The New York Times, I double-checked. The Wall Street Journal, I checked that too. Maybe it was from that obscure Oxford study that pronounced TNT as being #1 in the world in COVID response, whereby we have now recorded over 4,000 deaths, families' lives and livelihoods destroyed.
Senator Naked, can I just draw your attention to the matter that is before us and ask you to try and stick within that framework, please?
I am, Madam President. I'm just drawing a link between the flippancy of that statement.
No need to justify what you were doing, but I'll just ask you to bear in mind what was approved for you to raise.
And laid bare an horrendous healthcare system that this government claims to have funded over $40 billion in the last 7 years. Madam President, this statement by the Minister of Trade and Industry is emblematic of this government's approach to dealing with the people. So they know something to be fundamentally untrue or duplicitous, but they say it anyway. Kick the can down the road and avoid scrutiny or consultation. And we saw it here today. So, Commission of Inquiry for Paria, until now nothing. Task Force, $116 million on the Children's Authority, until now nothing. 852 million gone. And the Minister of Standing Orders raises under parliamentary privilege live sport at every turn, which we know is just to mislead the public.
Senator Naked, of all the persons here, I am listening to you very intently. I don't know that there's a Minister of Standing Orders. And no, hold on. And I also know what has been approved and what is before the chamber right now. So I will ask you again to confine your contribution to the issue that you were supposed to be raising, okay?
Mrs. Madam, and as I said before, as I continue, as I said before, that statement is so full of mendacity that is almost impossible when one does the research on the economics of that statement. There's no way that that statement can therefore be justified. So we have to ask ourselves, why would the Minister of Trade and Industry make that statement? Obviously, Madam President, that statement, like other statements that this government tends to make, for example, the Prime Minister returning today, obviously that is something just meant to distract from what is the most salient of issues. What indeed...
Senator Naked, for the benefit of everyone in this chamber, I'm going to read what was approved. Given the public concerns expressed subsequent to the statement made by the Minister of Trade and Industry on the increase in flour prices, the need for the Minister to explain her statements that said increase in flour prices is temporary and linked to future market conditions. Now, Senator Naked, what I'm hearing from you now is not linked to what I have just read out. So I am pleased, this is the third time, I'm going to ask you, please, to finish your presentation on this issue.
Madam President, guided as usual, but I thought I could segue into showing that such a statement, again, I repeat, unfortunately, was so duplicitous by its nature, by its utterance, that is emblematic of a government that never seems to tell the population of Trinidad and Tobago the truth. Clearly, when one states that a hike in flour prices is temporary and linked to future market conditions, when no economist in the world, when no government in the world has indicated that those future market conditions will ameliorate to the benefit of the citizens of the world, and therefore that hike in flour prices is indeed temporary. There's no view, short-term, medium-term, or long-term by any credible economic source, then that statement is indeed full of mendacity. And we call on the Minister of Trade and Industry to apologize to the nation, to apologize to the Senate indeed, and let us know why and where she got that information that states that that hike in flour prices would be temporary on a global level and benefit the citizens of Trinidad and Tobago. I thank you, Madam President.
Minister of Trade and Industry.
Thank you very much, Madam President. And I too would have had some difficulty in listening to the ramblings of Senator Naked. And he started with with a quotation by Jordan Peterson and described him as a modern philosopher. But Jordan Peterson was just described by world scientists in his comments on climate as a word salad on nonsense. And that's how he chose to start, and this is where the debate went, the motion went. Nonsense. It just seems to, this is a very serious matter. The war in Ukraine, the increase in prices globally, the pressures on world economies, the poverty that has been brought upon the world, and to think that you would come here to discuss semantics about the word temporary. And perhaps you just don't understand. And temporary, perhaps you just had a temporary lapse in judgment. And you've wasted the Senate's time as far as I'm concerned. But for your edification, temporary means for a limited time. That's what it means. It can mean for 5 years, like the UNC was in office for a limited time.
Minister, just address me, please.
The UN...
Senator Naked, Senator Lyder, just please. You allowed Senator Naked to make your contribution. Let us hear the response, please.
Yeah, I'm just giving examples of temporary. US, as I said, between 2010 and 2015, the UNC was temporarily the government of Trinidad and Tobago, and now the UNC will remain permanently in opposition. That's the difference between temporary and permanent. You, Senator Naked, you would have mounted a temporary campaign for the presidency of FIFA, but you were forced to withdraw after receiving no support. That's what it is, a limited time, temporary, and I could go on and I could embarrass you, and I will not do that because I have respect for the Parliament. But let me say to the nation, as I have the opportunity, that what is happening with regard to the world food prices and the price of flour is not unique to Trinidad and Tobago. I was on the in the national space speaking to the reasons why, speaking to the whole question of the global food prices. In the case of the UK, a 40-year hike in prices that they've never seen before. In the US, an 8% rise in inflation. It's the highest in 4 decades. In Canada, an inflation rate of 7.7%, highest in 39 years. And this is the situation we're talking about. And I came here, and I came to the population, and I said that flour, we understand as a government, it's the most basic item in the food basket of all households. And we understand the increase that will be felt by families across the world, across the country. And of course, I gave the rationale. And it makes no sense going through supply chain disruptions, the ongoing war, and so on. The point is, the reality is that the price of wheat is not within our control and is symptomatic of the ongoing global food crisis. Okay? And I mean, there are warnings about what the likelihood is in terms of this continuing, but as well, there's been a sound global response, and so that as a country, we have done what we can so far, in that there's no VAT, there's no tax or anything like that on flour. We've supplied foreign exchange to those who need to bring in the inputs to make the final product. We have suspended the CET on basic food items. We've done a lot. But at the same time, I gave a commitment to the nation that from when I spoke a week ago, that in another 2 weeks we will come back to ensure that we can do whatever is possible else to make it a little bit easier on the most vulnerable people in this population on account of the increase in the price of flour in particular, but among the other things that are also rising. And we made our appeal to the retailers, we made our appeal to the consumers, and we gave our commitment. And whilst I would agree with you that there's a sense of uncertainty, there is also the global response, and one would recognize that there is
a commitment by NATO to strengthen deterrence measures. There's a global bolstering of support to end this war. And therefore, one does not hope that the war would last forever. One hopes and prays that it is in fact temporary. And temporary could mean 1 year. It still is temporary, but we are all in this world working towards a position to return us to some sense of normalcy. And we hope and pray that...
Madam President, Standing Order 51-1, E, F, and L.
Yes. Please, Senator Naked, please allow the Minister to finish her contribution.
Yeah. So I really can't see why you would take issue with a word, not in these circumstances, not where the globe is hoping for the best results in favor of the world population. Okay? This kind of situation must not come down to a definition. We're not here to discuss definitions. It seems very petty. Your motion has been very puerile and petty. Okay, right? But I end by giving the national population the assurance that the government will continue to monitor. The government will return to find solutions so that we would ensure that the most vulnerable, their situation is improved. And for all of us in this global world, we are hoping and praying for the best. Yes? Thank you.
Senator Deonarine.
Thank you, Madam President, for the opportunity to raise this matter on the adjournment. The need for the government to present virtual asset legislation to Parliament, having regard to the FATF recommendation number 15, and in light of the government's policy position on the use of cryptocurrency in Trinidad and Tobago. Madam President, on June 14th, 2022, a question was raised on the order paper, question 159 to be specific, to gain some insight on the government's policy position and legislative agenda with respect to cryptocurrencies and Bitcoin mining in Trinidad and Tobago. This question was raised by myself in light of newspaper reports of a US $0.5 billion Bitcoin mining farm proposed by 3 companies, one being the Ansa Macal conglomerate and the Tamana Investment Park. Madam President, it was reported that given these developments, the Ministry of Trade was prompted to look into a policy and legislative framework to understand the possibilities of the cryptocurrency industry in Trinidad and Tobago. Madam President, in response to this question, the government's policy position was placed on the record of this Honourable House as one simply to not support Bitcoin mining at this time. Madam President, on one hand, this policy position can be seen as an anti-innovative one, but on the other hand, there are also the risks associated with cryptocurrencies that must also be considered. Bitcoin mining has large energy or electricity demands with a huge energy footprint. As a matter of fact, the proposed project by Trinimine would have a capacity of 300 megawatts. That is equivalent to powering approximately 60,000 homes in Trinidad and Tobago. There are other risks associated with Bitcoin farming, especially with respect to it being a conduit for a host of illegal activities, including money laundering, extortion, illicit drug trading, terrorist financing, and so on. Madam President, this matter today questions the justification on government's policy position and seek to understand how the government intends to cement its policy position of not supporting Bitcoin mining in legislation, given the anti-money laundering and counter-financing terrorist risks associated with it. Now, the impression that I got from the government was that, to their understanding, there are no uniform international laws that regulate Bitcoin mining. Therefore, regulation is not needed to support its policy position. However, FATF recently updated its guidelines on Recommendation 15 to guide governments on how to regulate the risks associated with Bitcoin mining and the cryptocurrency industry. FATF Recommendation 15 lays out the requirement for virtual asset management. Countries should assess their risks with respect to virtual assets and regulate it. Having legislation also means that if your policy position is that you don't want to encourage Bitcoin mining in your country, then you need to pass legislation to support your policy position, whether it is by means of banning it entirely or having limited use via regulations. This is important, Madam President, because we live in a globalized world. People do business outside of the territory. People could invest outside. Banks may have clients who purchase or invest into virtual assets outside of the country, just like you would purchase something online. The bottom line is this: if you want to have it in the country, you need to manage it and regulate it. If you don't want to have it, then you need to pass legislation restricting it or banning it. Saying that you do not support Bitcoin mining and cryptocurrencies is not sufficient. If there is no legislation saying that this is not allowed in the country, that means I can invest in it. It means that I can set up a Bitcoin mining farm. What is there to stop me from engaging in the cryptocurrency industry in Trinidad and Tobago, given the government's policy position? Just like you regulate accountants, lawyers, NGOs, etc., for anti-money laundering activities, the cryptocurrency industry needs to be regulated. Even though the policy position of the government is to not support it, I am not aware of any legislation that prohibits any potential investor of Bitcoin mining in Trinidad and Tobago or any individual wishing to invest in it. The most I would have seen was a joint statement by the Central Bank of Trinidad and Tobago, the Trinidad and Tobago Security Exchange Commission, and the Financial Intelligence Unit about potential risks of investing in or conducting transactions with cryptocurrencies. This statement was made in 2019. The Central Bank of Trinidad and Tobago is, as a matter of fact, not blocking commercial banks from selling foreign exchange to their consumers, to their customers who purchase cryptocurrencies. Some commercial banks are discouraging it. It is important to understand that regionally and globally, this sector has been emerging. As a result, we cannot bury our heads in the sand and say it doesn't apply to us because we, the government, doesn't support it. What about the people in a country investing in it or mining at home on their computers, or companies that come to Trinidad and Tobago and encourage people to invest in it? We spoke about countries that have not allowed it. If we look at the countries that have banned Bitcoin mining or cryptocurrency, they are countries, with the exception of China and India, they are not major trading partners of Trinidad and Tobago. We are talking about countries like Algeria, Bolivia, Egypt, Indonesia, Iraq, Russia, Turkey, to name a few. But what about countries that have allowed it? Within the Caribbean, there are countries that have supported and passed the necessary legislation. Dominica being the most recent. We have St. Kitts and Nevis, Antigua and Barbuda also on board. Now, I do not understand how the policy was arrived at, policy decision was arrived at. What has to happen, Madam President, is that the country needs to assess the risk in arriving at the policy position.
Senator Deonarine, I just need to interrupt you here because I think you're straying from your motion a little bit, all right, because you're actually now going into the issue of the policy and questioning the policy, whereas the matter here is framed differently. Yeah?
I'm guided, Madam President. So, Madam President, As the country continues to struggle with crime, the potential use by criminal activities is quite apparent. A lot would depend on the government's legislation empowering the banking sector to have the appropriate anti-money laundering systems specifically pertaining to cryptocurrencies. The investor who is involved in illegal activities can easily attempt to wash his money by manipulating the financial and cryptocurrency system. CFATF, that is the Caribbean arm of the Financial Action Task Force, should be advising on virtual assets. Have the CFATF done an assessment that informed the government of its policy position and whether there needs to be legislation or what regulations has to be put in place? Madam President, a proper assessment has to be done to ascertain risks to investors now and in the future. This is something that has generated a lot of public interest and will continue to generate public interest, and some clarity is needed on the legislative direction we are going with to support the government's policy position. I thank you, Madam President.
Minister in the Ministry of Finance.
Thank you, Madam President. As stated previously in response to a question in this Senate, the government is not supporting the introduction of cryptocurrency in Trinidad and Tobago at this time. However, the government, in collaboration with the central bank as the regulator of the financial system, has made significant strides towards the creation of a domestic legislative and regulatory environment consistent and compliant with FATF Recommendation Number 15. For the benefit of honourable senators and the public at large, allow me to explain what FATF Recommendation Number 15 involves and the work currently in progress to bring Trinidad and Tobago in line with this recommendation. FATF Recommendation 15 treats with money laundering, terrorist financing, proliferation financing, or MLTF-PF risks, which arise from the development and use of new products and new business practices, including new delivery mechanisms and the use of new and developing technologies for both new and pre-existing products. This recommendation has existed since 2012 and has been implemented in Trinidad and Tobago's laws since 2014 through Regulation 23 of the Financial Obligations Regulations 2010. The 2018 revision of FATF's recommendation also included the definition of virtual assets. Madam President, it must be stated that virtual assets are not limited to cryptocurrencies, but include any type of digital representation of value, which falls within FATF's purview and recommendations. FATF Recommendation 15 requires that countries ensure that virtual asset service providers are regulated for AML-CFT purposes and are licensed or registered and are subject to effective systems for monitoring and ensuring compliance with the relevant measures throughout the FATF recommendations. Identification and assessment of risks. The first step required by the FATF in mitigating against all MLTF-PF risks, including risks emerging from virtual assets, is to identify and assess these risks. We recognize, therefore, that it is incumbent upon any jurisdiction to undertake an assessment of the virtual asset sector as it exists to ensure the steps taken to impose AML, CFT, CPF obligations on the service providers within this sector or impose restrictions on the use of virtual assets, which are proportionate and sufficiently discouraging to curb illicit activities. In this context, I wish to reiterate that the government is not supporting the introduction of cryptocurrency in Trinidad and Tobago at this time. In tandem with the various changes proposed and implemented by the FATF, the Office of the Attorney General and Ministry of Legal Affairs, through its Inter-Ministerial Committee, National Anti-Money Laundering and Counter-Financing of Terrorism Committee, or NAMLC, and the Trinidad and Tobago AML-CFT supervisory authorities, the Central Bank of Trinidad and Tobago, the FIU of Trinidad and Tobago, and the TTSEC have continued to monitor the evolution of the use and potential use of virtual assets and virtual asset service providers in Trinidad and Tobago. National Risk Assessment, or NRA. This need for further understanding and identification of risks has led to the Government of Trinidad and Tobago's engagement of the World Bank to provide technical assistance with conducting a specific risk assessment into virtual assets and virtual asset service providers. This risk assessment is being undertaken as a standalone module within the broader scope of the NRA, which is currently underway being managed by the NAMLC. It is intended that the risks of this risk assessment will inform the extent to which virtual assets and virtual asset service providers are being misused or are likely to be misused by criminal actors in Trinidad and Tobago. This information should form the basis of any supervisory or regulatory action to be taken. This module is scheduled for commencement in the latter part of 2022. Joint Regulatory Innovation Hub. Further, Madam President, it is to be noted that together with the National Risk Assessment, the Central Bank of Trinidad and Tobago, the TTSEC, and FIUTT in some initial steps taken to understand the status of overall fintech activities, including virtual assets and virtual asset service providers' activities, in Trinidad and Tobago established a Joint Regulatory Innovation Hub on October 2nd, 2020. This hub provides an online portal through which entities wishing to establish fintech businesses in Trinidad and Tobago, including virtual asset service providers, can engage with the three authorities simultaneously to understand the regulatory framework and for the authorities to understand their business models. The hub also provides a mechanism for interested fintechs to submit applications for provisional registration for e-money users. This hub serves as a means for the authorities to gather information on various types of fintech businesses in operation in Trinidad and Tobago and possible risks that they may pose, which will inform policy decisions. As at December 31st, 2021, the authorities engaged with 43 entities on matters ranging from the requirements for virtual cryptocurrency to regulations, guidelines, and application procedures pertaining to payment service providers, EMIs, and regulatory sandbox, and the regulatory sandbox. The Joint Regulatory Sandbox. In addition, Madam President, the authorities have collaborated on the establishment of a Joint Regulatory Sandbox to complement the Regulatory Innovation Hub. The sandbox allows entities to test and evaluate their innovative products and services, as well as business models, in a controlled space prior to the full launch to the public. Phase 1 of the sandbox, Madam President, became operational with the enactment of the e-money user order 2020, which allows for the granting of a provisional license to an e-money issuer where the applicant does not immediately satisfy all the regulatory requirements to enable it to be licensed. Phase 2 of the sandbox is being developed for wider fintechs, but requires legislative amendments in order to be operationalized. Madam President, all fintechs, including virtual asset service providers that intend to provide financial products, services that are regulated activities, must engage with the regulators via the hub. Data collected through both the hub and sandbox will assist the authorities in understanding the risks posed by the fintechs, including virtual asset service providers, which in turn will also be used to inform the regulatory framework in line with the FATF Recommendation 15. Virtual asset service providers. Madam President, in May 2021, the Central Bank issued a draft policy for a comprehensive digital payment system legislative framework for Trinidad and Tobago for stakeholder consultation, and a public webinar was held in June 2021 to present the policy proposals. The draft policy includes a proposed regulatory framework for payment services providers, including fintechs and virtual asset service providers that engage in activities to facilitate payments or transfers. At this time, the Central Bank is receiving technical assistance from the technical arm of the IMF to prepare the proposed digital payment system, legislation and regulations. It is anticipated that the payment policy and draft legislation will be submitted to the Ministry of Finance later this year for review and approval by Cabinet. Central Bank Digital Currencies, or CBDC. Madam President, FATF Recommendation 15 also applied to CBDCs, similar to any other form of fiat currency issued by a central bank. CBDCs may have unique MLTF risks compared with physical fiat depending on their design. Such MLTF risks should be addressed in a forward-looking manner before the launch of any CBDCs. With the emergence of virtual assets such as cryptocurrency, stablecoin, and the like on the financial landscape, the central bank's focus is on the promotion of safe, efficient, and modern, largely digital transactions. Digital currencies can economize on the use of cash, promote financial inclusion, and enhance the payment system by providing cheaper and faster alternatives to purchasing goods and services. In this regard, the CBTT, or Central Bank of Trinidad and Tobago, has been examining the pros and cons of the issuance of a central bank digital currency. Given that, if feasible, it could complement efforts to promote a digital economy by allowing digital transactions with the full backing of the central bank as legal tender to be widely used by businesses and the general population. As a first step, the CBTT has conducted a comprehensive review of central bank digital currencies involving an assessment of the legal, technical, and operational aspects and country studies, including the experiences.
Minister, your time has expired.
Thank you.
Honourable Senators, the question is that this Senate do now adjourn to Monday, July the 4th, 2022 at 10 a.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Monday, July the 4th, 2022 at 10 a.m.